Welcome, everybody. It is an incredible day. This is day 10 of the Kyle Rittenhouse trial. The defense has rested. The prosecution made its case first. And today we are going to see arguably some of the most interesting elements of this case, starting number one with the jury instructions given to the jury by the judge as to the legal basis on which they are to decide. You have to compare the actions of the defendant to some legal standard. If I say to you, was something self-defense, the first question should be, what is self-defense defined as in the law? Jurors I served with on a jury on a self-defense case didn't seem to understand that. But that is what is so and there was much disagreement on Friday about what the instructions should be. They have over the weekend finalized that, and we're going to hear the instructions from the judge today. That's number one. Number two, oh, wait a second. I put some of these elements on the wrong spot. Let me see if I can fix this. Give me a moment here. I have some new judge elements as well, audio stuff. Let's see. Where's my soundboard? Judge. Here we go. Okay. Here we go. I'm going to play these for you in a little bit. So we're going to hear from that. And then we are going to get right into closing statements. I believe the order is going to be closing statement from the prosecution, closing statement then from the defense, and then a rebuttal from the prosecution. The judge is allotting 2.5 hours to each side total. For the defense, it would just be up to 2.5 hours for their closing statement. For the prosecution, that 2.5 hours has to contain the closing statement and the rebuttal. Okay, so that's the plan today. A bunch of different things to go over. Steve Bannon has just surrendered to the FBI. He is being arrested. Steve Bannon has been indicted for contempt because he ignored 2 subpoenas from the Trump Riot Committee. Here's video from 15 minutes ago.
Breaking news into CNN. Steve Bannon, the former President Trump's senior advisor, has now appeared at the FBI field office here in the District of Columbia to turn himself in. This following his indictment on 2 counts of contempt of Congress.
Look at this.
This is just moments ago, and there you see him arriving at the FBI field office.
I really would like to see that smirk wiped off of Bannon's face. And I don't mean somebody hitting him. I mean, it would be great if that stupid smirk was wiped off by actually having some legal consequences to the things he's done.
This indictment. Let's watch these pictures as it happens.
Any comment? Any thoughts, Mr. Bannon? Sir, Mr. Bannon, any comment on this? How are you feeling today, Mr. Bannon?
I like the coup plotter sign in the background.
Mr. Bannon, what are your plans now ahead of this?
Thank you. Everybody go back. All right.
Mr. Bannon, to the Gary,
Okay, so it seems like he says something. We couldn't hear it. Let's see if there's a close-up of that. Do we have any close-up of that? Maybe not yet. Here's a second video.
It's getting all of our attention. Just seconds ago, Steve Bannon arrived at the courthouse on his way to surrender to the FBI after being indicted for defying a subpoena from Congress. He is set to appear in a district court later today. You can't see him right here. You can just see that gray hair behind those cameras. Look at him. He's not rushing past them to walk inside. What is he like? This media attention, martyring himself for MAGA, a smile on his face as he's set to surrender.
So I think that's Stephanie Rule's voice. She also noticing that stupid smirk. So there it is. Let's see if we have any other closer in video. All right, nothing there. Okay.
Hispanics coming on our side, African Americans coming on our side. We're taking down the Biden regime. Every day the focus, you got Raheem Kassam today, you got Dr. Peter Navarro, Captain Bannon, you're going to have Boris Epstein, the whole show.
Is he promoting his show just as he's getting arrested?
Intense, we got polling out, economic data out, everything. I want you guys to stay focused, stay on the message. Remember, signal, not noise. This is all noise, that's signal.
Wow. Can you imagine? He's promoting his show as he's getting arrested. So there's that. And we're standing by for all of it very, very strongly. And that's all. I mean, it's crazy what's going on. All right. I have a few new mimetic elements for you guys. And okay. So first of all, the judge, as many of you know. Oh, yeah. Why do people think I'm not going to do super chats? I'll get to super chats. There's just no super chats right now. Everybody relax. So I have a bunch of different soundboard elements that Small Fuzzy Moss sent me now from the judge in the Rittenhouse case. Last week, we had the following.
Whatever you do, make sure you go to the bathroom somewhere other than the courtroom.
Right.
By the way, how are the calzones? The food is here. Let's take a break. Lunch is here. Uncharged piccolo's. Pizza is here. But we have Subway tomorrow.
Okay. I have a few others now. I have 4 additional elements.
All right. Enjoy your lunch. All right. How was the KFC? Very good, huh?
KFC, yeah.
Warm food. Warm food.
Warm food. That's the best one, maybe.
Warm food around noon.
Warm food around noon. Nun is actually a Hebrew letter. That could be a. He might be referring to the letter nun. That is. Let me hear that one more time.
Warm food around noon.
That is something else, huh? That is something else. Okay, so we've got that. Now, a couple of other things that I have. Here is an Obama-related thing that one of our viewers made. Let's see if people like this one.
Obama. Obama.
That's pretty good. Okay. And then we also have an historic new song from Jethro Bradley. I was worried Jethro Bradley had retired, but Jethro is back with an Obama song. This is an original song, guys, okay?
God bless the United States. God bless.
Obama.
You say Obama, I say Obama. You say your mama, I say your mamna. You say banana, I say banana. You say David Pacman, I say David Pacmanma.
That is being used by some, but it's...
Obama.
I did miss it. I should have mentioned it. I agree.
You say Obama, I say Obama. When Obama killed Osama, I think you mean Osama. When I smoke a blunt, it's always marijuana. The dude from Tibet, the Dalai Lama.
I like that. Marijuana.
Obama.
Yeah, the flute in the background is maybe the best comedic element. Okay, so that's really strong. And then lastly, we're just standing by for the start of the trial, guys. Everybody relax. I do have a Mango remix for you guys as well. Check this out. Hold on. Here we go. Uh-oh. Mangoes?
My bag of mangoes.
Uh-oh. I love mangoes too.
99 cents. Okay. Now that we are up under a Biden's regime, my bag of mangoes now costs $11.99.
That seems like a pretty good deal. A bag of mangoes? Aren't mangoes like $3 each? That's it. I want what this is good. Or $11. That sounds good.
The American people will lie. And highway robbery is what you're doing. Bring my mangoes back down. My bag of mangoes. My bag of mangoes.
Mangoes?
My bag of mangoes. Bring my mangoes back down. Raise the price of fruit. Don't raise the price of fruit. Don't raise the price of fruit. Bring my mangoes back down.
The Wisconsin crowd identifying with the mangoes.
It's really affected the American people. Those who want me to be healthy, healthy. Those who want me to be healthy. It's highway robbery is what you're doing. Don't raise the price of fruit. Don't raise the price of fruit. Don't raise the price of fruit. Don't raise the price of
Mangoes? Wow, what an incredible I don't even know what to call it. Composition. In most jobs, you might have like TPS reports.xls. Here, this is a work file. This is Lilu featuring Diamond and Silk and Deepak, bagofmangoes.mp4. That is a little bit of insight into what I have going on. So we're going to get back to those because people are just starting to connect to the stream. It's very, very early. We're going to review those a little bit later. And there is a lot coming forward. People saying super chats aren't working. They are. It's just that the first few are up, so they don't show up. But I'll read it anyway. David sends a super chat from Britain or the UK or England. I'm not sure which one. Sir, do you think the judge will still try to play both defense and judge today, or will he pickle Lane? Also, have you seen my wife? I actually know where your wife is.
Sir, your wife is up in the air.
Exactly. No, the judge is completely cartoonish in many different ways. By the way, the new thing now is that the Stephen Kenneth Destiny Bennell II community is attacking me for my view of the judge. Go away, guys. Come on. It's getting so boring. Okay. So that's that. Charlotte says, Dave, I work for a politician, have been watching your stream in the background. Had to log off from laughing so hard at the remixes. Many confused faces. Thanks for all you do. Well, I apologize, Charlotte. Charlotte also in the UK or Britain or England. Hard to know exactly which one. Oh, so I made an agreement with everybody that I was going to darken the mustache over the weekend, which I attempted to do. It didn't, it's a little darker. I got some of the beard comb in just for men stuff. It's only marginally darker. I'm kind of disappointed with the quality of it. So if I have time today, in order to stick to the promise I made, I'll keep trying to darken it. I'll get other things, but it's not a great product, I guess. And I shouldn't even say it wasn't necessarily just for men. It's just, I got a product. I don't want to disparage anything in particular, but I got a product to darken the mustache. Yeah. So, just so everybody remembers, Let's Go Brandon does get you banned. This is the 7th person I'm banning for that just this morning. There we go. Okay. Have you listened to opening arguments take on the trial? No, I haven't listened to anything, guys. I'm just too busy producing my show. David, I agree Kyle is likely to get off on the homicide. Is there a realistic chance he serves jail time for the lower level charges? I think there's about a 15% chance that he does any jail time. And in fact, let me ask you, people in the chat, do you think that there will be any guilty verdicts? That's question one. And do you think Rittenhouse will serve even a day of jail or prison time? Let me know in the chat. I want to hear from people. Okay. Let me know in the chat. And if you want to send a super chat, by all means, but I'm not requiring that. Just let me know in the chat. Let's see here. Another Let's Go Brandon ban. That person's banned. Let's see what else. There's just a lot of people to ban. I can barely even keep up with the ban hammers. It's kind of sad. Okay, good. All right, we've got that. Very good. So again, if you're just joining us, today is, in a sense, it is the absolute last day of the trial. We are about to hear jury instructions from Judge Schroeder.
Uncharged piccolos.
Then we will hear the closing argument from the prosecution, closing argument from the defense, and then a rebuttal from the prosecution. And then they will be off and running into deliberating. Now, I'm going to make a request of you guys right now. As soon as it is announced that there is a verdict, please let me know, info@davidpakman.com or however. I'm going to be doing my best to keep up. The verdict could be today. They might deliberate an hour. They might deliberate 3 to 4 and come back with a verdict. It could take a week. We don't know. I want to carry the verdict live. We're this far in. We're on day 10 in a row, really 11 if you include jury selection. Oh, sorry. I got to keep banning people here. Man, I can barely even keep up. Hold on a second. Another ban. That's number 12. And hold on. 13. Okay. There we go. Another Let's Go Brandon ban. Man, we've never had to ban people at the rate at which we're banning them today. It's crazy. It's really crazy. Okay, so the point is, when there's a verdict announced, usually they give us at least an hour. They give media an hour. And hopefully they will do that today. All right, good. I really want to just very briefly mention before I continue with Super Chats, and also voicemails are pouring in and they're starting any second here. Please get memberships on my website. We are still banned from Twitch. Last Monday, I received a 30-day ban from Twitch for showing a portion of the trial that was graphic. We are banned for 30 days. I've appealed it. The appeal hasn't even been adjudicated yet. I'm told it's in a queue. So I have no idea when that's going to happen. I'm hoping it'll be reduced to a week, which would get us back on today. They haven't even adjudicated it yet. So we lost 1,000 paid subscribers on Twitch. We're 7 days in, 23 days to go. Please sign up on my website, joinpacman.com. We do have a very special coupon code that will only go as long as the trial, and the code is Uncharged Pickles.
Uncharged Pickles?
And you can use that code at joinpacman.com. Also, anyone who signs up today via Patreon, it'll count double, okay? First person to sign up today is Kevin Gouldy using the code
Uncharged Pickles?
And Kevin is new member number, whoa, oh my God, get help with Notepad. That's not what I want. New member number 1 today. There it is. Number 1 at joinpacman.com. And we are about to start. This is the final day of the trial. We will have closing statements today. Mike says guilty on a gun charge.
And the appearances are as before, outside the presence of the jury. And I have sent proposal, or draft number 3 of the instructions to the attorneys this morning. And we'll make a record now on... Oh, would you get this on my printer?
Wow, have they not even agreed on the instructions yet?
Hey, Judge, this was...
Wow. Other super chats. David Wackman, who hates me but continues contributing, says lawless gangs are running wild, instilling fear and a terrified child to the liberals. I say be quiet. Your bleeding hearts cause many a riot. Lawless gangs running wild. Okay, who cares? Pokalova says, show me your dog.
All right.
Jeez.
Has everybody received a copy of draft number 3 of the proposed instructions?
Yes. Yes, Your Honor.
And state objections?
Judge, we have no objection. I know the defense has asked that the self-defense instruction be read with every count which is applicable. If they're asking for that out of an abundance of caution, we would agree with that request.
All right, what about that?
Well, Judge, we've had, we've all talked about things off the record in terms of our jury conference. I was under the impression that that was a requirement. I understand we're trying to streamline it. We're trying to not bore the jury with the instructions. I think that is, and if I'm wrong, I'm wrong, but I think that is what the law requires.
I inquired on the message last night. Is anybody familiar with authority on this subject that requires that? That makes, I guess I'll argue with you and then I'll hear the rest of what you have to say. You know, attention span, as you know, you speak to juries all the time. And when you start repeating yourself, you lose your audience mighty fast. They've got a lot to hear today from me and from you lawyers. And if I am reading the self-defense instructions 5 times, I would expect to lose the audience rather rapidly. By the way, how are the calzones?
And
this is so typical of lawyers. We're hidebound. We've always done it this way, And I will tell you that for years I have taken out common elements of things and put them in separate areas of the instructions. And once they learn what the term intent to kill means, I don't have to define it every single time it comes up. And I've never gotten, even to my knowledge, there hasn't even been an appeal on it. My job here is to communicate with the jury so that they understand what the law provides, and I think that can be done better, briefly and concisely, than by repeating the same old stuff over and over again. But given the position of the parties, if that's your position, we'll do it. But to me, it's a monumental waste of time, and it may end up having a negative effect. But I'm not.
All right, how was the KFC? Very good, huh?
Magnitude over 2 days, 2 weeks to try. So if you think that risks everything to proceed as I've suggested, then we'll go with the long forms every time. I'm gonna have to count on you to make timely objection if you feel that I'm leaving something out on a particular count, because I've prepared it in the 36 pages of instructions.
Oh my God!
Using a brief form without. There's already plenty of.
Going to be a long day.
Repeating going on, but if I have to do longer, you're going to have to object if you think I'm missing something, or it's going to be a waiver, just so you're forewarned. You have to make a contemporaneous objection. Is that clear?
36 pages.
Yes, sir. And the only one that you don't have it in that we had talked about a little bit was count 5. You had. There's a lesser included offense of recklessly endangering safety.
Oh, yeah, I'm sorry. On that one, I do think that, no, I didn't put it in there, although it does in the...
I didn't think they were supposed to refer to the judge as you.
Satisfied beyond a reasonable doubt of that the defendant was not acting lawfully in self-defense. But I'll try to squeeze the content in there as well. And I guess I'm not sure that I agree with your statement that, well, let's take a look at it.
So if you're just joining us, they're still arguing about jury instructions, which will be read today to the jury.
And of course, the state wants me, if I read the self-defense portions in, then they want me to repeat every time retreat and provocation, which you have opposed.
They don't.
So they're going to hear that again. What?
They don't want that anymore.
They don't want it anymore?
I'm going to withdraw that request simply because of time.
Okay. I think I'll go back to bed. Okay.
Whatever you do, make sure you go to the bathroom.
But in counts 2
somewhere
and
other than the
3,
courtroom.
I gave special instruction only with respect to Mr. McGinnis, because the law is different
here.
with respect to him. And we'll get to that.
Okay, very good.
But I didn't reread it with respect to the account involving Mr. Jumpsuit Man.
Jumpsuit man.
What I think is so you've done attempted first degree with self-defense, attempted second degree with self-defense. But the way that I read it, and if I'm reading it wrong, I know the court will correct me, on page 27 of the final instructions, it simply says, here are the elements. I didn't see
Elements of medical.
self-defense mentioned
You're right.
in there.
You're right. Because as I did, now, let me say, on counts, the attempt murder and the murder, on those, that's the pattern instruction. If I had my way, I think that's overly verbose. And
Verbose? I like
we didn't
that.
used to do it that way, and then they came up with this, and I follow it, but I think it could be better stated. But I follow the guidance of the instruction committee.
This
'cause they're more
guy,
them than
it's wacky. I agree.
very bright people. But and then on count 3, I gave a special instruction because of the situation with Mr. McGinnis, but I didn't on count 2 or count 5 because I relied upon the general principles of self-defense on which I instructed them. So if you want me to do it on 5, I need to do it on 2 too. When they've just that's on 2 also, and that's right after they've just heard it. So all right.
Well, my only concern is that the instruction makes it clear that self-defense is an issue for first-degree attempt and second-degree attempt. I don't know
I
if
understand.
right.
And
So
that's because that's from the pattern instruction. I understand you're thinking, well, because I didn't discuss it in the portion on reckless endangerment, that they're going to think it's not part of it. But the last sentence tells them, and if you are satisfied beyond a reasonable doubt that the defendant's conduct was not privileged under the law of self-defense, you should find the defendant guilty.
Did you see that under the recklessly endangering safety one, Your Honor? Is that what I'm just making? Is that what you're telling me?
That's on the that's on. Excuse me, I'm reading the 4th count here. Let's see. Let's have a look at what I said on 5. See, if I had set this up, I would have put a. Well, I'm not going to say what I would have done. You know, you're right. Well, maybe I misunderstood what you wanted. Did you want the whole self-defense instruction discussed again, or just the clause? And if you are not satisfied beyond a reasonable doubt that the defendant, or that I should say it, is all 3 elements of the crime of endangering safety of the first degree have been proved, and that the defendant is not privileged under the law of self-defense, you must find the defendant not guilty.
I think that's fine as long as the self.
You don't need the whole.
As long as they're aware that
the whole
self-defense
instruction
is an option.
Yeah, well, you're right. All right, I'm misunderstanding what your email said. So, if you are not satisfied beyond a reasonable doubt well, there's more missing there than that. You know that? There's not the clause about if you are satisfied.
Big thanks to Mitch Reed for signing up on my website, joinpacman.com. Mitch, you're the man. Thank you. Also, thanks to Shamari Vasquez, who just upgraded her subscription. I'm going to call it a new one. That's number 3.
Page 27, the fourth line will be, if you are satisfied that all 3 elements of the crime of reckless endangerment have been proved, and that the conduct of the defendant was not privileged under the law of self-defense, then you should find the defendant guilty of reckless endangerment of the first degree discharge
around noon.
as submitted. If you are not so satisfied, then you must find the defendant not guilty.
Okay.
Is that satisfactory? Okay. What's next?
Patreon is double today, yes.
I have nothing else on the instructions.
Defense?
So, Judge, this is more for the record. You've already made, I think, preliminarily, you had talked a little bit about the Richie McGinnis instruction.
Right.
Which is on page 8 and 9.
Right.
And the position that I had taken was one of the lines says but the defendant does not have a privilege of self-defense as to Richard McGinnis. After that, there's discussion about self-defense and what that means. On page 9, there's a sentence that says, if the defendant was acting lawfully in self-defense, his conduct did not create an unreasonable risk to another. I had told you in an email that all the parties were involved in that I thought that there was some incongruence in that in terms of how that reads. I know the court disagrees, but just for the record, I wanted to make sure that that was on there. Because I do think it's confusing. However, I know it's the pattern instruction. I know you took it from the pattern.
Yeah, I'm not even going to argue with you. It is the pattern, and I'm not going to argue with you that it is confusing. But it's an accurate statement of the law. Mr. McGinnis does not have a self-defense status because he's the defendant has no right of self-defense as to any harm he would cause to Mr. McGinnis. And that's what the instruction is telling the jury. But if he was acting lawfully in self-defense with respect to Mr. Rosenbaum, then it kills one of the elements. I think I'm reading that right.
Elements of bathrooms.
It gives him an absolution with respect to the element of what is the precise?
A lot of elements, huh?
Number 2.
Part of element, yeah. Unreasonable and substantial risk of death. It says then that the jury can't find that. Well, if they can't find that, they can't find one of the elements, so they have to find the defendant not guilty.
Judge, do you think it's appropriate then on page 9 to say if the defendant was acting lawfully in self-defense as it relates to Joseph Rosenbaum?
At what point do you want that put in?
I just think that makes it clearer. I mean,
where do you want to put in?
Where did you say?
Yeah.
On page 9, it would be right, so there's a subheading determining whether the beliefs were reasonable. I think it's the third or fourth to last sentence says, if the defendant was acting lawfully in self-defense, comma.
Okay, with respect to
Joseph Rosenbaum.
With respect to Joseph Rosenbaum.
His conduct did not create an unreasonable risk to Richard McGinnis.
Yeah, I'll do that. Any objection?
No.
Okay. Okay, what's next?
Your Honor, that on page, these are small, but on page 34, 2 of the witnesses, you said one of the witnesses had been convicted of a crime. Mr. Grosskreutz had been convicted of a crime, and Mr. Smith had been convicted of a crime for a juvenile adjudication. So I think if you just say multiple witnesses had been, something like that.
Okay. What page is that on?
I'm sorry, 34.
A lot of demands here from the defense. They're doing their job.
And we are asking for the cautionary.
Do you want the word some instead of one?
Or multiple? Yeah, some
Several?
is fine.
How many was it? 2.
That I recall.
There actually were. Well, I don't think you asked Ms. Sword about hers. There was another witness with convictions, but I don't believe the question was asked. So 2.
What was the answer?
2.
All right, I'll put down 2 then.
And then there was some conversations regarding a cautionary instruction regarding Mr. Armstrong.
Yeah, and I really struggled with it.
And we had proposed the instruction to the court, which I think we took off of 245 or something like that.
Yeah.
So we are asking, based on his testimony, that the court instruct with that modified 245 instruction as relates to Mr. Armstrong.
Did you want to be heard?
Well, I would stand by what I indicated over the weekend in my email, but I believe that I'm looking up the specific instruction.
My instinct is that Richards and Binger are not participating in this because they're the ones delivering the closing statements, and they're just sort of, staying in the zone as far as that goes.
I had planned on using if I had drafted it myself.
Judge, I just don't think it's necessary. The evidence was received. The points that the defense wanted to get into were made on cross-examination. Giving any kind of instruction on this would essentially be telling the fact finders how to weigh the evidence. I proposed some different wording. You should not base a verdict of guilty upon it alone unless after consideration of all the evidence you are satisfied beyond a reasonable doubt that the defendant is guilty is completely inappropriate. I can understand where it's appropriate if you're talking about accomplices, but certainly not when we're talking about a one picture out of 100 and some odd exhibits. So I don't believe it's appropriate. I don't believe it's necessary. I believe that these arguments about pixels and zooming are specious, that their expert used a very similar software program with zooming, was cropping.
But there was no objection then, you see.
I understand. There's no basis for an objection, and they know that.
I don't know that. Maybe they do. I don't know. I can't read their minds.
This is a forensically sound program used by a forensic analyst who's trained. This image was peer-reviewed. If they want to discuss the proprietary algorithms and how
here we go,
analysts would not know a proprietary algorithm contained in the software that they are using, that is an industry standard, they can go ahead and argue that. But to give an instruction that tells the jury essentially to ignore this evidence unless everything else proves it is way too far.
Well, this whole business about, well, I don't want to say the whole business, but the Daubert rule is the product of the abuse of so-called scientific evidence by attorneys. There were companies, pension funds, individuals were bankrupted because of legal decisions that were made on the basis of so-called science, which was later shown to be garbage. So when you come in here and you tell me, well, this is what they rely on, I think that's fine, except when my common sense tells me, well, wait a minute, what's happening here when you get an image that is consistent of, I'll say it again, let's say 2,500 pixels, and you blow it up to 25,000 or 250,000,
uncharged
and you don't
pixels?
really know what fills the vacant space. That's a little struggle for me, and this is not being used to decide which camera I'm going to buy or which phone I'm going to buy when I'm at the store. This is being used to decide about whether someone's innocent or guilty of a crime. So that's why I was.
Here we go.
When the witness answered, he didn't know, and the only reason I left here and I troubled about it, and in the end, I decided, well, wait a minute, we allow this kind of thing to happen in DWI cases where the officer is asked, well, how does the machine work? I don't know. I just am trained how to operate it. But there is a difference there. That has already passed judicial scrutiny, and this method has been judicially determined to be accurate. Has that been done in this? I don't know. So that was when I was thinking, well, maybe I should give a cautionary instruction.
Wow.
I ultimately, you convinced me in our exchanges that I don't want to be meddling and commenting on the evidence. I will tell you this, assuming that there's conviction, one or more, assuming that other motions don't contaminate the whatever outcome there is, if it comes out at some time that the method used produces unreliable results, this is going to fall like a house of cards. Because you're basing this extremely important segment of the evidence on something that I'm really queasy about. But as I said when I left here Friday, this is the jury's case. It's not mine. And I'm going to let them decide. They have...
He's going to let them decide, but he's going to warn them.
Photographs and your video, and they've got the testimony of the person who's worked with it, who knows a lot more about this stuff than I do. So I've decided to leave it alone. So I'm not going to give an instruction on it, but I've made my record on the high risk that I think it presents for the case. Okay, what's next?
The two last things, Judge, are the court had modified a little bit count 6, which was the...
I did.
Okay, so the third element that you have listed there is the dangerous weapon was a rifle that had a barrel length of less than 16 inches or an overall length of less than 26 inches. We have pulled a transcript, talked, and looked at it. Detective Antaramian was asked if this was a short-barreled rifle. He had answered no, he did not believe that it was. That's the only information regarding that.
Was the gun offered as an exhibit?
Yes.
That is evidence.
Correct.
Enough in itself. The jury can measure it.
Okay. Fair enough. I just didn't, the way that I looked at it, there was no other information that a reasonable juror could believe that count 3's been met. So
what are you telling me?
That I'm asking that you take it from them.
They're asking me to dismiss the case for failure to prove.
This count 6. Judge,
Count 6.
there have been many discussions about this count. I'm not going to rehash everything. The state disagrees with the interpretation the court has established. We do not believe this jury instruction is appropriate. We do not believe that the exception or affirmative defense, or whatever you want to call it, was properly raised. We argued about all that on Friday. I'm not going to rehash it. I believe it should go to the jury, and if the jury believes that it was not proven beyond a reasonable doubt, they can return a verdict on that. But the state has objected all along, or has given its version all along. We stand by that version. I believe that this jury instruction essentially swallows the entire statute. We've gone over that before. So I believe that if they raise an exception, then it should go to the jury. We would like the standard instruction. Clearly, the court's not going to do that.
Well, up to now, the motions were motions to dismiss the complaint. And you filed a very nice brief, which well explained what the law is. And of course, we were dealing with what the complaint stated and whether the complaint stated sufficient facts to bring the case to court. And the court is confined on that kind of a motion to what's in the complaint and whether it meets the law. And as you pointed out, these defensive matters are affirmative defenses, and the DA doesn't have to plead them. So that's why I ultimately denied the motion to dismiss, although I think it ought to have been mighty clear that I had big problems with this statute. I've made no bones about that from the beginning. And there always was access to the Court of Appeals all along here. Well, I guess that's not fair for me to say because I was sitting on it. But so shame on me. But I ultimately read the statute and have, even when I ruled on the motion to dismiss, I was of the opinion that the statute was as interpreted by the defense, but there was not sufficient grounds to grant the motion to dismiss. Is the firearm here now?
Yes.
We can either measure it, or you can stipulate that it does not meet what I've stated are the...
So we started a poll 16 minutes ago about whether they would do at least 30 more minutes of the debate. The poll is still running. It's looking more and more like the answer is yes.
if the barrel length is less than 60 inches, or an overall length less than 26 inches, then I'll deny the motion. If it does not meet those specifications, then this defense motion will be granted.
We are not disputing that the barrel is appropriate.
Isn't legal?
It is not a short-barreled shotgun or a short-barreled rifle, yes.
Either by...
Oh my God, the audio.
Correct.
All right, and then count 6 is dismissed.
Wow. They've dismissed another count.
What's next?
One other thing, Judge. I had filed on November 8th, we had addressed a motion for mistrial with prejudice. The court had taken that under advisement. What I had informed the court was
the mistrial.
So I have filed something in writing on that. I know the court likely hasn't had an opportunity to review it. I don't know.
I haven't even seen it.
Okay. I'm assuming that we're going to go obviously through closing arguments today, but I did want to make sure the court was aware that it had been filed, and at some point have the court make a final ruling on it, just for the record.
I will.
Okay.
If it's necessary.
So that means there's not going to be a mistrial, it sounds like.
Came in this morning? Okay. Okay, anything else?
Were you ever able to get the defendant's interview link that we sent to play? The Washington Post story?
I did receive that. I did receive that.
It relates to the motion. That's the only reason I asked. The defense motion, it relates to that.
Well, I'm not going to take up the motion now.
I understand now. I just know there were technical problems. I just wanted to make sure they were ironed out.
I did receive it.
Okay.
Okay. Anything else right now?
Judge, are you done? Attorney Charles? The only thing, Judge, in our arguments, we would like to indicate that pointing a loaded AR-15 at someone without reasonable justification would be a criminal act without citing, the specific statute, but that pointing under 941.20 is a crime. We would like to point that out, and we just wanted to preview that, so if there's objection, we can handle it now.
Okay. Do you want to respond?
We would object. This is once again relying on the exhibit that is so far out of focus, and there's been nothing in the record. When I specifically asked the Detective Howard regarding the strong arm robbery, I asked about it. Strong arm robbery while masked. I asked about it. It's in the record.
The struggle I'm having with that is, and I will, well, I'll leave that. How do we know it was pointed at or toward Mr. Zeminski or Mrs. Zeminski or whomever? You have a theory that it's pointed in that direction. I agree with that. But the statute's prohibition is pretty explicit. And I'm not sure that the evidence that you have, especially because it's just not just especially, but in part because it's just a regular photograph. It's not multidimensional. It doesn't show the exact area at which the firearm was aimed.
Judge,
even if you see the firearm.
Again, the photograph is perhaps the 5th or 6th most relevant piece of evidence on this topic.
Most what?
5th or 6th most relevant piece of evidence on this topic. We have testimony, we have videos. I'm not going to go over that again. The defense submitted their own exhibit of the FBI video with the Zeminskis denoted as being the only two that were on that side of the Duramax. Mr. Zeminski starts out by one of the windows of the Duramax. I guess it would be the rear passenger side window. And so there's no real dispute that they are in that area, and that is where that he is pointing the weapon. It's for the jury to decide if he's pointing it at Zeminski's or not.
So it's for the jury to decide. It is not for the jury to speculate. I mean, let's look at the statute. That's a good place to start.
I want to say thanks to Kelly Foltz and Miles Cornish, as well as Eric Fair Lehman, for signing up on my website, joinpacman.com. Really appreciate that.
Yeah.
Oh, also, thanks to Tariq Thomas for signing up on my website, joinpacman.com.
And
We're
brings up, a separate issue, I suppose, that what is the role of Mr. Rosenbaum, assuming the defendant violated that statute? That's the very theory that the state has proceeded on in the first place, is that the defendant was a vigilante who was getting himself involved in something that was not his concern. And now you're telling me that would justify Mr. Rosenbaum's actions? I'm kind of struggling with that, too.
Patreon is double today, guys. I see people in the chat.
I mean,
Yeah.
what does the jury do with that?
I don't fully understand the court's question. I would also note that
pardon me?
He also pointed the weapon at Mr. Rosenbaum before the shooting. While he's being pursued, he turns and points it at Mr. Rosenbaum.
Well, there's no question about that.
Correct.
He's being chased by him.
Pardon me?
I said he's being chased by him.
Well, they've made it much more complicated. It used to be points or aims of firearm at another. I'm not seeing that exact language anymore, but I'm not seeing it here in the statute that there would be a broad enough sweep to capture.
So 24 minutes ago, we started a poll asking, are they going to do another 30 minutes of this arguing over the jury instructions? We're only 6 minutes from that becoming a reality. We'll end the poll at that point.
Specifically at or toward another?
In the meantime, let me know in the chat if you think there will be any guilty verdicts at all on any count.
Weapon.
Could you start that over?
Sure. 1A is endangers another's safety by the negligent operation or handling of a dangerous weapon. We would argue that it is. If the court feels otherwise, we just simply will talk about it and not call it a crime.
Where was the firearm aimed? You say at the Zabinskis. I didn't hear the Zabinskis come in here and say that. Who said it?
Except for looking at the video, and that's who's over there. That would be the only evidence.
I mean, pardon?
Looking at videos and indicating that those are the ones who are over there, that would be the only evidence.
I can't say it. I'm not saying it didn't happen. I'm saying I don't think I can give an instruction to the jury telling them, something when I don't see the statutory.
We're asking for instruction. In our closing, in our arguments, we just wanted to say that it's.
I think it would be okay for you to say.
Hey, by the way, great to see Flossie Carter in the chat on the stream. Flossie, even significantly bigger YouTube channel than ours. Check out Flossie Carter. Congratulations for finding our stream. I appreciate it.
Statements that could be made, but I don't want to try to, rule in advance. I've refrained from doing that. I always try to, because I can't read your mind. But so I'm not going to say he can't mention that at all. That it's unlawful to point a gun at somebody. The jurors probably have a sense of that anyway. But
they have a sense of it. I like that.
But as to
the jurors generally have a sense that murder is wrong.
Okay, what's next?
That's all we have.
Okay. Ready for the jury?
Wow.
I'll probably take a break after the lengthy instructions.
So they actually stopped just 4 minutes short of going an extra half hour. It really looked like it was going to go long, but it didn't. We don't yet know what's for lunch today. We just don't know.
Warm food around noon.
Yeah. I do want to say thanks to Al the Alchemist, Anna Person, and Edward Lopez. They just signed up on my website, joinpacman.com. Appreciate you guys. Puts us at 10. Remember, today Patreon pledges count double. That means 1 counts as 2. 2 count as 4. 16 count as 32. 1,000 count as 1,100. What's 1,000 times 2? It's 1,100, right? I can't remember. They have not had, to my knowledge, Indian food. Now, when the judge referred to the Asian food last week, India is part of Asia, but traditionally when we say Indian, when we mean Indian food, we say Indian food. So we are looking into that very strongly. Jury's coming in. They're starting 36 pages of jury instructions. And then we will have closing statements, closing statement from the prosecution, closing statement from the defense, rebuttal from the prosecution, 2.5 hours allocated to each. So if this takes an hour, that puts us at close to noon. Then they will take a break, probably till 1. And then we could potentially have 5 hours, which would already get us to 6. So they may not even be done today. The judge was talking about we'll hand the jury the case by 3 p.m. their time, which is 4 p.m. on the East Coast. I think that's very optimistic because there's going to be a break. There's presumably going to be lunch.
By the way, how are the calzones?
Yeah. And today it maybe even be something else.
But we have Subway tomorrow.
Yeah, we just don't know what they're going to be bringing in today. So that'll all be happening. A few quick super chats here. How many think the judge has seen elements of misconduct in his trial? Judge seems different today. Oh, now he's on his phone. Many people have been convicted based on junk arson science, bite mark science, blood type science. Probably some of the judge was referring to. This is painful. Anybody need Medico?
Elements of medical.
Okay.
Here we go. We are just getting started. It's going to be a long day. It's getting really trashy in the chat, so we may go subscribers only. We've had to ban about 30 people just in the, how long have we been streaming? Hour? 45 minutes we've been streaming. So we may do it. Honestly, watching this trial just makes me hungry.
Let's take a break. Lunch is here. All right, how was the KFC? Very good, huh?
Oh, something about the pretty good, huh? Have you heard of KFC? Pretty good, huh? Is extra funny. Shout out to Durango's Pizza in Kenosha. David, thank you for doing this every day. Pleasure. It's been good to be here. Yeah.
The food is here.
Yeah. Still, my favorite moment is the judge telling the jury not to go to the bathroom in the middle of the courtroom.
Whatever you do, make sure you go to the bathroom somewhere other than the courtroom.
Yeah. Oh man. I wonder, how far is it from the courthouse to the nearest KFC? Kenosha Courthouse to KFC. Like, how far did they bring that in? It's about it is 2.3 miles. I guess in the Midwest, 2.3 miles isn't a lot. You know, in a lot of cities, it's like 2.3 miles. It could take you an hour to do that. Any interesting restaurants? Infusino's Italian Restaurant and Pizzeria. That's an interesting spot. I wonder if the Asian food was from Chen's Bistro, very close to the courthouse. Just looking at a map here. A lot of interesting little spots. I don't know if Kenosha is considered a culinary destination, but remains to be seen.
Nice weekend, and we'll begin our final phase of our case, which is my instructions, and I'm going to instruct you on the principles of law which you are to follow in considering the evidence and in reaching your verdicts.
Here we go.
It is your duty to follow all of these instructions, regardless of any opinion that you may have about what the law is or what the law ought to be. You must base your verdict on the law as I give it to you in these instructions. Apply that law to the facts in the case which have been properly proved by the evidence. Consider only the evidence received during the trial, and the law is given to you in these instructions. and from these things alone, guided by your soundest reason and best judgment, reach your verdict. If any of you has any impression of my opinion as to the innocence or guilt of the defendant, you must disregard that impression entirely and decide this case solely as you view the evidence. You are the sole judges of the facts, and I am the judge of the law only. Keep in mind that the information is nothing more than a written formal accusation against the defendant, accusing him of the commission of crimes. You are not to consider it as evidence against the defendant in any way, and it does not raise any inference of guilt. The information contains 6 counts of charged unlawful behavior against the defendant, and to each of these he has entered a plea of not guilty, which is a demand that the state prove every element of each crime beyond a reasonable doubt. Self-defense is an issue in this case. As to 5, and I might interject here, count 6 is no longer part of your consideration. That was the firearm charge. So that will not be something that you will need to address. You'll need to address only the first 5 counts. Self-defense is an issue in this case. As to each of counts 1 through 5, the state must prove by evidence which satisfies you beyond a reasonable doubt that the defendant did not act lawfully in self-defense. The law of self-defense allows the defendant to threaten or intentionally use force against another only if he believed that there was an actual or imminent unlawful interference with his own person, and he believed that the amount of force which he used or threatened to use was necessary to prevent or terminate the interference, and his beliefs were reasonable. The defendant may intentionally use force which is intended or likely to cause death or great bodily harm only if he reasonably believed that the force used was necessary to prevent imminent death or great bodily harm to his own person. A belief may be reasonable even though it is mistaken. In determining whether the defendant's beliefs were reasonable, the standard is what a person of ordinary intelligence and prudence would have believed in the defendant's position.
Ordinary intelligence is a tough one.
Existed at the time of the alleged offenses. The reasonableness of the defendant's beliefs must be determined from the standpoint of the defendant at the time of the defendant's acts and not from the standpoint of the jury now. There is no duty to retreat. However, in determining whether the defendant reasonably believed the amount of force used was necessary to prevent or terminate the interference, you may consider whether the defendant had the opportunity to retreat with safety, whether such retreat was feasible, and whether the defendant knew of the opportunity to retreat. You should also consider whether the defendant provoked the attack. A person who engages in unlawful conduct of a type likely to provoke others to attack, and who does provoke an attack, is not allowed to use or threaten force in self-defense against that attack. However, if the attack which follows causes the person reasonably to believe that he is in imminent danger of death or great bodily harm, he may lawfully act in self-defense, but the person may not use or threaten force intended or likely to cause death unless he reasonably believes that he has exhausted every other reasonable means to escape from or otherwise avoid great bodily harm. Counts 4 and 5 require intent to kill as part of the elements. Intent to kill means that the defendant had the mental purpose to take the life of another human being or was aware that his conduct was practically certain to cause the death of another human being. While the law requires that the defendant have acted with the intent to kill, it does not require that the intent to kill have existed for any particular length of time before the act was committed. The act need not have been brooded over, considered, or reflected upon for a week, a day, an hour, or even for a minute. There need not have been any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to have existed at the time of the act. You cannot look into a person's mind to determine intent. Intent to kill must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case which bear upon intent. Intent should not be confused with motive. Proof of motive is necessary. While proof of motive is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of the defendant, the state is not required to prove motive on the part of the defendant in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all of the circumstances.
I didn't want to interrupt, but that was a very... Did the judge say both that motive is and is not a requirement? That motive... That was a very strange thing there.
Of Kenosha in this county, the defendant recklessly caused the death of another human being, Joseph D. Rosenbaum, under circumstances which show utter disregard for human life. First-degree reckless homicide, as defined in the criminal code, is committed by one who recklessly causes the death of another human being under circumstances which show utter disregard for human life. Before you may find the defendant guilty of reckless homicide of the first degree, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. First, that the defendant caused the death of another. Cause means that the defendant's act was a substantial factor in producing the death. Second, that the defendant caused the death by criminally reckless conduct. Criminally reckless conduct means the conduct created a risk of death or great bodily harm to another person, and that the risk of death or great bodily harm was unreasonable and substantial, and that the defendant was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. The circumstances and the circumstances of the defendant's conduct showed utter disregard for human life. In determining whether the circumstances of the conduct showed utter disregard for human life, you should consider these factors: what the defendant was doing, why he was engaged in that conduct, how dangerous the conduct was, how obvious was the danger, whether the conduct showed any regard for human life, and all other facts. And
I mean, without even attacking the people on the jury as incompetent, because we don't know anything about them other than some of the things that were said, which raised real questions. Can the average person who doesn't work within the law even keep all these things in mind in making such complicated decisions? I'm just asking. I don't know.
As I have instructed you on the law of self-defense, then you should find the defendant guilty of reckless homicide of the first degree as charged in the information. If you are not so satisfied, then you must find the defendant not guilty on this count. Counts 2 and 3 of the information accuse the defendant of the crimes of recklessly endangering safety. Although the elements of each of these charges are identical, the rules of self-defense which apply to them are not.
Oh, boy.
The second count of the information charges that at the same time and place, the defendant recklessly endangered the safety of Richard McGinnis under circumstances which show utter disregard for human life. The third count of the information charges that at the same time and place, the defendant recklessly endangered the safety of an unknown male under circumstances which show utter disregard for life. First-degree reckless endangerment, as defined in the criminal code, is committed by one who recklessly endangers the safety of another human being under circumstances which show utter disregard for human life. Before you may find the defendant guilty of reckless endangerment of the first degree, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. First, that the defendant endangered the safety of another human being, and the risk of death or great bodily harm was unreasonable and substantial, and the defendant was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. Great bodily harm means injury which creates a substantial risk of death or which causes serious permanent disfigurement or which causes a permanent or protracted loss or impairment of the function of any bodily member or organ or other serious bodily injury. The third element is that the circumstances of the defendant's conduct showed utter disregard for human life. Again, in determining whether the circumstances of the conduct showed utter disregard for human life, you should consider these factors: what the defendant was doing, why the defendant was engaged in that conduct, how dangerous was the conduct, how obvious was the danger, whether the conduct showed any regard for human life, and all other facts and circumstances related to the conduct.
Judge seems confused.
Uncharged piccolos? Warm food around noon.
This is a mess. I agree with you guys. But I guess so far he hasn't made any jokes. That's something. Look at this.
By the way, how are the calzones?
My God.
Please proceed, Governor.
I do want to say thank you to, oh, nobody even signed up. That's sad. Okay. David, who eats more fast food, Donald Trump or this judge and the jury?
But we have Subway tomorrow.
Right.
All right, how was the KFC? Very good, huh?
I don't know the answer. I don't know. I love calzones, though. I really do. A calzone is... Every once in a while, my girlfriend would be like, let's order a pizza. And I go, And I go, oh, wait a second. The pizza place has calzones.
Pizza is here.
Right. And then I'll go, let's do it. Let's do it. Ricotta mozzarella. You really need both. You really need both. When was the last time I ate at a KFC? I think 15 years ago. One opened near where I was living at the time after there being no KFC for a while. And I went and got a crispy strip meal. I remember that KFC coleslaw. Quite compelling. I don't even know if it has mayo in it or real mayo. That was the last time. Yeah, about 15 years ago. The judge actually just pulled out an Asian food menu. He's actually worried that what is being advertised as wasabi is just horseradish and green food coloring, and he is not pleased one bit.
The food is here.
Will I open phones today? So, I am open to opening phones today, yes. But I actually have a very interesting live stream on my Instagram happening later today with a celebrity, which I will announce once it's confirmed. So, here's the deal. If we were to get to 100 and I don't have time, we'll do it tomorrow. Okay?
When I was instructing you a moment ago on reckless homicide, I indicated there were 2 elements. There are actually 3. I did read all of the ingredients, but I'm just going to reread a portion of that instruction so it's clear that there are 3 elements to that crime. And I also used the word both of the elements, and it's actually 3. So I apologize for that mistake. And
getting pretty dicey.
we'll stop with the reckless endangerment for a moment and return to the reckless homicide. And the elements of reckless homicide are that the defendant caused the death of another.
All right, I'll be back.
He did so by criminally reckless conduct. And the third element, which I read as part of the second, is that the circumstances of the defendant's conduct showed utter disregard for human life. And what tipped me off is, other than causing death, the reckless endangerment, which I've been reading now, has those same 3 elements. So utter disregard for human life is one of the elements of both crimes. And in order to convict on the first count, you must find the presence of all three of the elements of first-degree reckless homicide, and also find beyond a reasonable doubt that the defendant was not privileged under the law of self-defense. Is that clear? Thanks. Thank you very much. Getting back to the reckless endangerment charge with respect to Mr. McGinnis, there is evidence in this case that the defendant was acting in self-defense as to Joseph Rosenbaum. The fact that the law may have allowed the defendant to use force in self-defense as to Joseph Rosenbaum does not necessarily mean that recklessly endangering the safety of Richard McGinnis was lawful. You must consider the law of self-defense in deciding whether the defendant's conduct as to Richard McGinnis was criminally reckless conduct, which showed utter disregard for human life, but the defendant does not have a privilege of self-defense with respect to Mr. McGinnis. So the defendant would enjoy a privilege of self-defense with respect to Mr. Rosenbaum if you find the factual ingredients of that. But that doesn't mean that the fact that if he endangered the safety of Mr. McGinnis was privileged under the law of self-defense, because Mr. McGinnis was not attacking him. However, you must consider the law of self-defense in deciding whether the defendant's conduct as to Richard McGinnis was criminally reckless conduct which showed utter disregard for human life, but he does not have a privilege of self-defense as to Richard McGinnis. The law of self-defense allows the defendant to threaten or intentionally use force against another only if the defendant believed that there was an actual or imminent interference with the defendant's person, that he believed that the amount of force he used or threatened to use was necessary to prevent or terminate the interference, and that his beliefs were reasonable. The defendant may intentionally use force which is intended to or likely to cause death or great bodily harm only if the defendant reasonably believed that the force used was necessary to prevent imminent death or great bodily injury to himself. A belief may be reasonable even though mistaken. In determining whether the defendant's beliefs were reasonable, the standard is what a person of ordinary intelligence and prudence would have believed in the defendant's position under the circumstances existing at the time of the alleged offense. The reasonableness of the defendant's beliefs must be determined from the standpoint of the defendant at the time of his acts and not from the viewpoint of the jury now. You should consider the evidence relating to self-defense along with all the other evidence in the case in deciding whether the defendant's conduct created an unreasonable risk of death or great bodily harm to Richard McGinnis. If the defendant was acting lawfully in self-defense with respect to Joseph Rosenbaum, his conduct did not create an unreasonable risk to another. The burden is on the state to prove beyond a reasonable doubt that the defendant did not act lawfully in self-defense, and you must be satisfied beyond a reasonable doubt from all of the evidence in this case that the risk was unreasonable. You should consider the evidence relating to self-defense in deciding whether the circumstances of the defendant's conduct showed utter disregard for human life. The burden is on the state to prove beyond a reasonable doubt that the defendant did not act lawfully in self-defense, and you must be satisfied beyond a reasonable doubt from all of the evidence in this case that the circumstances of the defendant's conduct showed utter disregard for human life. If, as to each of these counts, you are satisfied beyond a reasonable doubt that the elements have been proved and that the defendant was not acting lawfully in self-defense, you should find the defendant guilty of reckless homicide of the first degree. If so satisfied, then you must find the defendant not guilty. The fourth count of the information charges that at the same time and place the defendant caused the death of another human being, Anthony M. Huber, with intent to kill that person. This is a charge of intentional homicide of the first degree, and you must consider first whether the defendant is guilty of that offense. If you are not satisfied the defendant is guilty of first-degree intentional homicide, you may consider whether or not the defendant is guilty of second-degree intentional homicide or first-degree reckless homicide, which are less serious degrees of criminal homicide. The crimes referred to as first and second-degree intentional homicide and first-degree reckless homicide are different degrees of homicide. Homicide is the taking of the life of another human being. The degree of homicide defined by law depends on the facts and circumstances of each particular case. While the law separates homicides into different types and degrees, there are certain elements which are common to each crime. Both intentional and reckless homicide require that the defendant have caused the death of another. First and second degree intentional homicide require the state to prove the additional fact that the defendant have acted with the intent to kill. First-degree reckless homicide requires that the defendant acted recklessly and that the circumstances of his conduct showed utter disregard for human life. It will also be important for you to consider the privilege of self-defense in deciding which crime, if any, the defendant has committed. The Criminal Code of Wisconsin provides that a person is privileged to intentionally use force against another for the purpose of preventing or terminating what he reasonably believes to be an unlawful interference with his own person by the other person. However, he may intentionally use only such force as he reasonably believes is necessary to prevent or terminate the interference. He may not intentionally use force which is intended or likely to cause death unless he reasonably believes that such force is necessary to prevent imminent death or great bodily harm to himself. As applied to this case, the effect of the law of self-defense is the defendant is not guilty of any homicide offense if the defendant reasonably believed that he was preventing or terminating an unlawful interference with his own person, or reasonably believed the force used by him, and reasonably believed that the force used by him was necessary to prevent imminent death or great bodily harm to himself. The defendant is guilty of second-degree intentional homicide if he caused the death of another human being with intent to kill and actually believed the force used was necessary to prevent imminent death or great bodily harm to himself, but the belief or the amount of force used was unreasonable. The defendant is guilty of first-degree intentional homicide if he intended to cause the death of another with the intent to kill and did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself. The defendant is guilty of first-degree reckless homicide if the defendant caused the death of another by criminally reckless conduct and the circumstances of the conduct showed utter disregard for human life. You will be asked to consider the privilege of self-defense in deciding whether the elements of first-degree reckless homicide are present. Because the law provides that it is the state's burden to prove all facts necessary to constitute a crime beyond a reasonable doubt, you will not be asked to make a separate finding on whether the defendant acted in self-defense. Instead, you will be asked to determine whether the state has established the necessary facts to justify a finding of guilty for first or second degree intentional homicide or for first degree reckless homicide. If the state does not satisfy you that those facts are established by the evidence, you will be instructed to find the defendant not guilty. The facts necessary to constitute each crime will now be defined for you in greater detail. First degree intentional homicide is defined in the Criminal Code as committed by one who causes the death of another human being with the intent to kill that person or another. In this case, first degree intentional homicide also requires that the defendant did not actually believe the force used was necessary to prevent imminent death or great bodily harm to himself. Before you may find the defendant guilty of first-degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. First, that the defendant caused the death of another. Cause means that his act was a substantial factor in producing the death. Second, that the defendant acted with the intent to kill the other. Third, that the defendant did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself. The third element of the first-degree intentional homicide requires that the defendant did not actually believe the force used was necessary to prevent imminent death or great bodily harm to himself. This requires the state to prove either that the defendant did not actually believe he was in imminent danger of death or great bodily harm, or that the defendant did not actually believe that the force used was necessary to prevent imminent danger of death or great bodily harm to himself. When first-degree intentional homicide is considered, the reasonableness of the defendant's conduct, when first-degree intentional homicide is considered, the reasonableness of the defendant's belief is not an issue. You are to be concerned only with what the defendant actually believed. Whether those beliefs are reasonable is important only if you later consider whether the defendant is guilty of second-degree intentional homicide. If, as to the fourth count, you are satisfied beyond a reasonable doubt that the defendant caused the death of another with the intent to kill, this is Mr. Huber, with the intent to kill, and that the defendant did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself, intentional homicide. If you are not so satisfied, then you must not find the defendant guilty of first-degree intentional homicide and must consider whether the defendant is guilty of second-degree intentional homicide as defined in the Criminal Code, which is a lesser-included offense of the first-degree intentional homicide. There are hierarchies of cases in the law. Typically, first-degree is the highest offense. Then lesser-included are crimes that are of the same nature with many common elements, but some differences. So there's a sequence of verdicts that are going to be submitted to you with respect to this count, and that's what we're going through at this time. So we'll take on now the, but let me advise you should make every reasonable effort to agree unanimously on the charge of intentional homicide of the first degree before considering the offense of second-degree intentional homicide. However, if after a full and complete consideration of the evidence, you conclude that further deliberation would not result in unanimous agreement on the charge of first-degree intentional homicide, you should consider whether the defendant is guilty of second-degree intentional homicide. Before you may find the defendant guilty of intentional homicide of the second degree, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements of this crime were present. First, that the defendant caused the death of another. Second, that he acted with intent to kill another human being. And third, that he did not reasonably believe that he was terminating an unlawful interference with his own person, or did not reasonably believe that the force used was necessary to prevent imminent death or great bodily harm to himself. You have already been instructed on the definitions of causing death and with intent to kill. These same definitions apply to your consideration of second-degree intentional homicide. The third element of second-degree intentional homicide requires that the defendant did not reasonably believe that he was preventing or terminating an unlawful interference with his own person, or did not reasonably believe that the force which was used was necessary to prevent imminent death or great bodily harm to himself. This requires that the state have proved one of the following. First, that a reasonable person in the circumstances of the defendant would not have believed that he was preventing or terminating an unlawful interference with his own person, or that a reasonable person in the circumstances of the defendant would not have believed he was in danger of imminent death or great bodily harm, or that the reasonable person in the circumstances of the defendant would not have believed that the amount of force used was necessary to prevent imminent death or great bodily harm to himself. The reasonableness of the defendant's beliefs must be determined from the standpoint of the defendant at the time of his acts and not from the standpoint of the viewpoint of the jury now. The standard is what a person of ordinary intelligence and prudence would have believed in the position of the defendant under the circumstances existing at the time of the alleged offense. If, as to the fourth count, you are satisfied beyond a reasonable doubt that the defendant caused the death of another human being with intent to kill and did not reasonably believe that he was preventing or terminating an unlawful interference with his own person, or did not reasonably believe that the force used was necessary to prevent imminent death or great bodily harm to himself, you should find the defendant guilty of second-degree intentional homicide. If you are not so satisfied, then you must not find the defendant guilty of second-degree intentional homicide, and you should consider whether the defendant is guilty of first-degree reckless homicide as defined in the criminal code, which is also a lesser included offense of first-degree intentional homicide. Again, you should make every reasonable effort to agree unanimously on the charge of second-degree intentional homicide before considering the offense of first-degree reckless homicide. However, if after a full and complete consideration of the evidence, you conclude that further deliberation would not result in unanimous agreement on the charge of second-degree intentional homicide, you should consider whether the defendant is guilty of first-degree reckless homicide, which is a crime committed by one who recklessly causes the death of another human being under circumstances which show utter disregard for human life. Before the defendant may be found guilty of reckless homicide of the first degree, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. First, that the defendant caused the death of another human being. Cause means that the defendant's act was a substantial factor in producing the death. Second, that the defendant caused the death by criminally reckless conduct, which means the conduct created a risk of death or great bodily harm to another person, and the risk of death or great bodily harm was unreasonable and substantial, and the defendant was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. You should consider the evidence relating to self-defense in deciding whether the defendant's conduct created the unreasonable risk to another. If the defendant was acting lawfully in self-defense, his conduct did not create an unreasonable risk to another. The burden is on the state to establish beyond a reasonable doubt that the defendant did not act lawfully in self-defense. And you must be satisfied beyond a reasonable doubt from all of the evidence in this case that the risk was unreasonable. The third element is that the circumstances of the defendant's conduct showed utter disregard for human life. Again, in determining whether the circumstances of the conduct showed utter disregard for human life, you should consider these factors: what the defendant was doing, why he was doing it, how dangerous the conduct was, the obviousness of the danger, whether the conduct showed any regard for life, and all other facts and circumstances relating to the conduct. You should consider the evidence relating to self-defense in deciding whether the circumstances of the defendant's conduct showed utter disregard for human life. The burden is on the state to prove by evidence which satisfies you beyond a reasonable doubt that the defendant did not act lawfully in self-defense. And you must be satisfied beyond a reasonable doubt from all of the evidence in the case that the circumstances of the defendant's conduct showed utter disregard for human life. Consider also the defendant's conduct after the death Consider also the defendant's conduct after the death to the extent that it helps you decide whether or not the circumstances showed utter disregard for human life at the time that the death occurred. If, as to the fourth count, you are satisfied beyond a reasonable doubt that the defendant caused the death of another human being by criminally reckless conduct, and that the circumstances of the conduct showed utter disregard for human life, and that the defendant's conduct was not privileged under the law of self-defense, then you should find the defendant guilty of reckless homicide of the first degree, as submitted. If you are not so satisfied, then you must find the defendant not guilty on the fourth count. The fifth count of the information charges that at the same time and place, the defendant attempted to cause the death of Gage Grosskreutz with intent to kill that person, a crime of attempted first-degree intentional homicide. With respect to this charge, you must
The judge got a text during the instructions. Is that true?
offense. If you are not satisfied that the defendant is guilty of attempted first-degree intentional homicide, you must consider whether or not he is guilty of attempted second-degree intentional homicide or first-degree reckless endangerment, which are less serious degrees of criminal homicide. The crimes referred to as attempted first and second-degree intentional homicide are different degrees of homicide. Again, that is the taking of the life of a human being. The degree of attempted homicide is defined by law depending on the facts and circumstances of each particular case. While the law separates intentional homicides into 2 degrees, there are certain elements that are common to each. Both attempted first and second-degree intentional homicide require that the defendant have intended to kill another, that he did acts towards the commission of that crime which indicate unequivocally, under all the circumstances, that he had formed that intent and would have caused the death of the other, except for the intervention of another person or some extraneous factor. It will also be important for you to consider the privilege of self-defense in deciding which crime, if any, the defendant has committed. The Criminal Code of Wisconsin provides that a person is privileged to intentionally use force against another under the following circumstances. Force is used for the purpose of preventing or terminating what the person reasonably believes to be an unlawful interference with his own person or by the other, and he uses only that amount of force which he reasonably believes is necessary to prevent or terminate the interference, and the person may not intentionally use force which is intended or likely to cause death unless he reasonably believes that such force is necessary to prevent imminent death or great bodily harm to himself. If you find that the elements of attempted first or second degree intentional homicide have been proved in this case, the effect of the law of self-defense is as follows. The defendant is not guilty of either attempted first or second degree intentional homicide if he reasonably believed that he was preventing or terminating an unlawful interference with his own person, and he reasonably believed the force used was necessary to prevent death or great bodily harm to himself. He is guilty of attempted second-degree intentional homicide if he actually believed the force used was necessary to prevent imminent death or great bodily harm to himself, but the belief or the amount of force used was unreasonable. The defendant is guilty of attempted first-degree intentional homicide if the defendant did not actually believe the force used was necessary to prevent imminent death or great bodily harm to him. Because the law provides that it is the state's burden to prove all the facts necessary to constitute a guilty and a reasonable doubt, you will not be asked to make a separate finding as to whether the defendant acted in self-defense. Instead, you will be asked to determine whether the state has proved the necessary facts to justify a finding of guilty for attempted first or second degree intentional homicide. If the state does not satisfy you that those facts are established by the evidence, you will be instructed to find the defendant not guilty. The elements of each crime will now be defined for you in greater detail.
Whoa.
Before you may find the defendant guilty of attempted first-degree intentional homicide, the state must prove, by evidence which satisfies you beyond a reasonable doubt, that the following 3 elements were present. First, that the defendant intended to kill another. Second, that he did acts which demonstrate unequivocally, under all of the circumstances, that he had formed the intent and would have caused the death of another, except for the intervention of another person or some other extraneous factor. Unequivocally means that no other inference or conclusion can reasonably and fairly be drawn from the defendant's acts under the circumstances. Another person means anyone other than the defendant, include the intended victim. An extraneous factor is something outside the knowledge of the defendant or outside of his control. The third element is that the defendant did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself. The third element of attempted first-degree intentional homicide requires that the defendant did not actually believe the amount of force was necessary to prevent imminent death or great bodily harm to himself. This requires the state to prove either that the defendant did not actually believe that he was in imminent danger of death or great bodily harm, or that the defendant did not actually believe that the amount of force used was necessary to prevent imminent danger of death or great bodily harm to himself. When attempted first-degree intentional homicide is considered, the reasonableness of the defendant's belief is not an issue. You are to be concerned only with what the defendant actually believed. Whether these beliefs are reasonable is important only if you later consider whether the defendant is guilty of attempted second-degree intentional homicide. If, as to the fifth count, you are satisfied beyond a reasonable doubt that the defendant intended to kill another human being, and that his acts demonstrate unequivocally that the defendant intended to kill and would have killed the other except for the intervention of another person or some other extraneous factor, and that he did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself, you should find the defendant guilty of attempted first-degree intentional homicide. If you are not so satisfied, then you must find the defendant not guilty of attempted first-degree intentional homicide, and must consider whether the defendant is guilty of attempted second-degree homicide, intentional, which is a lesser included offense of intentional homicide of the first degree. Again, you should make every reasonable effort to agree unanimously on the charge of attempted first-degree intentional homicide before considering the offense of attempted second-degree intentional homicide. However, if after a full and complete consideration of the evidence, you conclude that further deliberation would not result in a unanimous agreement on the charge of attempted first-degree intentional homicide, you should consider whether the defendant is guilty of attempted second-degree intentional homicide. Before you may find the defendant guilty of second-degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. First, that the defendant intended to kill another. Second, that he did acts which demonstrate unequivocally, under all of the circumstances, that he had formed that intent and would have caused the death of another human being, except for the intervention of another person or some other extraneous factor. The third element is that the defendant did not reasonably believe that he was preventing or terminating an unlawful interference with his own person, or did not reasonably believe that the force used was necessary to prevent imminent death or great bodily harm.
I know that the jurors will have this on paper, but how much do you think anybody's really retaining when it's being read to them like this?
Definitions of intent to kill unequivocally another person and extraneous factor. The same definitions apply to your consideration of attempted second-degree intentional homicide. The third element of attempted second-degree intentional homicide requires that the defendant did not reasonably believe that he was preventing or terminating an unlawful interference with his own person, or did not reasonably believe that the force used was necessary to prevent imminent death or great bodily harm to himself. This requires that the state have proved any one of the following. First, that the reasonable person in the circumstances of the defendant would not have believed that he was preventing or terminating an unlawful interference with his own person, or that a reasonable person in the circumstances of the defendant would not have believed that he was in danger of imminent death or great bodily harm, or that a reasonable person in the circumstances of the defendant would not have believed that the amount of force used was necessary to prevent imminent death or great bodily harm to himself. The reasonableness of the defendant's belief must be determined from the standpoint of the defendant at the time of his acts and not from the viewpoint of the jury now. The standard is what a person of ordinary intelligence and prudence would have believed in the position of the defendant under the circumstances existing at the time of the alleged conduct. If as to the fifth count you are satisfied beyond a reasonable doubt that the defendant intended to kill, and that the defendant's acts demonstrated unequivocally that the defendant intended to kill and would have killed another, except for the intervention of another person or some other extraneous factor, and that the defendant did not reasonably believe that he was preventing or terminating an unlawful interference with his own person, or did not reasonably believe that the force used was necessary to prevent imminent death or great bodily harm to himself, you should find the defendant guilty of attempted second-degree intentional homicide. If you are not so satisfied beyond a reasonable doubt that the defendant is guilty of attempted first or second-degree intentional homicide, You must determine whether the defendant is guilty of the lesser included offense of first-degree recklessly endangering safety, as defined in the criminal code, which is a lesser included offense of attempted first and second degree intentional homicide. First-degree recklessly endangering safety, as defined in the criminal code, is committed by one who recklessly endangers the safety of another human being under circumstances which show utter disregard for human life. Before you may find the defendant guilty of first-degree reckless endangerment, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. First, that the defendant endangered the safety of another human being. Second, that he did so by criminally reckless conduct, which means that his conduct created a risk of death or great bodily harm to another, and that the risk of death or great bodily harm was unreasonable and substantial, and that he was aware that his conduct created the unreasonable and substantial risk.
Just a reminder, guys, free Kyle in all caps gets you banned, and let's go Brandon gets you banned. Just as a reminder, I think we've banned 50 people already today.
Causes permanent, serious permanent disfigurement, or which causes a permanent or protracted loss or impairment of the function of any bodily member or organ or other serious bodily injury. Third, that the circumstances of the defendant's conduct showed utter disregard for human life. In determining whether the circumstances of the conduct showed utter disregard for human life, you should consider these factors: what the defendant was doing, why he was doing it, how dangerous was the conduct, how obvious was the danger, whether the conduct showed any regard for life, and all other facts and circumstances relating to the conduct. If you are satisfied that all three elements of this offense have been proved beyond a reasonable doubt, and that the state has proved beyond a reasonable doubt that the defendant was not acting lawfully in self-defense, then you should find the defendant guilty of reckless endangerment of the first degree as submitted. If you are not so satisfied, then you must find the defendant not guilty. You are not in any event to find the defendant guilty of more than one of any sequence of offenses. So you can return only one verdict per count. You should consider the charged offense first. If you find unanimously that the defendant is guilty of the highest degree of crime, you need not consider lesser included offenses. If you decide unanimously the defendant did not commit the greater crime and was acting lawfully in self-defense,
Is a juror asking a question?
I've got myself into a mid-sentence and I don't like it.
No. Uh-oh. All right.
Warm food around noon.
I do want to say a big thank you to Adam Janas and Anthony Blackman, who just signed up at joinpacman.com and are new members 11 and 12. Today, you can use the code UNCHARGEDPICKLES.
Uncharged pickles?
Also want to say thank you to Kate Davis. Kate made a pledge on Patreon, patreon.com/David Pacman Show. Patreon counts double today, meaning that puts us at 14 already. Really appreciate that and appreciate everybody who's been supporting the streams throughout the trial. This is the 11th weekday in a row with a Rittenhouse stream. And we don't know whether the jury will get the case today. The way it's going, I mean, listen, guys, the judge was talking about the jury will have the case by 4 p.m. our time. That's only 4 hours and 15 minutes from now. They still have a half-hour lunch, the completion of these instructions, and up to 5 hours of closing statements. I don't see this going to the jury today, but we will see. The defense was saying we're actually going to be kind of short in our closing statement. So I don't know. I'm guessing that everybody's standing because the jury is now being excused. There's, I guess, something they want to discuss further. Yeah. So we're going to stand by and look into all of that. We don't know what lunch is scheduled to be today. We just don't know.
By the way, how are the calzones? The food is here. Let's take a break. Lunch is here. Pizza is here. But we have Subway tomorrow. All right, enjoy your lunch. All right, how was the KFC? Very good. Warm food around noon.
Yeah. All right, so now they continue.
The concern that I have, and I worked with the instructions all weekend, and we discussed them by email, and then I'm reading them, and little things are striking me as I read them. But the jurors are never told to actually discuss self-defense except in the context of charged offenses. And what I was about to say to the jury, and decided I better talk to you people beforehand, is if the jury gets into a discussion of a charged offense, any charged offense, but let's use this one as an example, and they decide that the elements are there and he wasn't acting lawfully in self-defense, they're done. They never discuss the lessers. What?
Was or was not acting lawfully in self-defense?
Well, let's say if they decide the elements are there, but he was...
This is going to be all day.
...was not acting lawfully in self-defense, they're done. Then they find him guilty of the charged crime. What if they discuss count 1, or count 5, I should say, and decide that the elements are there, but they all decide it was privileged under the law of self-defense? They're not. Is there anywhere that they're being told? Are they being told you're done? See, under the old law, we did do that. Is that in here? Where is it saying that? Yeah, that's what I used to construct these from scratch. And I would tell the jury, which I was just doing now, that once you have exhausted this, you're done. As opposed to having them needlessly go through these lessers if they've already concluded that. And this is a case where this could happen. I'm not saying it should or would. I'm saying it could, that they would decide, well, yeah, the elements are there, and then they make a decision. And if all of them say on the basis of valid self-defense, then they really should not be considering lesser included. Am I wrong about that?
So if they find perfect self-defense on the charged count,
yeah,
they should be told.
You see what this is? Yeah, I'm sorry.
I mean, I understand where the court's coming from. I guess they could consider the other ones in 30 seconds and just go down to be not guilty, but
they're so complicated as it is.
No, I understand.
I feel terrible about giving this kind of stuff. It's just so. Well, anyway, see what the instruction is telling them, that kind of cryptically. It says it tells them if after a full discussion.
This is one of the most poorly managed cases. It's the most poorly managed case I've ever covered. Let me just speak to that. Hey, thanks to Hannah Lorber for the Patreon pledge. Patreon counts double today, putting us at 16. Also, the coupon code Uncharged Pickles remains available for your privileged use at joinpacman.com.
Uncharged pickles?
All right, we're going to end this poll, and we're going to do a new poll.
It says, however, if after a full and complete consideration of the evidence, you conclude that further deliberation would not result in unanimous agreement on the charge of second-degree intentional homicide, I'm going back to a different count.
A few more bands coming in.
Consider whether the defendant is guilty. So it is telling them. Yeah, I just think it's kind of unclear.
I think it's very unclear. What you're saying is the law. They all agree that the elements are met and there's a privilege. You don't go any further.
Pardon me?
I believe the pattern instruction makes that clear enough. If they can unanimously agree, which includes the privilege, they're done. They don't have to go forward.
Where does it use? It says you should make every reasonable effort to agree unanimously on the charge of second-degree intentional homicide before considering the offense of first-degree reckless homicide. However, if after a full and complete consideration of the evidence, you conclude that further deliberation would not result in unanimous agreement on the charge of second-degree homicide, you should consider whether the defendant is guilty of first-degree reckless homicide. So, I don't think it's not the way a person would speak if he wanted to make things clear. And I'm not saying anyone deliberately is trying to make things unclear.
None of this is.
But
I think one can say that about all 30-some pages of the...
Exactly. That's not a joke.
Don't do that. People will find out our lawyer's secret.
I think it's clear in the instructions, if the court did wish to make it clear, I would just explain if you're unanimous either way on the first count, there's no need to go to the lessers.
Yeah, I think that's a good way to do it. I think I'll tell them that in any sequence, if there are lessers submitted to them, once they've discussed the highest count, if they are unanimous either way, then they're done. Does that make sense? No, Mr. Binger is having a problem with that, and let's see what he is, or what he's...
Mr. Binger.
I don't like the way I said that either.
Aside from any one aspect, this all feels like it's a bogus trial with a conclusion that's foregone, which is going to be not guilty on all the major counts. Like all of this is crazy, but it's details. I think there was never really a shot at guilty on those.
Please proceed, Governor.
How about this? In any count where there are
lesser
multiple
charges
verdicts submitted to you.
Oh.
If at any point in your deliberations you are unanimous either as to both the elements, presence or absence of the elements of the crime, and the presence or absence of the right of self-defense, you need go no further.
The reason I was shaking my head, Your Honor, is because let's take Anthony Huber's counts, for example.
Yeah.
If the jury is unanimous that he is guilty of first-degree intentional homicide, they go no further.
Right.
If they are unanimous that he's not guilty of first-degree intentional homicide, then they are instructed to consider second-degree intentional homicide.
Only if they're not satisfied that it was done in self-defense. If they, for example, if in your example, if they discussed it and said, well, sure, the elements of attempt murder are there, and then they go around the table and they say, well, we all think it's not self-defense, then guilty. If they all say we don't think it's, well, actually, if they all say we don't think it's self-defense, then it's not guilty. And what the jury is being told is if you can't agree unanimously, then consider these lessers. But I don't think it's so clear as it should be.
The problem is the rubric he's setting out means there's no time at which they would really consider the lesser charges.
The court was originally proposing is telling the jury unanimous on the charge count one way or the other, then you go no further.
I like that.
That's not the law.
If you're unanimous on...
So, for example...
if you're unanimous on the legal question, intentional, well, you're right, because it could be an elements issue.
The jury...
Maybe the constructions committee is right, I don't know.
The jury only goes to lesser included if they are either unable to agree on the charge count or if they're unanimous not guilty on the charge count. Then they go to the lesser included. So there is no requirement.
After all this, the judge is lining it up for there to be no way to consider lesser included. But we'll see.
Yeah, if they're unanimous, then they're done. That's what I'm trying to tell them, but I don't know how to say it.
But that's not true, because if they're unanimous on first-degree intentional homicide, what they're concluding at that point is that the defendant, either the elements aren't met, or the defendant actually believed that deadly force was necessary. They would still then have to consider the second-degree intentional because it changes the self-defense into the objective, reasonable one. So they can be unanimous on count one. Let's take Huber, for example. They can be unanimous on the first-degree intentional homicide. They can be unanimous on that, and in the defendant's favor. But they still have to then move to the second element, or to the lesser included.
You might be right.
Perfect self-defense.
Pardon me?
If it's perfect self-defense, it's perfect self-defense for everything.
But they're not told to consider perfect self-defense on first-degree intentional homicide. They're specifically told.
It's fine.
Well, yeah, you're right. He's right.
They're not told to consider that until second-degree intentional homicide. The instructions, Your Honor, are the pattern instructions. I understand your point that if we had to redraft them today from scratch, maybe we could do better. But I'm sure we could. But we need to follow them, and I don't think deviation is appropriate.
I think you're right. And they are certainly correct in what they say. I just think that they're not clear. But maybe they are. I don't know. Now let's see how much damage I've done already by my last paragraph. So can you go back to what the last thing I said to the jury?
Dear God, remind me.
By the way, how are the calzones?
Big thank you to Kyle Dowdy and Patricia Rowan, who just signed up on my website, joinpacman.com. Our new members, 17 and 18. Great people. We love you here at the show and really appreciate your support of our work. You can use the coupon code UnchargedPickles today to get a 69% discount.
Uncharged pickles?
If you're just joining us, there was an interruption to the 36 pages of jury instructions. They're just rereading what he said. There was an interruption to the 36 pages of jury instructions after 30 minutes of debate about them as to how to explain to the jury what are the circumstances of considering the lesser included charges. We still then will have up to 5 hours of closing. So this is almost certainly going to go into tomorrow unless they go long today.
Crime and was acting lawfully in self-defense. You know, if he was acting lawfully in self-defense, the ball game's over.
Oh my God.
Yeah. I think that's correct. Even your suggestion is seductive, Mr. Binger, but see, they're not asked to consider that. That's where I'm having the problem. And they even make reference to it.
The funny thing is, as if these jurors will even have a sensitivity to these nuances.
We don't have, like some states do, they have a question right off the bat. Was the defendant acting lawfully in self-defense? If they answer that yes, we're all done. We've got it interlaced in all these cumbersome instructions. And now, does anyone have any objection to what I've already told the jury? Tell them what?
Just what we said. If you find perfect self-defense, you don't go on to the next count. It's over.
I understand what the term perfect self-defense means, but we haven't told the jury what that means. We're deviating from the standard instructions here, and the words perfect self-defense don't have a meaning to ordinary people, would require further definition from the court, and now we're going much further afield. I also have a problem with the wording of, if you find the defendant is justified in his self-defense, because we've instructed them on his own.
Can you imagine Is it self-defense? Yes. Was the self-defense justified? No. What?
And then we've given the instruction on what the law considers to be objective self-defense is what a reasonable person would think. When the wording that was just read by the Madam Court Reporter doesn't delineate between those two things. And I think, as I said, and I've repeated here several times, I think the more we deviate from these standard instructions, the more confusion it causes. Counsel has asked you to read the self-defense individually on each count. So they're already being told on each count that you are to consider the final thing is the objective self-defense, and that is if you find that, then he's not guilty. And to say across the board that you find self-defense is a defense to everything is not technically true, because there are different self-defense claims as to the different counts. So, for example, he may be justified to self-defense as to Rosenbaum, but not as to Huber. So a blanket statement that says anytime you find justified self-defense, he's not guilty, is not technically true.
Well, so again, it is if you're talking just about an individual count.
But I was saying a blanket.
And I think what I'm going to tell them, in addition to what I've already said, is if they are discussing any count that has multiple possible verdicts.
I think that the standard instruction already spells that out, Your Honor. I agree. If we had to do it from scratch, we could do it better, but I don't think we should deviate any further, because I think it's causing confusion. What the Madam Court Reporter just read back, for example, could be construed as saying anytime with regard to any count you find justified self-defense, he walks on all 5 counts, and that is absolutely not true.
That's not what I intend to tell them at all.
I know you don't intend to tell that, but what's already been said gives that implication. And again, I just worry that the more we deviate from these standard instructions, the more we get into these issues. I think we should stick with what you drafted, which has been sent to the parties. We've all agreed on them, and I am leery of any additional language that hasn't been cleared by the parties and could cause further confusion.
Well, I could say that whenever I've dealt with lesser included, I do give a little talk about how they should address them. And this is a more complicated case than any, frankly, that I can remember. I don't think I've said anything incorrect so far. I don't want to step into something that I haven't already done. I am inclined, though, because I've made a statement about if everything's present, they're done because they found their defendant guilty, and I do think I probably should give the alternative, which is, and I'm not going to use terms like perfect self-defense like he did. I'm going to use the term acted lawfully in self-defense, and they're instructed on that. So I think the correct statement is, if as to any of the cases with multiple submissions, if on any individual count they find in their consideration of the charged offense that the defendant acted lawfully in self-defense, they're done.
The gears of justice are turning.
Any objection?
No.
Okay.
While we're talking about the jury instructions, it was noticed as you read them on page 10, which is count 3, it should be first-degree reckless endangerment, and it's written and you read homicide, which is not a homicide count. So
on page 10,
top page 10 on count, still at the end of count 3, it says you should find the defendant guilty of first-degree.
Yeah, you're right.
Homicide.
You're right. It is in there as homicide. We didn't catch that last night when we talked about him. I sent you 3 drafts.
It's your fault, not his.
But you know what? Should I just leave that alone? They'll know that. I'll change it in the printed copy. Okay, thanks.
Wow.
Anticipating closings before lunch now. It's after 11.
How long are you going to talk in your first sequence?
I'm trying to limit myself to 2 hours.
Are you troubled by taking a break in the middle of your presentation? Well, let's just kind of plan on around noon because the lunch has already been ordered. So, and I'm not going to comment on the lunch.
Let's take a break. Lunch is here.
He's not going to comment on the lunch?
So
we have
let's ask
Subway
the judge to
tomorrow.
come back in, please. So I'll take a break at, why don't you, around, whenever you're comfortable, around noon, just ask for the break. Yeah, well, when he's the commander of the, I don't want to interrupt him at a time he doesn't want to be.
I want to say thank you to Gianfranco Saracino, who just made a pledge via Patreon, and those count double today, which puts us at 20. I have 5 incredible people to thank as well for getting memberships on my website. Nadine Perkins. Thank you, Nadine. Patrick Dillon and Rodney Hammock. Rodney and Patrick have signed up on my website. Corey Resner is a new member. And also thanks to Larry Burns, who have signed up on my website, joinpacman.com. We are at 25 for the day, and we are going to be here through the end of proceedings today. I also have an exciting live stream on my Instagram today at 6 p. East, 3 p. West with a celebrity. I will be announcing it as soon as it's confirmed. I'm standing by. Because they're on the West Coast, they may, a little slow on the trigger there. Maybe.
So, folks, what I was talking about with the cases that you have multiple possible verdicts submitted to you for consideration, when you address the charged crime, if in your discussions you conclude that the elements are present and the defendant was not acting lawfully in self-defense, then you needn't go any further. You can return your verdict of guilt based upon that conclusion. If in your discussions as to any individual count of those with multiple possible verdicts, in your initial discussion, if you decide that the defendant acted lawfully in self-defense, you're done. And you can return a not guilty verdict without considering the lesser offenses. Any question about that?
Oh, God.
It hopefully will become clear. I'm going to give you written instructions because I know this is arduous going through this.
Any confusion helps the defense because they're like, we're not sure, not guilty.
Instructions for your reference in considering these things.
And we resume.
Counts 1 through 5, that's all the counts now, each contain the guilty verdicts of any submitted offense, contain a question based upon the allegation of the information that the defendant committed the crime while using a dangerous weapon. If you find the defendant guilty on any of the counts, you must answer the following question. Did the defendant commit the crime while using a dangerous weapon? Dangerous weapon means any firearm, whether loaded or unloaded. A firearm is a weapon which acts by the force of gunpowder. Before you may answer the question yes, you must be satisfied beyond a reasonable doubt that the defendant committed the crime while using a dangerous weapon. If you are not so satisfied, then the question must be answered no. In reaching your evidence, examine the evidence. In reaching your verdict, examine the evidence with the utmost care and caution. Act with judgment, reason, and prudence. The defendant is not required to prove his innocence. The law presumes every person charged with the commission of a crime to be innocent, and this presumption requires a finding of not guilty, unless in your deliberations you find that it is overcome by evidence which satisfies you beyond a reasonable doubt that the defendant is guilty. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you may return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that the defendant is guilty. If you can reconcile the evidence upon any reasonable hypothesis consistent with the innocence of the defendant, then you must do so and find him not guilty. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given, arising from a fair and rational consideration of the evidence or want of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or hesitate when called upon to act, in the most important affairs of life. A reasonable doubt is not a doubt which is based upon mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt, such as may be used to escape the responsibility of a decision. Examine the evidence and search for the truth, giving the defendant the benefit of every reasonable doubt. Evidence is defined first as the sworn testimony of witnesses, both on direct and cross-examination, regardless of the party who called the witness. Second, any exhibits which have been received, whether or not they accompany you to the jury room. Third, any facts which the lawyers have agreed or stipulated, or which I have directed you to find. Anything that you may have seen or heard outside the courtroom is not evidence. You are to decide the case solely on the evidence offered and received at this trial. You should disregard entirely any question to which I did not permit an answer. Do not guess what the witness's answer might have been, and if the question itself suggested that certain information might be true, ignore the suggestion and do not consider it as evidence. Attorneys for each side have the right and duty to object to what they feel are improper questions asked of witnesses, and to the receipt of other evidence which they believe is not properly admissible. You should not draw any inference or conclusions from the fact that an objection is made. By allowing testimony or other evidence to be received over objection, I did not mean to indicate any opinion as to that evidence. You jurors are the sole judges of the believability of the witnesses and of the weight of the evidence. At the beginning of the trial, I described the charges against the defendant, counts 6 and 7, which respectively charged possession of a firearm by a minor and curfew violation, have been disposed of and are no longer part of this case. The other counts remain. Do not guess about or concern yourselves with the reasons for these dispositions. It must not affect your consideration of the charges that remain. Do not consider evidence that related only to the counts which have been disposed of. During the trial, I have ordered certain testimony stricken, and you must disregard all such stricken testimony. Exhibits become evidence only when received by the court. An exhibit which was marked for identification but not received is not evidence. Is not evidence. An exhibit received is evidence whether or not it accompanies you to the jury room. Remarks of the lawyers are not evidence, and if the remarks suggest certain facts not in evidence, disregard the suggestion. You should consider carefully the closing arguments of the attorneys, but their arguments, opinions, and conclusions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict upon the evidence under the instructions given you by the court. I have taken judicial notice of certain facts, and you are directed to accept them as true. The state has introduced evidence of statements which it claims were made by the defendant. It is for you to determine how much weight, if any, to give to any statement. In evaluating each statement, you must consider three things: whether the statement was actually made by the defendant. Only so much of a statement as was actually made by a person may be considered in evidence. Whether the statement was accurately restated here at the trial, whether the statement or any part of it ought to be believed. You should consider the facts and circumstances surrounding the making of each statement, along with all other evidence, in determining how much weight, if any, the statement deserves. The weight of the evidence does not depend on the number of witnesses on each side. You may find that the testimony of one witness is entitled to greater weight than that of another witness, and you may give it such weight in considering your verdicts. In weighing the evidence, you may take into account matters of your common knowledge and your observations and experiences in the affairs of life. Ordinarily, witnesses may testify only about facts. However, witnesses with specialized knowledge in particular fields may give opinions in those fields. In determining the weight that you give to these opinions, you should consider the qualifications and credibility of the expert, the facts upon which the opinions are based, and the reasons given for the opinion. Opinion evidence was received to help you reach a conclusion. However, you are not bound by any witness's opinion. It is your duty as jurists to scrutinize and weigh the testimony of the witnesses and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is, the believability of the witnesses, and of the weight to be given to their testimony. In determining the credibility of each witness and the weight you give to the testimony of each, you should consider these factors: whether the witness is interested or disinterested in the outcome of this trial, conduct, appearance, and demeanor on the witness stand, the clarity or lack of clarity of the witness's recollections, the opportunity which the witness had to know and observe the matters and things about which testimony was given, the reasonableness of the witness's testimony, the witness's apparent intelligence, bias or prejudice, if any has been shown, possible motives to falsify, and all other facts and circumstances during the trial which tend either to support or to discredit the testimony, and then give the testimony of each witness the weight you believe it is entitled to receive. The defendant has testified in this case, and you should not discredit his testimony just because he is charged with a crime. Use the same factors to determine the credibility and weight of the defendant's testimony that you use to evaluate the testimony of other witnesses. There is no magical way for you to evaluate the testimony. Instead, you should use your common sense and your experience. In your everyday lives, you determine for yourselves the reliability of statements made to you by others, and you should do the same thing here. Evidence has been received that 2 of the witnesses in this trial have previously been convicted of crimes. This evidence was received solely because it bears upon their character for truthfulness. It must not be used for any other purpose. We're going to hear the closing. You know what? Does anybody want a break, even just a short one, or not? You want to go right into your discussion? Anybody need a break? Okay. We're going to hear the closing arguments of the attorneys now.
Here we go.
We follow the classical debate format in the court. That is that the proponent of a proposition is entitled to give the first and the last argument. So Mr. Binger will address you first on behalf of the state, then Mr. Richards for the defense, and then after his remarks, one of the attorneys for the state will be addressing you on behalf of the state in rebuttal, limited to rebuttal of things stated by Mr. Richards during his presentation. The break, obviously, I'm not going to make you sit there for 5 hours. Unless you want to. So we'll break. I asked Mr. Binger while you were out of the room if he was comfortable with breaking his argument.
Okay, the audio has become unsynced. We're just going to do a quick refresh. Could be the court.
I asked Mr. Binger while you were out of the room if he was comfortable with breaking his argument in parts, and he indicated he was. So at a time he thinks is appropriate, around noon, we'll take our lunch break.
Warm food around noon.
And then pick up this afternoon. And then after all of the arguments have been presented, I'll give you about 3 or 4 more minutes of instruction. And then we'll do our striking with the tumbler over there. And it'll be yours. So let me ask you.
Do you have the pointer? Sister's pointer.
Which one do you want?
The sister's pointer.
The sister's pointer? Okay.
Thanks to Sander DeGroot for signing up on my website, joinpacman.com. Thanks, Sander.
We'll take a vote right now. Supposing the case arguments are finished at 4:30, 5 o'clock. And we'll be working well to get there. How many would like to begin their deliberations tonight and stay until a later hour? Or how many would like to come back and start fresh in the morning? And the cutoff point would be, say we got finished by 4 and I give you the case.
I don't think they're going to be done at 4.
The latest I would let you go if you didn't want to stay late would probably be about 5 o'clock. So I don't know how much you'd get done, but you'd have the option to get started this today, or we just start fresh in the morning if we finish up any time after 3:30 or 4 o'clock. So how many would want to continue on today? 1, 2, 3, 4, 5, 6, 7, 8. 8 out of, what do we got, 18? How many would rather come back fresh tomorrow?
All right, how was the KFC?
Knowing that
Very good,
some
huh?
weren't coming back. Okay, and of course, as always, I'll make the final decision, but I certainly will try to follow your wishes. So, okay, with that, Mr. Binger, it's yours.
Thank you, Judge. Good morning, ladies and gentlemen. I want to assure you that everything that the judge just read to you, you'll get a copy of, so you'll have a chance to look it over yourself. You don't have to memorize everything he just told you. I think it's no surprise that this is a case that there's a lot of noise and a lot of static surrounding it. So what I'd like to do at the beginning is crystallize it in a nutshell for you and keep it as simple as possible. This is a case in which a 17-year-old teenager killed 2 unarmed men and severely wounded a third person with an AR-15 that did not belong to him. This isn't a situation where he was protecting his home or his family. He killed people after traveling here from Antioch, Illinois, and staying out after a citywide curfew.
Your Honor, I'm going to object.
I knew it.
There's no curfew charge anymore. There's no gun charge.
I knew that was coming.
Although he claimed
there's no charge, but and there has been some discussion about the lawfulness of the curfew, not in this case, but elsewhere. So there had been a curfew announced.
Wow.
That does not mean that it was technically lawfully a legal curfew, but there had been.
Wow.
So I'll leave it at that.
Can you imagine?
Curfew that all the rest of us here in Kenosha were aware of, and I think most reasonable people, obeyed. Although the defendant claimed to be protecting a business that he wasn't familiar with, the actual killings in this case had nothing to do with that. And he also spent the entire evening lying about the fact that he was an EMT. None of the things that I just told you are in doubt in this case. So when we think about the defendant, I'd like you to consider, as you think about this case, what his true motivations were. Was this a situation where he sincerely cared about Car Source, even though he'd never heard of it, never bought anything there, never worked there, and not even its owners were out there that night protecting it? Was he genuinely interested in helping people? He ran around with an AR-15 all night and lied about being an EMT. Does that suggest to you that he genuinely is there to help? He's not there for the same purpose as the protesters. So why was he there that night? When you think about these things, I think there are some things that we can all agree on. In America, it's hard these days. People are polarized and there's a lot of political issues back and forth. And the judge has made it clear this case is not about politics. There is common ground here. We have all agreed, and I asked you this 2 weeks ago today. Raise your hand if you agree life is more important than property. And all of you raised your hand. We also agree that no one person's life is more valuable than another. You don't get to kill someone simply because they're a drug dealer. You don't weigh a pastor's life over a teacher's life. You don't weigh a police officer's life over an engineer's life. All life is sacred. I think we can also agree that we shouldn't have 17-year-olds running around our streets with AR-15s, because this is exactly what happens. And finally, I want you to keep in mind that we've all read stories and heard about heroes that step in to stop an active shooter or to give their life to save others. In fact, many people in Wisconsin went out and got carrying concealed weapon permits just so that they could be there in case there was an active shooter and wanting to stop them. So when you consider this case, look for the truth. So many people look at this case and they see what they want to see. They have a preconceived notion and they tailor the facts to fit whatever they believe. And you all agreed to keep an open mind. You all told us you didn't have any of those preconceived notions. Now you've heard the evidence, and it's time to search for the truth. So consider, for example, whether or not it's heroic or honorable to provoke and shoot unarmed people. Consider whether it makes someone a hero when they lie about being an EMT.
Wow.
I think all of us are familiar with someone who does the sorts of things that the defendant has done. They enjoy the thrill of going around and telling people what to do without the courage or the honor to back it up, and without the legal authority to do so. And when you think about the defendant's behavior in this case, contrast it with Anthony Huber, a man who was there because he knew Jacob Blake, who carried his skateboard everywhere and who rushed towards danger to save other people's lives. So when I talk to you here in my closing argument, I'm going to focus first on the murders that the defendant committed. Second, I'm going to address some background issues, give you some context, and talk about some of the things that I don't think are relevant to this case. And finally, I'm going to tie it all into the jury instructions that the judge just gave you.
Well done so far.
As prosecutors in this case, my colleague Jim Krause and I have tried to present you with all of the relevant evidence that we think you should consider in this case. And I told one of you in jury selection that at the end of this, you would be the expert. You would have all the information. You would be the one who would know all about this case and make that decision. And that's what we've tried to do. So let's go to August 25th, 2020. The defendant came from outside our community, carrying a gun that wasn't his, because he expected and anticipated violence that night. And he pretended to guard what turned out to be an empty building owned by people he'd never even met, while fraudulently claiming all night long to be an EMT.
Elements of medical.
There were a lot of people out that night. Some people stayed home protecting their homes and their families. Others went to their businesses, boarded them up, and protected them. And a lot of those people had weapons. A lot of them had guns. There were other people who came along to protect Car Source or Ultimate Gas or other businesses. And many of them were armed with AR-15s, just like the defendant. In fact, you're going to see a video, and you've already seen it, of a clash between people with AR-15s at Ultimate Gas and other folks that are, I guess, protesters. And there's people getting in people's faces, there's yelling, there's shouting, there's even shoving. And yet, in this entire sequence of events, from the shooting of Jacob Blake on Sunday, August 23rd, 2020, all the way after that, everything this community went through, the only person who shot and killed anyone was the defendant. Yes, there was property damage. No one's here to defend that. No one's here to tell you it's okay to commit arson or looting. No one's here to tell you it's okay to be rioters. I'm not defending any of that. You know, because you've been told in the testimony, I'm prosecuting Joseph Ziminski for arson. That's not okay. But what you don't get to do is kill someone on the street for committing arson. So let's keep that in mind when we're talking about the people involved in this case. So let's begin with the provocation and the murder of Joseph Rosenbaum, because it's all captured on video. As the defendant and Mr. Rosenbaum arrive at the 63rd Street Car Source, Mr. Rosenbaum is ahead of the defendant. And as you see in the FBI video, when Mr. Rosenbaum starts to run, the defendant starts to run as well at the same time, as if he's pursuing him. Mr. Rosenbaum could not have possibly have known the defendant is behind him. There's no indication in this record that he knew the defendant was there. It's not an ambush. It's not a situation where he goes there and lays in wait for the defendant. The defendant arrives at that location, and you hear him yell, "Friendly, friendly, friendly," because he's aware of the fact that the people that he's about to confront are hostile to him. And I'm going to show you in a moment the video in which the first thing he does when he arrives at that location is drops the fire extinguisher that he's holding in his left hand so he can raise the gun with his right and left hands and point it. This is when you hear someone, I think the testimony is Rosenbaum, it's not clear to me, but either way, yell, "Gun, gun, gun." And then Mr. Rosenbaum charges around to try and stop the defendant from pointing his gun or shooting anyone. So let's take a look at some of that video.
Very childish people getting themselves banned in the chat.
This is Exhibit 73, the full drone video. And as we've pointed out to you before, and Jim will point out to you here in a second on the screen, when the defendant originally arrives at that scene, the first thing you see him do is drop the fire extinguisher and point his weapon at people. And then the chase occurs right after that. And you're going to see that entire sequence of events here on the full drone video. The defendant turns as he's being pursued and points the gun at Mr. Rosenbaum. And then as he enters the area between the parked cars, he slows and turns, and before Mr. Rosenbaum can even come close, he fires at him, shooting and knocking him to the ground. Now I'm going to show you the slowed down and zoomed in video of the defendant when he first gets there. And Mr. Krause is going to help me by directing your attention on the larger screen here to exactly where you will see the defendant. I'm going to replay it a few times so you can see quite clearly that the defendant sets the fire extinguisher on the ground with his left hand and then brings his left hand over to the gun and raises it and points.
Back in 5.
Guys, check the gun. Make sure it's empty. Under Wisconsin law, you're not allowed to run around and point your gun at people. This is the provocation. This is what starts this incident. The defendant rushes in and immediately points the gun. And as you'll see in a little bit, Mr. Rosenbaum doesn't take kindly to people pointing guns. I don't think anyone does. That's not unusual. No one wants to have the gun pointed at them, and no one wants to watch anyone else do this to someone else. We have the gun. It is in evidence as exhibit number 28. I'm having the detectives check it to make sure that it is safe. The defendant comes running in and drops the fire extinguisher on the ground like this. And then raises his left hand to the gun and points. This is what we see in the video. Him putting the fire extinguisher on the ground and then raising the gun.
Your Honor, I'm going to object. He's facing the wrong direction.
That's an argument.
Okay.
I'd like to actually have, well, I'll leave it alone.
So what you see in that video is his left arm reaching for the gun, holding it up. You can see it again on the video here. His left arm reaching up towards the gun. That is what provokes this entire incident. And one of the things to keep in mind is that when the defendant provokes the incident, he loses the right to self-defense. You cannot claim self-defense against a danger you create. That's critical right here. If you're the one who is threatening others, you lose the right to claim self-defense. Then we have the chase that occurs after that. And we have taken that drone video and we have slowed down portions of that chase for you. So what we have right here on the screen, this is Exhibit 84, and this is the middle portion of that incident. And you can see Mr. Rosenbaum chasing after the defendant, throwing that plastic bag, and then the defendant turns and points the gun back at Mr. Rosenbaum. And this is the moment in time when Mr. Rosenbaum essentially does sort of a little hop with both of his hands in the air. And the defendant has testified. He saw at that moment that there was nothing in the defendant's hand, or in Mr. Rosenbaum's hands. He was unarmed. There's the defendant turning and pointing the gun. Mr. Rosenbaum leaps, his hands out to the air, and then watch here at the end. This is where the shooting occurs. Mr. Rosenbaum is not even within arm's reach when the first shot occurs. I'll play that again. The defendant is pointing the gun at Mr. Rosenbaum. Mr. Rosenbaum raises his arms off to the side. The defendant approaches these cars and slows down, and then turns and shoots Mr. Rosenbaum. Finally, I'm going to play you Exhibit 86. This shows you the final part of that, zoomed in and slowed down. Here's the defendant running in between those parked cars, slowing down, and you can see just how close, or rather how far away, Mr. Rosenbaum was when the defendant shot him. You can see from this video that Mr. Rosenbaum is not even within arm's reach of the defendant when the first shot goes off. The defendant fires 4 shots in quick succession. And I'll come back to this in a moment, but you'll note during this entire sequence, it's the defendant who chooses where to go. He's the one who decides to run where he runs. And he slows down right as he gets to these parked cars. That's what allows Rosenbaum to get closer. We've seen this on the aerial footage from the FBI, and I want you to see that perspective as well. This is Exhibit 25. This is the annotated aerial footage. You see the defendant approach, running in the same direction as Mr. Rosenbaum. This is where the pointing occurs in the direction of the Zeminskis. You can see Joshua Zeminski's right there on the screen. I'm going to put the cursor over where the Zeminskis are. They're right in there. The defendant is pointing his gun right here, and he's pointing it in the direction of the Zeminskis, because they're standing next to that car. And then the chase occurs. Now, what's interesting to me is watch when the crowd starts to run. The crowd's already starting to run here even before the defendant has fired a shot. That's likely because they heard the first shot from Joshua Zeminski, and the crowd starts to run away. The defendant has testified that that shot from Mr. Zeminski had nothing to do with his decision to kill Joseph Rosenbaum. And I'll come back to that in a second. Finally, I'm going to show you this incident from the perspective of Drew Hernandez, because he is behind all of this, and then he comes upon Mr. Rosenbaum's body. Is that audio playing? Why is the audio not playing? Is it coming? I'm not sure why you're not hearing any audio on that. Is Brian around? He's not. All right. Can you text Brian, please? At any rate, for this purpose, I'm sorry? At this point, the defendant has shot and killed Joseph Rosenbaum, and Mr. Rosenbaum is laying face down. That's where he falls. Richie McGinnis actually rolls him over after trying to stem the bleeding here. You can see in the foreground that plastic bag that Mr. Rosenbaum threw on the ground. I don't think there's any dispute. There was nothing harmful in that bag. It was a clear bag containing some clear items.
Objection. There is a dispute what's in that bag.
Then you can make that dispute in your argument.
It's argument, and you'll be allowed to respond.
You can see in this video the crowd is attempting to save Mr. Rosenbaum's life. So, we have shown you the defendant murdering Joseph Rosenbaum from 3 different angles. The drone footage, Drew Hernandez, and also the FBI video. The defendant admitted that during this entire incident, he knew that Joseph Rosenbaum was unarmed. I'm going to come back to this in a little while, but there's this alleged threat that Mr. Rosenbaum made earlier in the evening to kill the defendant. I will debunk that. That did not happen. It is the one fact in this case the defendant wants you to believe that there's no video of. And in fact, I have the video of the entire incident. I've played it for you and I'll show it to you again. There's no threat. There's also no evidence that Mr. Rosenbaum, he never said, I'm going to take your gun. He never said, I want your gun. There's no indication of that. Dr. Kelly has testified that the first shot that the defendant fired at Joseph Rosenbaum hit the victim in the right pelvis, fracturing it. Mr. Rosenbaum was incapacitated at that point. He is, whatever threat he might have posed, it's over. There is no further threat. He is falling to the ground, and the defendant doesn't stop after that first shot. He tracks Mr. Rosenbaum's body all the way down, firing 3 more shots. A second shot, which goes through Mr. Rosenbaum's hand, and then a third and fourth shot, one that grazes the right scalp and one that goes right into Mr. Rosenbaum's back. And that is the kill shot. That is the one that took Mr. Rosenbaum's life. There is no evidence that Mr. Rosenbaum was reaching for the defendant's gun. And after that first shot, there's no way Mr. Rosenbaum could have taken that gun even if he wanted to. He is already falling to the ground. He is helpless. He is vulnerable. And as I said, the kill shot is the one to the back. This is that wound. Dr. Kelly testified that the angle of this shot was from the left shoulder towards the center of the back, and the bullet continued on down towards the right lower back area, tearing through bodily organs and killing Mr. Rosenbaum. Here's a picture of the wound to the hand. There's been a lot of testimony about this wound. This is one in which the evidence suggests that Mr. Rosenbaum's hand was most likely turned in this position, palms outward with his thumb to the ground, when the bullet goes through the area in between his middle finger and his ring finger and penetrates the lower knuckle of the middle finger and the index finger before exiting. Dr. Kelly testified there's soot in that area, suggesting that the hand was close to the end of the defendant's barrel of the AR-15 at the time of that shot. The defense wants you to believe it's there because Mr. Rosenbaum is deliberately reaching for the gun. Well, that doesn't make any sense. First of all, this occurs after Mr. Rosenbaum has been shot in the hip and has got a fractured pelvis at that point. He is falling. He is not able to walk. He's probably not even able to control much of his movements at this point. When you're reaching for that gun, this is not the way you're going to do it. This is not going to be effective. I submit to you, ladies and gentlemen, to the extent Mr. Rosenbaum's hand ever got close to the end of the defendant's gun, it was completely inadvertent, not at all intentional.
For people worried about the graphic footage, I was actually talking to our YouTube rep about everything that's going on. Everything's fine. Everybody relax.
With any of this. There's been some focus on that because I think the defense was hoping they could work this into their self-defense claim and make an argument that that first shot by Joshua Zeminski somehow made the defendant fear for his life. Unfortunately, The defendant wasn't on board with that, because in his testimony, he told you that that shot had nothing to do with his thought process. It didn't affect him in any way. He said he didn't think the shot came from Joseph Rosenbaum. He knew Joseph Rosenbaum was unarmed, and he admitted to me, you can't kill Joseph Rosenbaum for something Joshua Ziminski did. So let's just carve Joshua Ziminski out of this case. I'll deal with him on his arson trial in January, but until then, it doesn't factor into any of the decisions the defendant made. And in fact, as you see on the FBI video, the Ziminskis continue walking straight on down the sidewalk. They don't pursue the defendant. They don't threaten the defendant in any way. Now, the defense wants you to think Joseph Rosenbaum was there to attack the defendant. We'll never know what Joseph Rosenbaum was thinking because the defendant killed him. So we're just guessing. But let's assume for a minute, yeah, Joseph Rosenbaum is chasing after the defendant because he wants to do some physical harm to him. He's an unarmed man. This is a bar fight. This is a fist fight. This is a fight that maybe many of you have been involved in. Two people, hand to hand, we're throwing punches, we're pushing, we're shoving, we're whatever. But what you don't do is you don't bring a gun to a fist fight. What the defendant wants you to believe is that because he's the one who brought the gun, he gets to kill. So I want you to contrast this, two different scenarios. One scenario where there's two guys who are throwing punches at one another like a bar fight. I think we'd all agree you can't kill someone. You can't punch the guy, knock him to the ground, and then get on him and strangle the life out of him. That's murder. So what's the difference here? The only difference is the defendant brought a gun.
Point made by one of our viewers last week, remember.
That's why he's got to come up with this cockamamie theory that Joseph Rosenbaum was not only going to take the gun, but take it and then turn it on the defendant. And the defendant actually told you that he thought Joseph Rosenbaum was going to take that gun and not only kill him, but kill other people, which is really ironic considering the defendant is the one who killed people in this case and the only one. But putting that aside,
cockamamie,
they have to convince you that Joseph Rosenbaum was going to take that gun and use it on the defendant because they know you can't claim self-defense against an unarmed man like this. You lose the right to self-defense when you're the one who brought the gun, when you're the one creating the danger, when you're the one provoking other people.
This is very solid so far.
The defendant fired 4 shots at Joseph Rosenbaum and caused 5 wounds total. The first shot fractured Joseph Rosenbaum's pelvis. This causes him to be helpless. He is falling face first to the ground and he is vulnerable. The second shot went through his left hand, probably ricocheted off the ground and hit his lower left thigh. It's a flesh wound. I'm sure it hurt, but probably not all that serious. The third and fourth shots are as Mr. Rosenbaum has fallen almost completely to the ground. He's parallel to the ground.
Notice the judge is eating and looking at papers.
The defendant fires a round into his upper back, which is the kill shot, and another round which grazes his right scalp. At this point, as you saw in that video, a crowd rushes to that body to try and save Joseph Rosenbaum. They're trying to put clothing on the wound to stop the bleeding. They're going to take him across the street to a hospital. KMH, Frederick South, is literally right across the street. And this crowd, except for the defendant, are all focused on trying to save this person's life. A person, by the way, they probably had never even met before. Because that's what most people do. Richie McGinnis testified. I rode with Rosenbaum in the back of that SUV. I told him we'd have a beer together when this was all done. Mr. Rosenbaum was unable to respond. The defendant decided to pull the trigger on his AR-15 4 times. That was his decision. And he is responsible for every bullet that comes out of that gun. He doesn't get a pass by pulling the trigger fast. He could have chosen to stop after the first shot, after the second shot, after the third shot. and assessed whether or not there was still a need to keep firing. But he went 4 times in 0.76 seconds. The defense has made a big point of this, how fast he fired, as if that somehow excuses him. Exactly the opposite, ladies and gentlemen. He controls how quickly he pulls the trigger. He is in control of that decision-making process. No one else made him do that. And this is indicative of someone who doesn't care about the consequences, doesn't care to stop and figure out, am I good? Do I need to stop? Or I'm just going to keep on going. And as I said, he tracks the body all the way to the ground with those 2nd, 3rd, and 4th shots. The only way that you could possibly justify the murder of Joseph Rosenbaum is if you believe that Joseph Rosenbaum was actually reaching for the defendant's gun, and that a reasonable person in the defendant's position with that AR-15 strapped tightly to his chest would think that Joseph Rosenbaum was even capable of taking that gun away as he's falling to the ground with a fractured right pelvis. And then, not only all that, you'd also have to believe that Joseph Rosenbaum was going to turn that gun around and use it to kill the defendant. You have to believe all of those things to justify the murder of Joseph Rosenbaum. That's why the defense is trying so desperately hard to convince you that Joseph Rosenbaum threatened to kill the defendant, which never happened. That's why they're trying so desperately hard to convince you that Joseph Rosenbaum was reaching for that gun. Because if he's not reaching for that gun, and he's not going to use it to kill the defendant, it is not justified. There is no valid self-defense claim. One of the things the judge has instructed you is that when the defendant provokes this situation, he has to exhaust all reasonable means to avoid killing someone. Did he? He didn't have to shoot. He's the one who chose where to run. He chose to run in between those parked cars. He slows down as he gets there. The crowd's already running away. You know, the defense wants to make a point. There's a whole bunch of people over there who are doing stuff to cars, and the defendant had no escape route. The crowd's actually already running away at this point. They've heard the first gunshot from Joshua Zeminski, and they're already starting to scatter. But if you look on the video, there's a huge open space in that lot where the defendant could have circled back around, and he actually does circle back around after killing Rosenbaum, where he could have gotten away. He has to exhaust all reasonable means of escape before killing Mr. Rosenbaum. Your Honor, I do have some more video I want to play. I'm having a little bit of technical problems that I'd like to work on, so I think this would be a good time to pause, if that's okay. Okay, thank you.
All right, folks, please don't talk about the case during the break. Read, watch, or listen to any account. And we will begin again at, is 1:45 too soon? Did you say 12:45 or 1:45? Oh, well, I thought we'd have a leisurely. No, how about 12:45? Is that a better idea? Let's do that.
2-hour lunch.
Talk about the case.
2-hour lunch suggested there. Okay, judge confused about, I guess, timing and time zones and stuff like that. So they will go to the food, folks.
Warm food around noon, but we have Subway tomorrow. Pizza is here. Let's take a break. Lunch is here. The food is here. By the way, how are the calzones? All right, how was the KFC? Very good, huh? All right, enjoy your lunch.
Okay, so they are heading to lunch at this point in time, and we don't know exactly what they're going to be having. I want to say thank you to Dana Trujillo and Lesko. You almost got me there. Someone named Lesko, who signed up on our website, joinpacman.com, new members 27 and 28. We are in the 11th straight day of streaming the Kyle Rittenhouse trial. We are about maybe a quarter of the way through the prosecution's closing statement. Then there will be a defense closing statement. Let's see, they're going to be discussing a few other matters. And then the prosecution will get a rebuttal. This is a big, big deal.
Right, when we get to the point of reducing the number to 12, we have to decide what to do with the other 6. And the alternatives would be to just let them go about their regular business and tell them we might call them if we need them. Or we can keep them here where they can sit and watch daytime TV. I don't know.
Can you imagine?
There are limited channels they can watch.
What a nightmare. I'd be punching myself in the face.
And of course, they will not be permitted to talk about the case. So, any preferences?
My preference is to keep them here.
Yes. Okay, we'll do that then, and we'll have to find some way to entertain them. That makes sure it doesn't involve some of the channels that are available on the television. Okay.
He doesn't want the jurors watching CNN, basically. All right, so there it is. And they're going to be taking a break now, and then we'll be returning. I can't tell you how much I appreciate people who have been supporting these streams. They are very long days. We're also producing the daily podcast in addition to doing the streams, and we've got a live stream coming up later today that I think many of you are going to enjoy on my Instagram with a celebrity coming to the David Pakman Show, and so many really great things. Sign up at joinpakman.com, please. And you can use, as long as the trial is going on, you can use the coupon code Uncharged Pickles.
Uncharged Pickles?
Spelling is above my head. It is all one word, no space, of course. And if you make a pledge on Patreon, it counts double. Pat Rowan just made a pledge at patreon.com/David Pakman Show. And it indeed puts us at 30. Folks, the mustache dies today unless we get to 50, and we will open phone lines at 100, and it is all extraordinary. So I'm going to take my lunch break as well. I do have hot food coming.
Warm food around noon.
Oh, no, wait, before I do that, let me just go over some of the mimetic elements that I was not able to show you guys. So let's see, just a couple cool things that people in the audience made. Here is Lobamna. Okay, check this one out.
Obama.
Okay, so we got that one. We have a new song called Obama. It's very good. Very, very good. This is from Jethro Bradley. Check this out. Anthemic, I would say.
God bless the United States. God bless.
Obama.
You say Obama, I say Obama. You say your mama, I say your mamna. You say banana, I say banana. You say David Pakman, I say David Pakman.
That is being used by some, but it's...
Obama.
I did miss it. I should have mentioned it. I agree.
You say Obama, I say Obama. When Obama killed Osama, I think you mean Osama. When I smoke a blunt, it's always marijuana. The dude from Tibet, the Dalai Lama.
Yeah. Okay. Okay, so we got that, and then also another new submission from our viewers. This is a very special, whoa, this is Lilu featuring Diamond and Silk and Deepak, that's me. It's called Bag of Mangoes. This may arguably be even better. Mangoes?
My bag of mangoes. I love
I love mangoes too.
99 cents. Okay. Now that we are up under Biden's regime, my bag of mangoes now costs $11.99.
That seems like a pretty good deal. A bag of mangoes? Aren't mangoes like $3 each? I want what, $8 or $11. That sounds good.
The American people will lie. And highway robbery is what you're doing. Bring my mangoes back down. My bag of mangoes. My bag of mangoes.
Mangoes?
My bag of mangoes. Bring my mangoes back down. Raise the price of food. Don't raise the price of food.
The Wisconsin crowd identified with the mangoes.
Unfortunately affected the American people. Those who want me to be healthy, healthy. Those who want me to
Oh, man.
It's highway robbery is what you're doing. Don't raise the price of fruit. Don't raise the price of fruit. Don't raise the price of fruit. Don't raise the price of
Mangoes? Wow, an extremely powerful message about mangoes. All right, guys, we are in a lunch break. Then the prosecution's closing argument will continue. Thanks to Cheryl Belcher for making a Patreon pledge. Those count double, puts us at 32. I will thank everybody, every last patriotic American and world resident who signs up on my website after the lunch break. And it's all happening. Keep it here. All right, everybody. We are moments away from the resumption of the Kyle Rittenhouse trial. We are now in the last day, probably, or maybe the second to last day, in the sense that we're in the middle of the prosecution's closing argument. They have up to 2.5 hours total, including a rebuttal. Then the defense gets to go up to 2.5 hours. Then the prosecution will rebut. So there's a question as to whether they're going to be done today or not. And if they are, there's a question as to whether they will begin to deliberate today or not. So that's what's going on. And momentarily, they're going to resume. They are getting back from lunch.
Warm food around noon.
Yep. So I just had a pear, and I have to tell you, one of the best pears I've had. I used to really struggle with pears to know when are they ripe. And I would either cut into it too early. You get that with a Bartlett, you get that unsatisfying. You know when it's not ripe enough. When you cut into it, disappointing, or it's too late and it's got all these brown spots inside. But now I'm definitely doing much, much better as far as that goes. And I found a system that works for me to figure out when is the pear ready. So Bartlett is probably my favorite, followed by Bosque, and then lastly D'Anjou, as some people pronounce it. Am I still growing tomatoes? No, it's essentially winter. So, no. What else is going on? I guess that's sort of it as far as the case goes. Let's get to some voicemails and super chats about the case as we get set back up here to get going again. Let's see. Of course, Whitney is checking in.
So another noteworthy thing that maybe judges don't recognize or, have not observed is that the military has options to where you can have children in the military.
Of course. Let's see what else we've got here. I think this is Troy York.
David Packman, Vincent James of the Red Elephant just eviscerated Kyle Kalinske.
I never know. Troy is constantly calling about things other people on the left have said. Oh, sorry. I've got to ban a couple people on YouTube. I apologize. Troy York constantly calls in about things other people have said and criticizes me over them, or things people I haven't heard of have either said about me or others. In this case, he said something James of oregano. What was that? Let's listen again. Hold on. Let's see. This is so obscure.
Vincent James of the Red Elephant just eviscerated.
Vincent James of Bread Elephants? Is that what he said? Anyway, let's see what this is about.
Kyle Kalinske in a recent video of his.
Troy, I don't care what Bread Elephants say about Kyle Kalinske. I don't watch any clips of any shows like mine, so I don't know what Kyle's doing, and I don't know what Vincent James is. It's like, give me a break, guys. Let's see what else we got.
Jingle bells, jingle.
Nope, we're moving off of that. Let's see what else we've got. Well, Whitney called back in.
I don't see Trump being a successful dictator in this country.
Let's hope not. I think this is another Troy York.
Hello, David Packman. This is in reference maybe to one of your programs a week ago where you were talking about Kyle Rittenhouse and why he was over there.
All right. I just can't take the Troy. It's either he's coughing uncontrollably, he doesn't remember what he was going to say. It's just really, really bad. All right, let's try super chats instead because we're failing pretty hard over on voicemails. Pappy says, I'm tired. Here's $5. Well, I appreciate that. Sean says, I hope the people understand if Rittenhouse is found innocent, remember, it's not innocent, it's not guilty. This sets the case law. We're going to have more teens running around playing Call of Duty. Yeah, I do worry about the impact. I mean, this guy's going to be made a hero. I already recorded today's podcast, and we actually addressed this heroism element on the podcast. Let's see. Will I cover the riots after the verdict? I mean, listen, if there are riots, I will cover them. I am going to admonish you, though, please, if there is an announcement that the verdict has been reached, usually there's 45 to 60 minutes before they read it. Please start emailing me info@davidpakman.com. I don't want to miss it so that I can actually get set up and stream. And then as far as phone lines today, if we get to 100 today, we'll do phone calls if we have time. If not, it'll be good for tomorrow. And if we get to 50, I will keep the mustache for another day. Otherwise, it goes today. There's a lot of people in my household very much ready for the mustache to go. And as of right now, that's exactly what would happen. Is it just me, or does the defense attorney sound like Bert the Muppet? Unsure. David, sir, we appreciate you. Thanks, Katya. The judge's candy crinkling is out of order. Was it candy or was it nuts? Fantastic troll job by the defense with the pixelated video stuff. Played the judge like a fiddle. Yeah. The defense was so successfully able to play off of the judge's technical ignorance. Are they coming back? Oh, we're almost back. Yeah. That they very much used it in their favor. If Rittenhouse had been armed with mangoes, then we wouldn't have this situation, although he still could see a charge for illegally priced fruits. Very much so. Hades wants to talk about Garrett Foster. Not what we're doing today. Let's see what else. A lot of people are borderline about to get banned. I think we might have already banned 70 or 80 people just today alone. Like, let me give you, for example, there's someone who is every 5 seconds saying, will you condemn the riots that will happen, David Pakman Show? Will you condemn the riots that will happen, David Pakman Show? Anyone who knows me knows I condemn all rioting. But it's like, how many times are you going to chat the same thing before it's just going to be like, that's it. That's it. We're banning you. It's just spamming when you're saying the same thing every 5 seconds. I do want to say, instead of focusing on all these horrible people. Okay. All right. And he's still doing it. So we're just going to ban. Instead of focusing on these horrible people, I want to instead thank everybody who has been signing up and supporting the streams. We do have our primary funding source is our website memberships, davidpakman.com/membership or joinpakman.com, whichever is your preference. We are banned from Twitch for another 23 days, and we lost 1,000 paid subscribers there. As you can see above my head, it says Twitch subscribers 0. And so I would love it for you to support through our website, joinpakman.com. Today's coupon code is UnchargedPickles.
Uncharged pickles?
You can also make a pledge via Patreon. Some people say Patreon. I once heard someone say it. I don't know. And you can make a pledge via Patreon, and those count double. They would very quickly get us to 50. And also, whoever is number 50 gets a free item from the David Pakman Show online store. A few other people want bans. We can keep handing them out. The bans are free. Joel says, appreciate your coverage of the trial, David. Some chatters are hoping that police would have mowed Kyle down, which is kind of extreme. I hope people would think a bit more critically about this tragic and avoidable event. Yeah, I think that it's a legitimate thing to say. People in Kenosha on that night could reasonably have thought of Kyle Rittenhouse as an active shooter who needed to be stopped. That's reasonable. It's also completely plausible that in this situation that Kyle Rittenhouse created, at some point he feared for his life, making self-defense accurate under the law. So it's a horrible situation that is completely and totally avoidable, in every way, period. A couple other voicemails. Let's see.
Hi, David. This is Nick from Vermont. How are you today? Great mustache. Anyway.
Thank you.
Use mascara. That will darken it. If you don't know what mascara is, ask your girlfriend.
I've never heard of mascara.
She, I'm sure, has some. Anyway, this judge is a joke. Do you know if the prosecution has any recourse? You know, defense can always appeal. Does the prosecution have recourse to claim?
So our attorney who has been sending messages said last week, the prosecution cannot appeal a not guilty verdict. That's what I remember Graham, the attorney, telling us last week. And I'm glad to be corrected or for there to be clarification. Glad to have that happen. Let's see. I think we've got someone trying to sneak Let's Go Brandon into the voicemail.
Yeah, guys, go to join.davepackman.com. Use the code Let's Go Brandon. Let's go Brandon.
Oh my God. How do these people, I mean, these are like the lowest brow, bottom of the bottom of the bottom of the barrel people. We are blocking that number. Blocking a couple other people. And it's so cringy. Yeah, Let's Go Brandon is so cringy. That's the thing. They think it's slick in some way, but it's just painfully cringy. Ian says, thanks for your coverage. No matter the verdict, it's sad when right-wing vigilantes bring guns illegally to escalate and use the gun's presence to justify its use. I thought he'd grab my gun, which I am not even allowed to have, so I shot him. Yeah, that's what we call a situational problem with the whole thing. I want to say a big thank you to Sean Dixon, who just signed up on my website with the coupon code Uncharged Pickles.
Uncharged Pickles?
And his new member number 33. Also, thanks to Ola Nordman for signing up with the same code.
Uncharged Pickles?
That's number 34. And then Short Brief and Jason Benko made pledges via Patreon. They count double, and it puts us at 38. We are standing by here for the resumption of the prosecution's closing statement, and it has been good so far. They're now going to bring in the jury. Elements of cringe. Yeah, Flossie Carter.
Could you come down, please?
By the way, we really appreciate Flossie Carter being in the chat today. Flossie's got nearly 2 million YouTube subscribers, making me look like a little kid with my paltry 1.4. Flossie does really great reviews and different reviews of different technical elements that are available to people. Great to have Flossie watching. We had TYT Sports in the chat last week, and a lot of different people. Remember, these all caps free Kyle. Kyle is a hero. Let's Go Brandon. You're just insta-banned. And it's so sad that so quickly you will never participate on my channel again. Sad, I guess, for you. I don't know. Sad to be an adult and to be banned for humiliating yourself. Thanks to Rachel Kendall for the Patreon pledge. Those count double, and that puts us at 40 today. Also, John Peter with a Patreon pledge puts us at 42. These numbers are climbing very, very quickly. What's the over-under on when the next Whitney call would be? I don't know. I'll let you guys know. I'll keep an eye on it to see if she calls in. PBS a little slow. Here we go. PBS is back. All right. Obama, I read on Facebook that Rosenbaum's bag had uncharged pickles in it. I read the same thing, actually.
Obama.
Oh, boy. I got a couple emails about... Actually, I'm not even going to mention what I got emails about. I'm changing my mind. All right. So Mr. Binger is going to continue his closing statement. It was solid to start with. I'm not saying it'll convince the jury. I'm just saying it was a solid closing statement. And we're watching all of these statements very, very closely.
Thank you, Judge.
I will be stepping away for a phone call at some point during this.
Well, your full stomachs won't distract you too much from the presentation here. So I had been talking about the murder of Joseph Rosenbaum. And as you can tell, I'm trying to go in chronological order. I'm trying to go through these events in a way that makes the most sense. So count one of the information is with regard to Joseph Rosenbaum. The second count of the information pertains to Richie McGinnis, who you heard testify. He testified that he was in the line of fire behind Joseph Rosenbaum as the defendant fires 4 rounds with his AR-15, which is loaded with full metal jacket ammunition. And I'll talk a little bit more about that type of ammunition in a little bit. But you've heard testimony that it's the type of ammunition that is capable of going through body armor. It is capable of going through a squad car. It is designed to go through the target and continue flying on for up to 550 yards. Richard McGinnis testified that when those shots went off, he thought he had been hit. He thought his life was in danger. One of the rules that I think most people who are familiar with firearms knows is always check your background, meaning know what's around your target and know what's behind your target. This is true when you're hunting, it's true when you're target shooting, and obviously it's true when you've got an AR-15 in downtown Kenosha in the middle of protests with houses and people nearby. But there's no indication the defendant cared one bit about his background, cared one bit about where those bullets were going to go. And as I said, he put Richie McGinnis in danger. Richie McGinnis, after this incident you've seen on the videos, goes to try and help Joseph Rosenbaum and has his own video shows. When he first gets there, he finds Mr. Rosenbaum's body face down on the ground. And I'm going to play this exhibit 15 for you.
Rittenhouse does not want to see these videos, that's for sure.
You okay? Just don't move, man. Don't move. All right, can I flip you over real quick? Oh, I'm gonna flip you over real quick, bro. Flip over real quick. Just gotta get pressure on this, dude. Where's it at? Where's it at, dude? Get a light on it. Get a light. Give me a fucking light. Put pressure on it. Where, dude? Where's the hole? Get the fucking mask up. Come on. Put pressure. Keep your eyes open. You shot him. I didn't. Let go. Dude, just get pressure on this shit. We gotta keep alive. I got it. What's your name? What's your name? What's your name? Is y'all thinking the hospital right here? Yeah, get him up. Get him up. Start calling. Yo, keep pressure on him. I got him. Get him. Keep pressure on him. Get his arms. Put that down. I got you.
You want to talk about medics, you want to talk about people who care, you want to talk about people who were there trying to help. You just heard them and you just saw them. People who didn't know Joseph Rosenbaum, they just knew somebody needed help. And while that's going on, the defendant flees, callously disregarding the body of the man that he just shot and killed. And as he's running off, he's lying to the crowd about what just happened. This is exhibit number 12.
So there was just like 6 shots. It went off.
The defendant says he pulled a gun. That statement, he pulled a gun, was a lie. It's not true. The defendant knew it wasn't true. He's lying to the crowd as he's running away. Joseph Rosenbaum didn't have a gun. The defendant knew he didn't have a gun.
True.
The defendant is lying to save his own skin instead of going and trying to help the person that he has just shot and killed. In exhibit number 3, Gage Grosskreuz's Facebook Live video, he tells a similar lie. As they're running, Mr. Grosskreutz asks the defendant, "Did you just shoot someone?" And the defendant says something about the police and then says, "I did not shoot anyone." And this is similar to the lie that he told Jason Lukowski at exactly that same time. As he passes Mr. Lukowski, he says, "I did not shoot anyone." And that was established through Mr. Lukowski's testimony. And again, I think it's worth emphasizing at this point that Jason Lukowski had just met the defendant maybe an hour. This is about 11:50 at night. Mr. Lukowski got there about 10:45.
Almost.
This is Gage Grosskreutz running towards danger, running to try and help. This is exhibit number 3.
Hey, what are you doing? You shot somebody? Who shot? Who shot? Hey, what are you doing? You shot somebody? Who shot? Who shot?
Listen to the second thing he says.
You shot somebody? Who shot? Who shot? Hey, what are you doing? You shot somebody? Who shot?
It's hard to tell what his exact words are. I hear the word "not" pretty clearly in there, as in I did not shoot anyone, I did not do anything. Jason Lukowski, he lies to. The crowd, he lies to. Gage Grosskreutz, he lies to. So at this point, the crowd is dealing with what they perceive to be an active shooter. Someone who has just shot someone, who is still in possession of the gun, who is fleeing the scene, and how are we supposed to know where he's going next? You know, all night that night, the crowd has been hearing the sound of gunshots. They've been hearing fireworks, firecrackers, but now someone actually has been shot. The crowd sees the defendant running with a gun. He's lying to them. He still has the gun. He's shot someone. This is provocation to them. This is someone who has committed a criminal act and is putting people in danger. It is entirely reasonable for that crowd to believe at that moment that he is a threat to kill again. The defendant could have made it unequivocally clear what he was doing. He could have stayed at Mr. Rosenbaum's body, helped protect him, helped preserve his life, call 911. As he's running, he could have announced to the crowd exactly what he was doing, told them. He could have fired warning shots to try and keep him away. He could have dropped the gun. He could have raised his hands and surrendered. He could have signaled to this crowd that he did not pose a threat anymore. But everything he does is indicative of someone who is still a threat. Now, the defendant is going to tell you he wasn't. But from the crowd's perspective, how are they supposed to know any different? He does nothing to demonstrate to the crowd that he isn't a threat to kill again. And it turns out he does. It turns out within a few seconds, he does kill again. I submit to you, ladies and gentlemen, that in this situation, the crowd has the right to try and stop an active shooter. They have a right to protect themselves. The defendant is not the only one in the world who has the right to self-defense. But what does the crowd do to try and stop the defendant? I submit to you, and this is not a criticism of them, but they use almost the least minimal, least intrusive means possible. They could have used deadly force against him. They could have shot at him. But instead, somebody comes up behind him and knocks his hat off. Anthony Huber comes up with a skateboard and the defendant blocks it with his arm. And then the defendant falls to the ground on his own. No one knocked him down.
This is an interesting approach.
This man that the defense wants to call jump kick man. He's got no weapons, no gun, no knife, no nothing. Comes in and tries to kick the defendant in the face. Anthony Huber comes back and tries to grab the gun. Actually does grab the defendant's gun and tries to pull it away because he's trying to disarm an active shooter. And Gage Grosskreutz comes running in, stops with his hands up in the air until he sees and hears the defendant adjusting his weapon as if preparing to fire again. And then what does Gage Grosskreutz do? He reaches for the gun to try and disarm the defendant. Gage Grosskreutz had his own gun in his own hand. He could have aimed it and fired at the defendant, but he did not. And you heard Gage Grosskreutz testify about that, about how that is a decision that he was not prepared to make at that point in time. He is not the type of person who is just willing to take someone's life in an instant, unlike the defendant, who took 2 lives that night, very quickly and seemingly very easily. There is a video, Exhibit 5, which is the BG on the scene video, which traces this entire incident, which we call the second event. This is going to show you Mr. Huber, Mr. Grosskreutz, and the other individuals who are trying to stop an active shooter using what I would characterize as the least intrusive means possible. Someone knocks his hat off. Anthony Huber comes in with a skateboard. In just a few seconds, the defendant kills one person, attempts to kill 2 more, and blows off Gage Grosskreitz's arm. It's that fast. This is someone who has no remorse, no regard for life, only cares about himself. And these folks that are coming at him, the jump kick man, Anthony Huber, aren't armed. They're not a credible, imminent threat to his life. They are trying to stop an active shooter. And they have a right to do so. Imagine if the crowd couldn't do that. Imagine if they weren't allowed to try and stop someone in this type of situation. After killing Anthony Huber, after severely wounding Gage Grosskreutz, the defendant walks away like he's some sort of hero in a Western. Without a care in the world.
He was providing medico, though, I thought.
You know, it's interesting. This occurs about a block away from the police line, right down the road. If the defendant's so concerned about his safety, the police are right there. And in fact, they pull up to this scene almost instantly. The defendant's got his medic bag on. He proclaims himself a medic. He doesn't know at this point if Anthony Huber's dead or alive or capable of being saved. And yet the defendant offers no assistance, makes no attempt to try and help anyone else. All he cares about is himself. We have taken that video and we have broken it down into individual frames. And I want to take you through, frame by frame, the incident with Gage Grosskreutz. Because a lot has been made about Mr. Grosskreitz's motions and what he does and where he goes and things like that. So I think it's helpful for us to take a look at this. So this is Exhibit 80, beginning with frame 356. At this point, you can see that Anthony Huber is staggering off after being shot in the chest. The wound has entered his lower left rib cage and has wound up almost exiting near his right shoulder. It has ripped through his ribs, his heart, his aorta, and he may not technically be dead, but he's he's going to be dead within a few seconds. He is stumbling away. The defendant has the weapon pointed towards Gage Grosskreutz here, who is cowering, hovering, hiding, covering his head, trying to stay out of the way. And I'm going to go frame by frame here slowly as we see the movement. Now we see the gun is moving down towards Gage Grosskreutz. It is pointed directly at him from a distance of just a couple of feet. Gage Grosskreutz has his right leg planted as if he's pushing backwards, trying to get away. The gun is still pointed at him. The defendant here is going to adjust the gun, turn it over as if he's making some sort of adjustment on it. Gage Grosskreutz testified that this was a movement that he interpreted as the defendant preparing that gun as if it was going to fire again, as if clearing a jammed round so that he could shoot it at Mr. Grosskreutz. At this point, Mr. Grosskreutz is, I think, probably thinking to himself, if I can get away, I will, until he realizes that the defendant is getting ready to fire again.
Why do people think they have a right to chat on my YouTube stream? Like, you don't have a right to that. Really troubled people.
In none of these frames is Mr. Grosskreutz's right hand with his Glock pistol pointed at the defendant. You can see Mr. Grosskreutz is actually backing up with his right leg. Let me go back a couple of frames here. This is frame 444. You can see his right foot is on the ground, but it's starting to move back. Now as I move forward in the frames, 447, his right leg is moved back. This is someone who is about to retreat. His hands are in the air. He's backing away from the defendant until, as he's testified, he sees the defendant start to manipulate that gun in such a way that it makes Mr. Grosskreutz feel like he's about to be shot. And only then does he take action. What action does Mr. Grosskreutz take? Does he hold that gun with both hands, the Glock that he's got, and point it at the defendant? No, never. Does he even take the gun with one hand and point it? No, never. Instead, you can see him start to lunge in with his left arm forward. The gun is not in this hand.
I'll be back, guys. I got a phone call.
He's lunging forward, reaching for the defendant. Probably reaching for the gun. Probably trying to block the gun. You can see now he's going to take a step with his right leg across the defendant's body. Not directly towards the defendant, but across the defendant's body. As he's reaching in, almost swiping away at that gun with his left arm. He has bladed his body in such a way as to try and present as minimal of a target as possible, which is probably what saves his life. His right leg is about to hit the ground here. The gun, the AR-15, is pointed directly at him from just 2, maybe 3 feet away. He's trying to shield himself with his left arm. And as we approach frame 500 here, the gun goes off. At no point in this process is Mr. Grosskreutz pointing his gun at the defendant. Frame 499, the gun is just fired. Frame 500, you see the puff of smoke. 501, the bullet has hit Mr. Grosskreutz's right bicep, severing it. I'm going to continue forward after this because you can see that his right arm, this is an interesting frame right here, 504. You can see that gun. I'll go back even more. You can see that Mr. Grosskreutz's arm with the right hand with the gun, his right hand is pointed off to the side. What pulls that gun down closer to the defendant is the fact that Mr. Grosskreutz just had his right bicep severed. It's not a voluntary action. It's an involuntary, the muscle is severed. Now watch, frame 502, watch his right hand. 503, 504, 505, 506, 507, 508. At this point, yeah, absolutely. That right arm is probably dangling down towards the defendant. It's not going to be able to pull that trigger without a working bicep muscle, and it's not a voluntary thing. It's done because the defendant just blew his arm off. But yeah, this is the time after the shooting when, yes, the gun happens to be pointed at the defendant. And I got to stop here for a moment and highlight the hypocrisy of the defense. Because according to the defense, if someone has a gun, they're a threat. If someone points a gun, they're a threat. There's only one exception to that. The defendant. By their logic, he gets to run around with a gun all night. But, oh, we're not supposed to take him as a threat. He gets to point the gun at everyone. But, oh, we're not supposed to take him as a threat. No, it doesn't work that way. The same set of rules apply to the defendant as everybody else. There's no exception in the law for Kyle Rittenhouse. There's no exception that says, if anyone else has a gun, you're a danger, except for Kyle Rittenhouse. There's no exception in the law that says, if you point your gun at people, oh, that makes you a threat and I can kill you, except for Kyle Rittenhouse. I can do it all night long. The same rules apply to him as everyone else. And everyone else has a right to defend themselves also, not just the defendant. We have shown you photos and videos of Gage Grosskreuz's injuries. Exhibit 60 is a video taken right after Mr. Grosskreutz was wounded by the defendant. It's hard to look at, but this is what we're dealing with. When you fire an AR-15 at someone from close range, this is what it looks like. I guarantee you, ladies and gentlemen, the defendant had no clue what his gun was capable of. He didn't even bother to pay any attention to it, didn't concern himself with what he would be doing to other people. But this is what happened. Let's not flinch away from this. It's important that we understand what that gun was capable of that night. It killed 2 people, and it did this to Mr. Grosskreuz's arm. When those shootings occurred that I just played for you, what would a reasonable person in the defendant's position at that time think? The good news is, ladies and gentlemen, you're going to tell us. As part of your decision in this case, you will represent the reasonable person, of ordinary and prudent person, and you will put yourself in the defendant's shoes that night. I submit to you that at the time of those shootings, a reasonable person in the defendant's shoes would have known that he had provoked Joseph Rosenbaum by pointing his gun at someone else, that the defendant had put someone else at risk of dying by doing that. The defendant should have known that the crowd was aware of the fact that he had just shot someone and that they felt their lives were in danger. That is reasonable. It is also reasonable to understand that at that point, Gage Grosskreutz had just witnessed all of this. He had heard the defendant had shot someone. He'd heard the defendant lie about it. He saw the defendant shoot at Jump Kick Man at close range, miraculously missing. Had seen the defendant kill Anthony Huber. Gage Grosskreutz reasonably believed his life was in danger at that moment. And he was proven correct, because the defendant shot him too. So when you consider what's reasonable in this case, consider whether or not it's reasonable for a criminal to be able to shoot himself out of a crime scene. When a bank robber robs a bank and runs away and the crowd comes after him, can he just shoot anybody and claim self-defense? If someone comes up to that person and tries to stop them, tries to disarm them, like Anthony Huber did, do they forfeit their life? Did Anthony Huber forfeit his life by trying to be a hero and stop an active shooter and protect others? Is that justified? Can the defendant just kill him? In this case, the crowd was right. The crowd knew the defendant had just shot someone. When they're coming after him, they know he's just shot and killed Joseph Rosenbaum. But you know, not every active shooter situation is the crowd have perfect knowledge. When they're told that person running up the street just shot someone, we don't have time in the moment to go back and take a look at the body and replay the video and make a decision before going after the person with the gun. You know, we've had several police officers testify that in an active shooter situation, their first instinct, their first training is to go in and stop the threat. They don't sit there and wonder, well, maybe it was self-defense. I don't know. I'm going to, wait and see. And every day we read about heroes that stop active shooters. That's what was going on here. And that crowd was right. And that crowd was full of heroes. That crowd did something that, honestly, I'm not sure I would have had the courage to do. If I see a guy running up the street with an AR-15 and I hear he just shot somebody, my first instinct is not to approach. Anthony Huber was different. Jump Kick Man was different. Gage Grosskreutz was different. That doesn't make them a threat to the defendant's life. It doesn't make their lives worthless. They don't give up their right to defend themselves. They have just as much right as the defendant. I told you I wanted to begin by talking about the murders committed by the defendant. Now I want to go back and put it all in context for you. And that context starts with, bruh, I'm just trying to be famous. The defendant's TikTok profile. 4 doors, more whores. Picture of him up in Ladysmith, probably in early May, proudly holding his new AR-15. Up until August 25th, 2020, this is the only time he'd ever fired that gun. Maybe put 100 rounds through it or so at that property up there with Dominic Black. They purchased that gun on that same trip. The defendant admitted he knew as a matter of law he could not buy that gun because he was only 17. Yet he wants to tell you that he thought legally he could possess it, which didn't make a lot of sense to me. We don't have a lot of defendants come in and say, well, I possess cocaine. I knew I couldn't buy it, but I thought I could possess it. No, it's not the way it works. Dominic Black conducted what we call a straw purchase for the defendant. He purchased that gun for someone who was not legally allowed to purchase it for themselves. I'm prosecuting Dominic Black for that, as you know, just like I'm prosecuting Joshua Zeminski. Because what Dominic Black did was wrong, and we don't tolerate that. The agreement was Dominic Black was going to keep that gun until the defendant turned 18. It was Dominic Black's gun. It was legally his. And the defendant knew that it was going to be held onto until he turned 18, that he was not going to have it until that birthday. I want to focus a little bit on this AR-15 because I think it's important when you consider the recklessness of the defendant's conduct, how much he knew, cared, or didn't know about this deadly weapon. He'd only fired it that one time, maybe 100 rounds through it. He loaded the gun with full metal jacket ammunition, which I'll talk about a little bit more. He wanted it because he said it looked cool. Didn't seem to know or care much about the type of ammunition or the type of gun. You had a couple of witnesses tell us in this trial, and I could not believe it. A gun is a gun is a gun. Don't even start with that. And a bullet is a bullet. No, it is not. It is not. And anybody who says that is ignorant and reckless, because there are some important distinctions here. Full metal jacket ammunition is capable of piercing body armor and squad cars. And you heard Officer Krieger testify that when they heard someone was running around with a rifle, he went and got his plate armor out of the back because their regular body armor wasn't going to stop those rounds. Ryan Balch talked about how full metal jacket ammunition is designed, and this is a former Army infantryman, is designed to go through a target like a deer or a person and continue on. He says it can hit a target 550 yards away. That's 5.5 football fields. And he explained that he had a handgun that night, which he put hollow point ammunition on. And that's what he was planning on using for self-defense. Because hollow point ammunition acts differently. It's going to hit its target, but it's not designed to continue on and go through and hit other targets. So you will hit what you hit, but you're not going to put the rest of the community at risk, especially on a night when there are hundreds of people out on the streets in a heavy residential area. We can see on that map that car source, there are houses, there are churches, there are daycares, there are schools nearby, and you're firing full metal jacket ammunition around. I submit to you, ladies and gentlemen, that AR-15 had no lawful or legitimate purpose that night. Now, the Second Amendment allows people to carry guns. That is true. There are people who can't carry guns, convicted felons, for example. But, generally speaking, I'm not saying people don't have the right to carry a gun. What I'm saying is that AR-15 did not accomplish any of the goals that these folks said it was going to. So, for example, Ryan Balch says the handgun is what he was going to use for self-defense. Several witnesses agreed you can't point this gun or shoot this gun at people to protect property. So if you're going to protect the car source building, how is this gun going to help with that? The defendant has admitted the gun was useless when he was going to treat people as a medic because it got in the way. He had to take it off and hand it to someone. So you can't use it as a medic. You can't use it to protect the building. So what's it there for? Well, it looks pretty imposing, and it has some deterrence value, but Jason Lukowski, Dominic Black, and Ryan Balch all said they never actually intended to use their guns. So why is it there? The defendant was wearing a sling that night. He purchased that sling at Jelinski's that afternoon. The purpose of the sling was so the gun couldn't be taken away. Wouldn't fall off, he wouldn't lose possession of it. It was designed to help him retain possession of that gun. And he loaded it with 30 rounds, the full magazine, capable of killing 30 people or more. Why do you need 30 rounds of full metal jacket armor to protect a building? This AR-15 is completely incompatible with the role of a medic. Richie McGinnis testified he's been to demonstrations in Seattle, Portland, Washington, D.C., New York, Minneapolis. He's never seen anyone walking around claiming to be a medic with an AR-15. And certainly when you see someone like that, it doesn't exactly send a warm, fuzzy message. Oh, come to me, I'm here to help. And the defendant acknowledged he had to take off his AR-15 to treat people. No serious, credible medic wears an AR-15 slung around their body. That's because the defendant was a fraud. He was not an EMT. He lied. He lied to the press. He's being interviewed by Richie McGinnis, who he hears is a member of the media, and he says, I'm a certified EMT. You're lying. You're absolutely lying. Jason Lukowski and Dominic Black said the defendant had to borrow his medical supplies from us. This is an emergency situation. Everybody's anticipating violence. Everybody's prepared for people to be hurt, harmed, injured, and yet the defendant's going to go there and walk around claiming to be a medic? He's like a quack doctor practicing without a license. That puts lives at risk. And one of the things I had Gage Grosskreutz testify about is that tattoo on his right arm which said, "First, do no harm," which is one of the precepts, one of the fundamental tenets of the practice of medicine. First, do no harm. So how do we evaluate the defendant's performance as a medic that night? Well, on one hand, he wrapped up an ankle and I think maybe helped somebody who got a cut on their hand. Yay. On the other hand, he killed 2 people, blew off Gage Grosskreitz's arm, and put 2 more lives in jeopardy. So, when we balance your role as a medic that night, I don't give you any credit. He showed no remorse for his victims, never tried to help anybody that he hurt, and even on the witness stand, when he testified on Wednesday, he broke down crying about himself, not about anybody that he hurt that night. No remorse, no concern for anyone else. For him to call himself a medic is an insult to anyone like Gage Grosskreutz, who spent hundreds of hours training and working hard to become an EMT. It's an insult. The defendant made a series of reckless decisions that night, going armed with an AR-15 at 17 years old when he knew he shouldn't have done so, because that gun is normally locked in a safe that he doesn't have access to, and it's not even legally his. He's out after a citywide curfew. He's intentionally and knowingly entering into a dangerous situation, and he expects it because he brings along his AR-15 and some body armor. So don't tell me you didn't know. He brings along no non-lethal means of defense, which means his only option is to kill. I don't know about a lot of you, but I remember that night. I didn't come down here. I don't think most reasonable people did. In part because we all knew it was going to be violent and dangerous. Most reasonable people, to the extent they came out, they were gone by then. Because you don't willingly put yourself in this situation unless you want it, unless you're looking for it, unless you want trouble. Now, to put this in perspective, at this time here in our community, there were people who were scared. There were people who were worried about themselves, their homes, their families, their business. That's understandable. But this is different. There are also people out there who were exercising their First Amendment right to assemble and to have free speech because of whatever they believed in. And they have that right too. But that's not what we're talking about. The curfew, the riots, the arson, the looting that we'd seen on those prior nights, roadblocks set up around downtown, closed exits on the interstates, all of this was sending the message to reasonable people, go away. Don't come down here. Who was left at 11:45 at night? Most reasonable people had gone home before the curfew or never even came at all. But the defendant's down there, he says, because he wants you to believe he's protecting CarSource, even though he had no actual ties or genuine concern for this building. You have this caravan of people from West Bend, Ryan Balch, Jason Lukowski, Joanne Fiedler, coming down from some other community having no idea what's going on here at Kenosha, having no idea what businesses are, having never dealt with CarSource before, just injecting themselves into this situation. CarSource that night was empty. The owners testified. They moved all the cars off the lot, they took the tools out from inside, and they didn't even feel the need to protect that building. So who's there? These guys with their AR-15s are just wannabe soldiers, acting tough, trying to manufacture some personal connection to this event, furthering their own personal agenda. Just a small part of the deluge of chaos tourists we saw here in Kenosha, trying to feed off of what we were going through. Despite everything we did to try and tell them, go away, stay out. Did those owners, Sam and Sal, ask anyone to protect their business? You know, I called them to the stand because I wanted you to hear from them. I had their statement, but I wanted you to hear from them. And I'm sure you formed your own impressions about them. I'm not here to tell you that I believe what they said on the witness stand. I don't think it really matters much, except I wanted you to have a flavor of who these people were and what was going on at that building. What was interesting to me is that text message from the defendant to Sam asking for the address of CarSource, even though the defendant says he's already been there. That didn't make any sense to me. It's not hard to find if you've driven past there every day. You know, Kenosha is one of the easiest cities in Wisconsin to navigate. It's all east, west, north, south. How hard is it to find this place? But the agreement was the defendant was supposed to stay at the 59th Street location. There's another group at 63rd. It was their responsibility, and the defendant testified that when the shootings occurred at 11:45 or 11:50 at night, he didn't even know if that other group was still there or if they'd left. But crucially, you heard the testimony of Kriston Harris, who was out there reporting for his Rundown Live, and he's making some video, and he tells the defendant, stay on your property. Don't go out in the streets and engage with these protesters because you're just making it worse and you're escalating the situation. He tells the defendant specifically that, just 20 minutes before the shootings. Kriston Harris probably said that because he knows this is a crowd that is feeling threatened by the defendant and his group. Richie McGinnis testified when he left the Stella Hotel and immediately ran over to 59th Street, he saw guys up on the roof and he felt threatened. These guns, he said, were the thing that changed the dynamic for him. Drew Hernandez, we showed video of Drew Hernandez having laser sights pointed at him. And he said he felt threatened. He thought someone was pointing a gun from the roof and putting his life in jeopardy. These are two people who are veterans. They've been to protests in Seattle, Portland, Washington, D.C., New York. They've been through this before. And yet here in little old Kenosha, the defendant's group made them fear for their lives. That's the kind of impact these AR-15s had. The crowd is yelling at the defendant's group, stop pointing your guns at us, stop pointing these laser pointers at us. And the defendant sees this. He's well aware of the fact that the crowd out on the street is hostile. They don't react well to him. And he knows that by 11:35 at night, this crowd is all the way down there south of 60th. That's where they're at. So if I go down there, I need to be prepared and I need to expect that these folks are not on my side. Joseph Rosenbaum. He's dead, so we don't know what he was thinking. We don't know what was going on in his mind. That makes him an easy target for the defense today because they can stand up here and pile on him and destroy his reputation, and he can't speak for himself. That happens a lot in homicide trials. Blame the victim who can't speak for themselves. So I'm going to tell you a little bit about Joseph Rosenbaum, and you've heard some testimony about him. He had been in the hospital, left it that day, had a clear plastic bag with his possessions, toiletries, a water bottle. We've all seen this. You get it in the hospital, it's pretty common. He's walking around like it's pretty much his only possession in the world. He visits Carrie Ann Swart, his girlfriend, and then happens to wander downtown into the middle of civil unrest. No indication he planned to be there. No indication he's part of any sort of movement. He just happens to stumble into it. So what does he do that night? Oh, let me tell you all the awful things Joseph Rosenbaum did. He tipped over a porta potty that had no one in it. He swung a chain. He lit a metal garbage dumpster on fire. Oh, and there's this empty wooden flatbed trailer that they pulled out in the middle of the road, and they tipped it over to stop some bearcats, and they lit it on fire. Oh, and he said some bad words. He said the N-word. If he were alive today, like Joshua Zeminski, I'd probably try and prosecute him for arson, but I can't because the defendant killed him. But that's the way we deal with people that do these things. When you commit arson, we prosecute you. We don't execute you in the street. And I'm not here to say that the things that Joseph Rosenbaum did were good or that I condone that kind of behavior. Not at all. But he didn't deserve to die for it. You can't kill someone for these things. He's 5'4", 150 pounds. Jason Lukowski characterized him as a babbling idiot. Lukowski says, I turned my back and walked away. This guy wasn't even a threat. I think we all know somebody like Joseph Rosenbaum, the Napoleon complex, the little guy who just wants to chatter, but when it comes down to it, it's all bark. It's no bite. It's like a little dog. Bark, 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 but really ain't gonna do anything. There is no dispute in this record that at no point that night did Joseph Rosenbaum hurt anyone. Never had a gun, never had a knife, never had a bat, never had a club. And in the Drew Hernandez video, that fight at Ultimate Gas that we showed you, he's being shoved around by the crowd like a rag doll. And yeah, he's mouthing off, he's talking a lot, but he doesn't actually threaten anybody, doesn't actually hurt anybody. They're pushing him around like he's a tiny little person, which, frankly, he was. And in the background of this video, you will hear somebody say, point your gun at me, or something like that. That's Joseph Rosenbaum. He's upset because somebody pointed a gun, and that triggers him, which is understandable. I think most of us would be triggered by that sort of thing. And that's what's upsetting to him. But he gets right in the face of people who have AR-15s. Never reaches for their guns, never rears back to punch anyone, never even lays hands on anybody. You're going to watch this confrontation here at Ultimate Gas, and I want you to keep in mind that there's a group of people on one side with AR-15s and a group of people on the other side. And none of the people with the AR-15s feel their life is in danger. None of them shoot their guns. They can handle themselves. The defendant can't. That sound you heard was somebody throwing some sort of plastic thing at one of the stanchions underneath the gas station, and it makes a sound that almost sounds like a gunshot. So add that into the mix. You've got people with guns, loud voices, clear hostility, and the sound of something that, frankly, to me sounds like a gunshot, and yet everybody keeps their cool. Nobody hurts anybody. Nobody fires a gun. And watch how they push Joseph Rosenbaum around like a rag doll. Watch this guy in yellow. He's going to shove Joseph Rosenbaum about 8 feet away. Well, I guess it was a different guy that did that, but they're shoving him around like a rag doll. Nobody feels threatened by Joseph Rosenbaum. He's not reaching for anybody's gun. He's a mouthy little guy. He's a little dog that barks. And you know what he's going to do now? He's going to tell him, hey, I need to go grab my bag. I don't have my bag. So they let him on through. There he is about to reach down and grab his bag off the ground. That's Joseph Rosenbaum. You've heard testimony that he tells people, shoot me, asking them to shoot him. I'm curious how that's a threat to anyone else. He's triggered, as we saw in that video, by people pointing guns at other people, which is reasonable. Most people would feel that same way. And then we get to the crux of the defense, this threat that he supposedly made to the defendant. The defense would love to be able to play you a video of this threat. They would love for you to see it and hear it yourself. This is a night in which there are dozens of people out there, reporters and regular folks who are recording with their cell phones and with other cameras all night long. We have shown you video of almost every minute of the defendant's night from multiple different angles. And yet, you have not been shown a single video with this threat. Nowhere. It's not out there. Ryan Balch testified, and we have his transcript. We have his testimony, and what he says is there was an incident in which Dustin Collette had put out a dumpster fire and said something to the effect of, fuck around and find out. And Balch steps in, and he has an exchange with the protesters, and he turns around, and Rosenbaum is right there in front of my face yelling and screaming. And I tell him to back up. And he goes, you know what? If I catch any of you guys, blah, blah, blah. So that's the timing, according to Ryan Balch. Right after that dumpster fire. Kriston Harris from the Rundown Live was there, physically, standing right next to Ryan Balch. Not only was he there during the dumpster fire, but he stays with Ryan Balch and or the defendant for the next 6 or 7 minutes, recording everything. And I've played this video for you. It is Exhibit 18. And I played for you a period of time from 1 hour and 22 minutes to 1 hour and 28 minutes. And I asked Kriston Harris, I call him to the stand, and I said, I'm going to ask you 2 questions. Number 1, do you independently remember seeing Joseph Rosenbaum hearing this threat? And he said no. And then I said, okay, well, maybe you missed it, because, you know, there's a lot going on. So will you rewatch your video for me and tell me, is it in there? And he said, no. This video captures.
Just I heard all of it. I was on a conference call I had to be on, but I was listening.
And there's no threat. There's no Rosenbaum. It didn't happen. The defense desperately wants this because they've got to give you a reason why it's okay to kill Joseph Rosenbaum. And this threat is critical to their case. But it's not there. In exhibit number 3, and I'll play it for you here as I'm talking. Joseph Rosenbaum isn't even visible. Now, I submit to you that even if, I'm sorry, this is exhibit 18, even if there was a threat made, it's still not enough because Joseph Rosenbaum's unarmed and you can't kill him. But the defense has pinned a lot of their case on a threat that didn't happen and they can't prove.
Welcome to Vaush, who is joining. A lot of prominent streamers stopping by today.
Live video. And I'm going to go to that mark.
Kriston T. Harris here at the Rundown Live, and I'm here with a bunch of Sean T. Harris here at the Rundown Live. If you are live, share this in all your groups, your forums, start watching, protect. Hey, it's just like the year, man.
So here's the dumpster fire.
2020 is a blunt, it would be just a fucking stem. I could use a doobie right now.
Joseph Rosenbaum is not in this video. Here's Dustin Collette about to put the fire out.
How's it going? Guys want to fuck around and find out? Hey. You want realistic?
Can we all at least agree, whatever the guilt or innocence of anyone involved, these are just great people I would love to hang out with?
Yeah, that's true. Just stay on your property. There's way too many of them. I have to agree with her.
There's Ryan Balch standing right next to Gage Grosskreutz. Joseph Rosenbaum isn't here. And the defendant and his group are being told an important message. As long as you stay on your property, but don't go out there and cause trouble.
I have to agree with her. They shouldn't be on the street. They're just protecting their property. One of the guy's an asshole. I know, I thought they were yelling at them. I was like, what? One of the guys losing his patience. He should go inside. Yeah, that's what we're about to send him. Yeah, if you guys could switch him out.
He's talking to Ryan Balch right now.
He's got a lot of rage. He says the wrong thing. This whole crowd burns the guy's life. Protect your property. They're respecting that. Just keep it there.
This is where Ryan Balch goes and talks to a protester.
He's just trying to protect his property. He didn't do anything. He said he has no problem with you guys.
There's this background issue to the entire trial that's not even really talked about, which is the whole concept of just random dudes patrolling. Like, even the mere use of the word patrolling could be the subject of hours of exposition about the absurdity of the entire situation. Not at issue in the guilt or innocence on this particular situation. I'm conceding that.
Don't look for trouble or anything. I know you are, but like, they got their own medics, and if somebody's close by, take care of them. I know you're just trying to make peace. I get that, but they don't look at it that way. They look at you guys as it's a different. It's as much as you guys are afraid of them before they march down here. I know, but like when the conversations are having. Thanks, guys.
Back away from the business. Back away from the business.
The rest of the video is the crowd being warded off by gas launched by the police. They launch tear gas, which affects the defendant, which affects Ryan Balch, it affects Kriston Harris, and that group all runs alongside the 59th Street car source, away from the street, away from any protesters. At no point in that video do you hear any threat that Joseph Rosenbaum makes. It's not there. Trust me. If the defense had it, they'd play it for you. Now, they want you to believe that that threat is made, and they also want you to believe that it was something that the defendant took into account when he decided to kill Joseph Rosenbaum. One of the questions that occurs to me is, how would the defendant even know who that guy is? Because earlier in the night, Joseph Rosenbaum is wearing a red shirt and a blue bandana. But by the time he's killed, he's got no shirt on. He's got no blue bandana. This is someone the defendant has never even met before. He's one of hundreds of people in the crowd. And yet, we're expected to believe that in a split second, the defendant remembers this guy? I don't believe so. So then, that video that I just showed you leaves off at about 11:35 p.m. The police have moved the protesters south of 60th Street. They've tear gassed the crowd, and there's no protesters left. 59th Street is no longer in any danger. It wasn't much danger to begin with. There wasn't anything left there to protect. But by this point, there's no more danger. As law enforcement comes through, you've heard this video where they tell the defendant and his group, "We appreciate you," and hand him out bottles of water. As long as you stay on that private property, yeah. No one is saying you don't have the right to stay on private property and protect private property. What people are saying, what the crowd is saying, is stay there. Don't go out looking for trouble. The defendant hears this message from the police and takes it the wrong way. He thinks, oh, well, now I'm junior policeman. I can go run around stopping crime.
Basically.
But I asked him and I asked some other witnesses, if the police are there on the scene and the protesters are gone, go home. Why are you still here? Shouldn't have been here in the first place, but why are you still sticking around? And interestingly enough, one of the questions I've always had in the back of my mind is, what's the end game here? When is this crew going to be done and decide that it's time to leave? Well, right after the defendant kills Joseph Rosenbaum, kills Anthony Huber, and comes back, they all flee like rats off a sinking ship. But it's boring at 59th Street. There's no protesters. There's no action.
I like that. Since it's boring at
So
59th Street.
decides about 11:35 p.m. to cross the police line and go looking for trouble. He knows at this point he's entering a hostile crowd. He's seen this crowd. He knows what they're like. That's why he has to yell friendly to them, because he knows they're not going to see him and think he's friendly. And he knows he's got to have Ryan Balch with him, some sort of buddy to protect him. And he's immediately confronted by that man with the yellow pants who says, "You just pointed your gun at me." And the defendant says, "Yeah, I did." He admits that. Now, what's interesting to me is they want you to believe this never happened. They want you to believe this guy in the yellow pants made it up or is lying. But he's just standing there by the side of the road, minding his own business, when the defendant happens to walk up to him. Do you think he just sat there and thought, oh, I'm going to make up a lie about this guy on the spur of the moment? Or did it really happen? And is it consistent with everything else you've seen about the defendant? Does he sound like the sort of guy who would point a gun at someone for standing on a car? Does he strike you as the kind of guy that would threaten deadly force to protect property? Because that's what happened. The man in the yellow pants says it happened. The defendant agrees. And then he comes into the trial and says, oh, I was being sarcastic, like he's a little 17-year-old and he wants to get out of it. Shortly after that, the defendant loses track of his protector, Ryan Balch. So now he's in a position where he knows that he's surrounded by people that consider him a threat. He knows that he's not supposed to go anywhere without Ryan Balch. He knows he's supposed to go back to 59th Street. And he does. He tries. He walks up to the police line. He says, I work there. That's my business, which isn't true, but whatever. And they won't let him through. Now, Ryan Balch makes it on through shortly thereafter, but the defendant gives up. He could go one block in either direction and make it back easily if he wants to, but he stops and decides, you know what, I'm going to stay here and maybe see what's going to happen. So then he talks to these people with fire extinguishers, and he's going to go down to 63rd Street, and he asks one of them to come along, and they say no. Now at this point, he doesn't have Ryan Balch. He knows he's supposed to go back. He knows he's supposed to have a buddy, and yet he decides to go it alone. He decides to run down to 63rd Street or walk down to 63rd Street. Doesn't even know if that other group is still there. Doesn't even know if he's really needed, but he can't wait to take this opportunity to go down and confront people. Because he thinks he's some sort of cop, some sort of law enforcement agent, some sort of junior cadet who's out there with the responsibility to fight crime. Nobody asked him to do that. Nobody gave him the right. Nobody deputized him. Ryan Balch says, the police told me, the crowds, we're going to push him down by you, you're going to deal with him. The Bearcats hand out water and tell him he's appreciated. As he's crossing the police line, they warn him about people throwing rocks. What is the message the defendant takes from all of this? The wrong message. Oh, well, now I've got the power. I've got the gun. I'm going to go confront these bad guys. I'm going to stick my nose in things. So what does he do when he gets down to 63rd Street? The first thing he does, we showed it to you at the very beginning, that drone video, grabs that gun and points it at someone to protect property. Points it at the Zeminskis. Because why? Because they're, what, about to mess with some sort of fire? They're not threatening anyone's lives. He doesn't need to protect anyone. He doesn't need to protect himself. He's pointing a gun because he thinks he needs to protect property. He says he wants to put out a fire, but the first thing he does is drop the fire extinguisher on the ground. His AR-15 isn't going to put out a fire. So why is he really there? And we all agree, you can't use or threaten deadly force to protect someone else's property. You are here to decide whether or not his actions are legally justified, not to buy pathetic excuses that might be given to you. As a teacher, when a student says to you, the dog ate my homework, that's an excuse. It doesn't get you out of the homework assignment. If you panic in a situation that is not reasonable, that is an excuse. It is not a legal justification. If you're 17, if you don't have training or experience, if you put yourself in a situation where you're in over your head, if you're scared, those are excuses. Those are not legal justifications to kill. They do not erase your personal responsibility for your own actions.
Wow.
The court has read to you the instructions in this case. They lay out the law that you should apply. That reading took a long time, and I understand there was a lot to digest. And one of the things that you will have the opportunity to do when you go back and deliberate is read through those instructions yourselves. Because I get that listening to them doesn't always make it clear. But I encourage you to focus on some things when you consider the defendant's behavior in this case. You are told that criminally reckless conduct is conduct that threatens other people's lives and poses an unreasonable and substantial risk to other people. There is no dispute the defendant's activities here threatened other people's lives. He took 2 lives. You know, this is not like a normal murder case. A lot of murder cases we're in here trying to convince a jury that the defendant killed somebody. That's not in dispute here. That's the easy part. The question is, does he get a pass? Do we think that's okay? Do we think what he did was right? That's the question you have to answer. And when you consider whether his conduct was criminally reckless, consider, did it pose an unreasonable and substantial threat to the safety of others? Count 4 charges him with first-degree intentional homicide of Anthony Huber. There is no doubt that the defendant intended to kill Anthony Huber or committed conduct that he knew was practically certain to kill Anthony Huber. That gun was pointed at Anthony Huber's lower left rib cage, and the defendant deliberately pulled the trigger. That was no accident. And when you do that with an AR-15 against someone's body, it is practically certain to kill. We all know this case comes down to self-defense, but there's a high bar for using deadly force in a self-defense situation.
This is
the
crucial.
Law says
this is
the
critical.
defendant may intentionally use force which is intended or likely to cause death or great bodily harm only if the defendant reasonably believed that the force was necessary to prevent imminent death or great bodily harm to himself. So did Joseph Rosenbaum pose an imminent threat of death or great bodily harm to the defendant? No way. Did Anthony Huber pose an imminent threat of death or great bodily harm to the defendant? Absolutely not. Did Jump Kick Man or Gage Grosskreutz? No. None of these people posed an imminent threat to the defendant's life or to cause great bodily harm. The standard, when you make this decision, is what a person of ordinary intelligence and prudence would have believed in the defendant's position under the circumstances that existed at the time of the alleged offense. The reasonableness of the defendant's beliefs must be determined from the standpoint of the defendant at the time of the defendant's acts and not from the viewpoint of the jury now. So put yourself in the defendant's position. Would you have done the same thing? Would a reasonable person have done the same thing? Would you have engaged in the reckless conduct that led to this course of events? Would you have gone out after curfew with an AR-15 looking for trouble? Would you have aimed at other people? Would you have tried to use the gun to protect an empty car lot? No reasonable person would have done these things. The court has also instructed you on provocation. You cannot hide behind self-defense if you provoked the incident. If you created the danger, you forfeit the right to self-defense. By bringing that gun, aiming it at people, threatening people's lives, the defendant provoked everything. And if he does that, he has to exhaust all reasonable means to avoid a confrontation. All reasonable means. So if Joseph Rosenbaum's running at him, Joseph Rosenbaum is no threat to his life. And not only is the defendant expected to run, he's expected to yell, push, shove that rag doll around, run back for help, call 911, call for help, do all sorts of other things besides just turn and fire 4 shots as Joseph Rosenbaum falls helpless to the ground. Ladies and gentlemen, there is no doubt in this case that the defendant committed these crimes. He committed a first-degree reckless homicide against Joseph Rosenbaum. He put Richie McGinnis's life in jeopardy. He put Jump Kick Man's life in jeopardy. He intended to kill Anthony Huber, and he attempted to kill Gage Grosskreutz. All of those elements are true. The question is whether or not you believe that his actions were legally justified. And I submit to you that no reasonable person would have done what the defendant did. And that makes your decision easy. He is guilty of all counts. Thank you.
Wow. The prosecution.
Mr. Binger, let's take a break and about 2:25 hopefully. And please don't talk about the case. Read, watch, or listen to any count of the trial.
So further admonishments from the judge.
Whatever you do, make sure you go to the bathroom somewhere other than the courtroom. By the way, how are the calzones? The food is here. Let's take a break. Lunch is here. Uncharged piccolos. Pizza is here. But we have Subway tomorrow. Warm food around noon. All right, how was the KFC? Very good. All right, enjoy your lunch.
All right, so they will be taking a break. And we'll be back in about very 10, 15 minutes. So what's my thought on the closing statement as a non-lawyer from the prosecution? I think that given the facts of the case, Mr. Binger did almost as good as a job as could be done. I think that there was a moment where, and we'll have to go back, where he said something along the lines of, if you bring the gun, you can no longer claim self-defense. That's not true legally, is my understanding. You can be the one who brings the gun and it still could be self-defense. The mere presence of the gun is not indicative.
2:25 on that clock.
I clocked the closing hour 45 minutes. Is that what you have?
You know, you could have gotten away with murder because I wasn't timing it. After having, you were. How long did he talk?
He talked 2 hours and 8 minutes.
What?
No way.
Give the exact starting time.
No way.
What's that?
I said I can give the exact starting time.
Well,
No way.
Why don't we call one of the networks and they can tell us because.
Detective Howard was timing.
What?
Detective Howard was timing. That's beside.
So, well, let's get everybody under oath and
Wow.
work it out, and if necessary, we'll have a hearing on it.
I'll explain that in a second.
That's all that came through?
So the prosecution has been allotted 2.5 hours total, including their rebuttal. If Mr. Binger went an hour 45, as Jim Krause just claimed, he would have 45 minutes for the rebuttal after the defense. If he went 2 hours and 8 minutes, he would have only 22 minutes for the rebuttal, which sounds tight. Okay, so this is one side's claiming he spoke an hour 45. The other side's claiming that he spoke 2 hours and 8 minutes. Let's see here. Vaush Destiny Piker III is asking, when can we expect the verdict? We have no idea. It's not even clear that they will deliberate today. The defense now will have up to 2.5 hours for their closing statement. That would put us at, let me see, 3:25 and then 2.5 puts us at 5:55, which would be 4:55 there. I don't see how you even necessarily do the rebuttal today, depending on how long the defense goes. Then there's a question as to whether they would even be, then you've got the rebuttal. I don't know. My instinct is they won't really even start to deliberate until tomorrow. That's my sense. Okay. I want to say thanks to some amazing people. These are some of the most patriotic Americans I can imagine. Dan Stevens, Jeremy Jones, and Jasmine Kennedy. We love all three of you. 3 people who grabbed memberships on my website, joinpacman.com. You too can sign up at joinpacman.com using the coupon code Uncharged Pickles.
Uncharged Pickles?
Which saves you 69%. I also want to say thanks to our new Patreon supporters, J.S. Mark DiMicelli and Jacob Penland have pledged. Those count double today. That puts us at 51. Now, I have an extra special announcement. This is a heretofore unannounced element of the show. At 6 p.m. Eastern time today, right after the conclusion of this, I will be doing an Instagram Live with actor Casey Simpson, who I'm told our younger viewers are very familiar with. He's a follower of the show. He's a progressive. We're going to do, it might even be partially in Spanish. He speaks great Spanish. We had a completely abortive attempt at a joint live stream on TikToks not long ago. There was some kind of technical problem. We are going to do it on Instagram today. Okay, very good. People love it. That's going to be today at 6 p.m. Eastern time. Everybody relax, please. Oh, my God.
Please proceed, Governor.
That'll be at 6 p.m. Eastern time today. So I look forward to seeing many of you there. It'll be on the David.Pacman Instagram, as well as on Casey Simpson's Instagram. He has like a borderline illegal number of followers. Let me see where he's at right now. Close to 2 million. I have 97,000. So that's a preferential stream for me, obviously. So that'll be at 6 p.m. Eastern time today. At the bottom of this hour, I'm going to have to get on another meeting. It's crazy. All these people want to have meetings, business meetings, all these different things. I'm going to get on that at the bottom of the hour, but the stream will continue. Super chats are pouring in like someone opened a fire hose. Trump's defense used half their time during his second impeachment. Yeah, the defense may not use all of their time, and they've said they don't really plan to. I believe there was a missed opportunity to mention that in the video, Kyle is running towards the crowd, gun drawn. How did he then feel threatened? Worst murder trial judge since Lance Ito. It's incredibly painful to recall the details. Did the judge just joke you could have gotten away with murder? It's a joke, but really? Kevin says it's been a crazy trial. In the end, 2 people are dead, another wounded, and 1 hangs in the balance. This isn't a football game. These are people. Humanity gets lost sometimes. Quote, you could have gotten away with murder. I know. It's crazy. David Pacman, sir, what will they be eating on the day of the verdict?
I don't even know what I'm doing, sir.
KFC, Subway, or maybe the Asian food from the ports. I actually I saw a friend over the weekend, and she's from a part of New York where they have like a hint of this same accent. And she was talking about a coworker being fired. And I just was like, I've been dealing with that this entire week. I've been dealing with that accent.
Warm food around noon. By the way, how are the calzones?
Do you think the fact that most people recall the last bit of information to reach decisions hurts the prosecution? No, because the prosecution will get a rebuttal. The prosecution gets the last word. The prosecution will have somewhere between 22 and 45 minutes of rebuttal. So that is something we are standing by for momentarily. A few voicemails did come in. I was asked if Whitney calls in, let us know. She just left. This is hot off the presses. Listen to this.
So, like to justify like gun causes and stuff like that, but also like sometimes buying a gun is just doesn't work just because people can lie and get your guns taken away. So like recently I saw some stuff in the news about Maria Butina because people.
All right, now we're getting off track. Also, the Eggman called in, which I like. Let's listen to the Eggman.
Hey, Dave, I'm not a doctor, but listen, man, when looking at Kyle Rittenhouse's mom, okay, you could say that she's a mentally disabled racist, and you can determine that from just listening to her on just one or two interviews.
Whoa, okay, that's the Eggman is shot out of a cannon. Let me clarify what he's referring to. Today, I did quite a segment about the Sean Hannity interview with Wendy Rittenhouse. And in it, I mentioned a lot of people have been writing to me saying, David, Wendy Rittenhouse is being taken advantage of. She's clearly cognitively disabled. I found no evidence that she's cognitively disabled. I think some people are editorializing her physical appearance to say she's clearly mentally disabled. I don't know that at all. And I think the Eggman is reacting to that. So let's continue to listen.
Pretty much, it's obvious. Like, you can make determinations about Trump's health or Biden's health just as a bystander. Back in the day, Dave, we had an R word to call people like her, okay? It's actually a medical term when your growth is stunted, okay? Your mental growth. It's called the R word, or turgid. You can't say it anymore, okay? But that's what she is, an R-word racist. And if you look at her and you can't see that from listening to her, you're giving her just way too much benefit of the doubt.
The Eggman's on fire. Wow, I'm shocked here.
Shalom, brother. Oh, and that's why he came out that way. He's disgusting, just like her. And if you think people are judging her because how she looks, fine. Look at her face. Look at her physical features. Scientifically, biologically, you can look at her and see that she's missing a link, a gene, or something. There's something wrong with those people.
Oh my God. Wow. Shalom to the Eggman, Bavakasha. That is really something else. I don't know how the crowd's going to react to that. The Eggman even left another voicemail. Do you guys want to hear the second one? Because he's really on fire. I want to say thanks to Christopher Copley, who just made a pledge via Patreon. Patreon pledges count double today, and it puts us at 53. Wow, people want the other Eggman voicemail. All right, here's the second Eggman voicemail. These are super aggressive today.
I loved the call from Miss Darcy today, Dave. So, yeah, your older listeners are not all crazy right-wingers, okay? Or old people aren't crazy right-wingers. But the ones that listen to you, Miss Darcy just proved, are New York liberal elite, maybe Jewish. Come on, Dave. Dog and Warder. I want you to get an elderly person to call your show and tell you that they, in like a southern accent or, you know, something like that, like,
I was complimented by a caller on this is all podcast stuff. The Eggman's all over today's podcast, which you all should be. I jokingly said dog the other day.
Fraud. It's a fraud.
Yeah. And the caller really liked it.
Of course, elderly people in New York City, like Ms. Darcy, are liberals. But in the rest of the country, elderly people are crazy fucking right-wing psychos, okay? And they're all rooting for Kyle Rittenhouse and these two guys that murdered Ahmaud Arbery. So, it's scary out there, Dave. I do like Ms. Darcy, though. I've got to go give my dog some water right now because he's probably thirsty. Shalom, brother.
All right. So that's the Eggman. That's his full testimony today. I'm going to have to really think about it for a while. That's a lot. That's a lot from the Eggman. Will I open phone lines today? So here's the deal. If we get to 100 members, I will open phone lines. However, depending on how long this goes, I may have to go into my live stream with actor Casey Simpson. So if that happens, we'll carry over the success of the 100 to tomorrow, and we'll open phone lines tomorrow one way or the other, okay? So please do support the stream. We are hard banned from Twitch. It's a total hard ban. And it's a 30-day ban. We're 7 days in, 23 days to go. We lost our 1,000 paid members on Twitch. So please, I would love it if you signed up on our website, joinpacman.com, because it's been a tough one. We were off off to the running, off to the races, I guess I would say. And then we just got hard banned. And then our appeal has not even been adjudicated yet. So the coupon code today is Uncharged Pickles. You see it above my head. You save 69% when you sign up on my website with that code.
Uncharged pickles?
Let's look at a few other super chats. David, what's in the glasses? Are you a seltzer man? This is just regular water, still, as they call it these days. Just still water, nothing too special. Let's see if I have anything else here. Here's one other Rittenhouse-related voicemail.
David, sir, watching this Kyle Rittenhouse trial with you right now, and I got to say, yeah, I agree with you. The prosecution's doing well in closing arguments. Whether it changes the guilty or not guilty, we'll see. I tend to agree with you on the statement you made that it's looking like he's going to get caught.
Okay, all right, good. So the caller agrees with me is essentially what we're talking about here. And let me see if I have anything else on the trial.
Hi, David. My name is Nico from California, Los Angeles, California. I just wanted to say thank you so much for all your coverage on the Rittenhouse trial.
Pleasure.
This judge seems to be holding the defense's hands in this trial. I'm just seeing you say that the prosecution doesn't really have any recourse if it's a non-guilty. What do you think is going to happen after seeing their last-minute statements? Also, you are so gorgeous. Are you single, and where do you stay?
Okay, so I'm going to assume the caller is male because of the name Nico, although I could be wrong. I am not single, but I exclusively date women. That is something that I do. So if indeed the caller is male, it would not be in my, you're not on the right team, I guess is what I would say, with complete and total peace and love. But I appreciate the kind words, of course. Let me see if I have any other. I do have one more from Whitney, I guess.
As Caucasian families,
Caucasian
start, dwindle in size, and
what?
Your people are getting more and more racist. Like, they're having their kids inherit a world in which they just...
All right, so that's that. We're going to be done with that. All right, so the trial is going to be... Whoa, very shaky camera there, as you can see. The trial is going to be back momentarily. I am going to step away. I've got a call in 7 minutes. Then I'm going to be back. We're going to have the defense closing arguments and then the rebuttal from the prosecution. I think it will get crazy today. Everybody stand by. The stream's not ending. They're back in 5 minutes, and then I'll be back in about 20. All right, we'll see you then.
I think we agree for the most part on the second portion of the argument. It would have been from around an hour and 13 minutes. Detective Howard and I both timed the first part, and we have it, well, Attorney Richards has it as 37 minutes. I have it as 32. So I don't think it's 2 hour, even with his timestamps, it's not 2 hours and 8 minutes.
Well, look, I actually wouldn't have strictly enforced it. I was going to make my usual statement, but I won't because someone will accuse me of being biased against my own religion. But I usually have been quite permissive about this. I set very strict rules and then am somewhat indulgent. So I probably won't call anybody about it. But so you can both talk for 8 hours.
I just want you.
Okay. Yeah, we got it.
May it please the court, ladies and gentlemen of the jury, good afternoon. Showing you a snippet of State's Exhibit 18, which Mr. Binger just spent 3 or 4 minutes showing that Mr. Rosenbaum wasn't around. And my client couldn't know that he wraps his head in orange. Chain, bag, orange. Ladies and gentlemen, we've had this video almost as long as they've had this video. But Mr. Binger will use this video to lie to your faces and tell you that Kyle Rittenhouse was taking advantage of the situation.
I object, Your Honor.
It's in the picture.
It's argument.
Ladies and gentlemen, this case is not a game. It is my client's life. We don't play fast and loose with the facts, pretending that Mr. Rosenbaum was Citizen A #1 guy. He was a bad man. He was there. He was causing trouble. He was a rioter. And my client had to deal with him that night alone. When I say that the truth matters and this is not a game, what do I mean by that? Mr. Binger is the one who put on the Kandari brothers. The reason he put them on, in spite of what he might say today, is because he wanted you, now 18, soon to be 12 people, to say, gosh, that kid just went to that place and just protected it. He wasn't asked. He was asked. Mr. Kandari's asked Nick. Nick got a group of people to go down there the people from West Bend came. Provocation, another thing. Think back on November 2nd when this case started. Did you hear one word out of Mr. Binger's mouth about provocation? You didn't, because it was never said. But when his case explodes in his face, now he comes out with provocation. That was opening. And most importantly, in opening, quoting from Mr. Binger's first paragraph of his opening statement on November 2nd, 2021. This occurred after the defendant chased down Mr. Rosenbaum and confronted him while yielding an AR-14. Ladies and gentlemen, you've seen the videos. Mr. Rosenbaum sees, and I'll show you the video in my closing argument. You'll see Mr. Rosenbaum take off when he sees my client coming along with the Zeminskis to set up the ambush of my client. Provocation? I don't think so. The things that I've just pointed out to you, why is that a problem? Because 1, he's lying. 2, he's misrepresenting. Or he wasn't prepared when he started this trial, and his closing argument has been a change to try and fit what has come out. Remember how when he was talking, there's no proof that the Rosenbaum and Zeminski knew each other? Maybe they did know each other that night, but they were together throughout the night. You see them together in pictures wreaking havoc in this city. And now we have the magic pixel camera that brings forth his provocation. I'm going to go through the charges and we'll talk about each one of them. Then I'll go through the witnesses and hopefully I'll bring it home in an honest and forthright fashion. Count 1, reckless homicide. My client shot Joseph Rosenbaum. Ladies and gentlemen, make no mistake, there was nothing reckless about my client's conduct that day in regards to Mr. Rosenbaum. Mr. Rosenbaum was coming at him. My client ran from him, retreated, which is not needed, continues to run. The plastic bag is thrown, the metallic plastic bag. Kyle doesn't know what it is at that time. It causes him to turn and look over his shoulder, pointing the gun in that direction. Mr. Rosenbaum, is he dissuaded by that? No, he is not. He continues running and advancing on my client. That whole time, the state doesn't say anything about Mr. Zeminski firing the shot, Mr. Zeminski having his gun out. Think of the circumstances as they existed at 11:50 on August 25th of 2020. He runs through that parking lot. He continues running on. He turns as he comes into that box canyon with the cars, the van, and I believe it's a Pepsi machine, and he turns because he has no place else to go. I'll show you the Zanin video later on. And what's important about the Zanin video, you see that mob of people destroying the cars at Car Source 3, which Mr. Binger doesn't want my client to go and try to protect, even though he was asked by those individuals to protect that property. Nick Smith called him, hey, they're bashing up the cars and starting fires. Go down there. He goes down there. He has as much right to go there as anybody else in the city of Kenosha and be unmolested by the likes of Joseph Rosenbaum, Kelly, and Joshua Zeminski. And Mr. Binger says, oh, we'll get the Zeminskis later. Well, ladies and gentlemen, last time I checked, this is still the United States of America, and he has the burden of proof. If he wants you guys to believe that my client pointed a gun at him, call the Zeminskis. Put them on the witness stand, ask them questions, and let me or Mr. Sharafasi cross-examine them. That's how we do things in a court of law, but not in Mr. Binger's court. He says, I'm blaming the victim. As a defense lawyer, I might get accused of that more than some other people. Ladies and gentlemen, Mr. Rosenbaum was shot because he was chasing my client and going to kill him, take his gun, and carry out the threats he made. And Mr. Binger wants to make a big hullabaloo about the shot in the back. Remember his opening statement. He shot him in the back. And that's why I'm sitting here in front of the jury like this. Did he shoot him here? Did he shoot him there? Because of the way the bullet went in and where the bullet ended up in the hip, you know full well that the individual, and I asked the doctor, is on a horizontal plane. What is that horizontal plane consistent of? Somebody leaping, lunging at my client. And we know how close Mr. Rosenbaum was to my client. The furthest he could have been when it started, the first shot, 4 feet with the stipling. We know that his hand was on the gun. Mr. Binger wants you to believe that that was just happenstance and accident. Come on, people. Physical evidence does not lie. Use your common sense and good judgment. He talks about Mr. Rosenbaum just somehow ending up down at the riots. Remember that? Mr. Rosenbaum, according to the testimony, walked from the bus center 4 miles out to Ms. Swartz's house, and then he couldn't stay there for some reason, and 4 miles all the way back. That's not just ending up. That's going someplace with a purpose, and throughout the night, you saw his purpose. And there was more than one piece of testimony about Mr. Rosenbaum, whether it was a hospital or whether or not it was a jail. Remember that? And there was testimony regarding his medication. Ms. Swartz said we couldn't get medication because the Walgreens were all boarded up. She said, the hospital said, they gave him his medication. So whatever facility gave him his medication. Mr. Binger, the man with the burden of proof, why didn't he bring in a hospital or a jail to prove that Mr. Rosenbaum was properly medicated? He'd been off his medications, according to Ms. Swart, for 7 to 10 days. We know that he was acting like somebody who wasn't on their proper medication. He was not acting normal. Next. Richard McGinnis. Reckless. And here, Mr. McGinnis, I'd like to talk about, because the self-defense does not go to Mr. McGinnis, but if Kyle was privileged in exercising self-defense against Mr. Rosenbaum, it carries over to the endangering count of Mr. McGinnis. And Mr. McGinnis, specifically, if the defendant, and I'm reading directly from an instruction, page 9, second full paragraph, which you will be given, if the defendant was acting lawfully in self-defense, his conduct did not create an unreasonable risk to another. That is Mr. McGinnis. Ladies and gentlemen, when my client shot Joseph Rosenbaum, he feared for his life. He feared because of the prior threats, the prior statements, and the violent acts that had been witnessed by my client. Mr. McGinnis, as a witness, I think he helped us more than he hurt us. He talked about, and this was on cross for Mr. Binger, how do you know what Mr. Rosenbaum was thinking? He goes, I don't, but I know he yelled, fuck you, and then lunged at Kyle Rittenhouse. Why is he yelling the FU? One of two things. One, to intimidate, or two, he got into a situation over his head, thinking, as he said before chasing him, "You won't do shit, MFer," to my client. Well, he was wrong. He states Kyle did not know that he was there, meaning Richard McGinnis. He's a citizen journalist who was running along with his hand in his phone and his hand up in the air in to get a story. My client is not responsible for endangering him when he runs into danger. Plus, the instruction says that if he was privileged as to Rosenbaum, he's privileged as to count 2, Mr. McGinnis. Count 3, jump kick man. The uncomplaining, unidentified witness in count 3. There will be some video later on when I'm going through some of that. You'll see, and I ask you to pay attention. The state has said he's not kicking him. He doesn't hit him. When you watch the video, and it'll be in slow motion, watch where his foot goes, watch what happens to Kyle's head. The force of him kicking him in the face spins his body 180 degrees around. And then it's on. Huber coming in from behind, hitting him in the neck with the skateboard. Ladies and gentlemen, what you see throughout event number 2, and this is the beginning of it, is individuals working in a mob. They don't know what happened at Car Source 3, event number 1. But somebody said, hey, he shot somebody. Doesn't know that he was being chased by a crazy person. But they're going to get their licks in on Kyle Rittenhouse, or, as they perceive him, somebody from the other side who has been putting out their fires, causing problems for them, stopping them from wreaking havoc in Kenosha like they did the night before. And ladies and gentlemen, the standard is likely to cause death or great bodily harm. Great bodily harm is defined as likely to cause serious bodily injury. A kick to the head is likely to cause a serious injury. Did my client suffer a debilitating injury as a result of that? No, but that's not the standard. Mr. Huber, he's a rioter, pushing a dumpster lit on fire, going to the barricades to pick up pepper balls, throw them back, pointing his middle finger at the police. He's assisting Rosenbaum at the gas station, hits Rittenhouse 2 times with the skateboard, and attempts to disarm him. You'll see it all in the slow motion video later on. And Kyle Rittenhouse is running away from Anthony Huber. The state wants to call my client an active shooter. And the reason they want to do that is because of the loaded connotations of that word. Everyone has heard of the theater killings, the school shootings, and things like that. Ask yourself, the definition of an active shooter is somebody with a plan to inflict multiple casualties, usually out of anger or animus towards a group. This case, what caused Kyle Rittenhouse to shoot somebody? Joseph Rosenbaum. He runs after shooting Joseph Rosenbaum for almost 2 blocks before scene number 2. Mr. Binger makes a big thing about Kyle Rittenhouse not staying around Car Source 3 after the shooting. Ladies and gentlemen, if Kyle Rittenhouse had stayed at Car Source 3, all that would have happened is it would have made the police have an easier job, because scene 1 and scene 2 would have been put in the same location. My client ran 2 blocks without shooting at anyone, pointing at anyone, doing anything to try and get away. He tells the individuals he's going to the police, and he's running in that direction when he stopped. He's hit in the head with a hand with a rock in it, knocking his hat off. Mr. Binger says, oh, he just knocked his hat off. I don't think that individual was trying to steal Mr. Rittenhouse's hat. He was trying to take his head off. Who comes in next? Anthony Huber, for the first time. Hits him. Opening statement, Mr. Binger, was he takes a swing at him. Now it's he blocked because we took the videotape and lightened it up. Huber strikes him in the head and arm the first time. Jump kick man comes in, kicks him in the face, spins his body 180 degrees, and Anthony Huber comes in for the second lick to the shoulder neck area, trying to take his head off. And when he does that, his other hand goes grabbing for the gun, his bare hand onto the gun and pulling it away from Kyle Rittenhouse. Mr. Binger wants Kyle to sit there and hope and pray to God his strap works, and Anthony Huber can't get the gun. We don't know that. We'll never know that as he's running away from him. A shot as the gun is being separated from his body, and you'll see the butt way far away when the shot is finally fired. Even Gage Grosskreutz said he was concerned about the blows that Jump Kick Man and Anthony Huber were inflicting on Kyle's head. That's probably the only thing I agree with Mr. Grosskreutz. Gage Grosskreutz. The state must prove beyond a reasonable doubt that what Kyle did under those facts and circumstances was unreasonable, that he was not entitled to self-defense. Consider all the events that had occurred that evening. Him being attacked, kicked in the head, hit in the head with a skateboard, other individuals running up on him, and now Mr. Grosskreutz runs up on him. And the first action of Mr. Grosskreutz, and I'll go through the video later, is really he's running in, the hand is coming up, and the gunshot with Huber goes off. And the natural reaction is the flinch. He covers up. And then he pulls his hands up. And as he's standing with his hands up, look, he's not gripping the gun anymore in a pistol grip. Hands apart, hands up. And as he comes in to finish the job, the hand is on the gun going for Mr. Rittenhouse. And he says it's an involuntary movement. The shot comes before it gets directly to his head, but the motion is coming, the shot, and it continues on with that momentum. Enough momentum to go through the bullet and point directly at Kyle's head. Does Kyle fire again? No, he doesn't. Actions likely to cause death or great bodily harm, and he is coming in with a loaded Glock. And we asked Mr. Gage Grosskreutz about it. He wouldn't even admit that there was one in the chamber. That's why we had to put on the officer to talk about the unfired shell casing. Lukowski talked about clearing the weapon and a live round coming out. Because Grosskreutz won't say anything that puts him in a bad light. Grosskreutz, the person who has 10 million reasons to lie. And we all know he did lie, because he never gave a new interview after giving his statement saying he dropped his gun going down the street. Ladies and gentlemen, those are the charges. Those are a synopsis of the charges. As I stated, the burden is on the state, and they must prove beyond a reasonable doubt that my client did not have the right to self-defense. Kyle, as he sits here, is presumed innocent of all charges. If there is any reasonable hypothesis to reconcile with Kyle's innocence, that is what you are to choose. remember when looking at the burden of proof, they have it. Think about some of the things, the shoddy investigation, the rush to judgment from the Kenosha District Attorney's Office, the Zeminskis not being called as witnesses. They have the burden of proof. We don't. They want it to be that Kyle was out there doing something improper. Kyle was a 17-year-old kid out there trying to help this community. He was asked to provide help in protecting property at the car sources. It started and he did it. He did provide aid and he was asking if anybody needed aid. Whether somebody chooses to accept that aid, that's on them. But Mr. Binger wants to poo-poo his sincere belief that he's helping people because he borrowed bandages from Dominic Black, and I think he might have borrowed something from Lukowski also. But in the picture, when the Kindiri poses with all the people who are going to protect his property, there's Kyle's big orange gator box. He's got his pack on, filled with things, and he's willing to do that. Ladies and gentlemen, Kyle was not an active shooter. That is a buzzword that the state wants to lash onto because it excuses the actions of that mob on the 25th of 2020. Whenever Kyle was there, he reacted to people attacking him. There's numerous times, and you'll see him on the video, he does not shoot. He runs 2 blocks from 63rd to 61st Scene 2 without firing his weapon. Individual hits him in the back of the head. He does not turn around to address that threat. Huber takes a swing at him with the skateboard like that. Kyle blocks, and the skateboard's knocked out of his hand. He doesn't turn around and shoot him. He keeps running and falls from the 2 hits. He's run that far, and yet somehow he just fell over on his own. As soon as he's on the ground, they're there attacking him. And you see the people the law of self-defense. You've seen it, you've heard it. Now I'm going to go through the witnesses. Oh. Dominic Black, first witness, charged by Mr. Binger for providing the gun to my client. 2 counts, looking at up to 6 years in prison. His case has been adjourned so that he can help the state. I don't think he helped the state that much. I think he was a pretty truthful witness, all in all. He told them about Kyle there to help people, that they had permission from the Kindiris, that he saw Kyle help the woman with the foot, help the person with the hand. Mr. Binger wants to just say, oh, that doesn't matter. If it wasn't Kyle, it would have been somebody else. The point is, he was there and he did it. There was no pointing by Kyle of any laser sight. There was no ability for Kyle or him to point laser sights at anyone because their guns didn't have the type of optics that did that. He said Kyle was there to help. The only person helping was Kyle. And he can say what he wants about whether or not he let Kyle take the gun or not take the gun. He never told him not to. He went to the location with him. They bought straps at Jelensky's together. He's trying to cover his butt a little bit. The guns were there and they took them. They took the guns, as he said, to deter people attacking them. He saw Kyle at the end, sweating, was in shock, and said that he shot someone, he had to do it. That is Dominic Black. Corey Washington saw the rioters breaking up concrete at the church parking lot, described Rosenbaum as erratic, stated the crowd was suspicious. I don't know what that means. One of the things that I thought was strange was the night before they were burning garbage trucks, but they only burnt the old ones. I think that tells you something about his point of view, that there's a certain amount of property damage that is justified and okay. Kenosha was using those garbage trucks that the rioters lit on fire. And nothing regarding property destruction was going to do anything to help Jacob Blake. We also learned that Kyle Rittenhouse smokes cigarettes and that he has an affinity for the Dinosaur Museum. Detective Howard, ladies and gentlemen, Detective Howard's testimony and Detective Antaramian's testimony is the stuff of what reasonable doubt is made of. Two detectives, both lead officers on this case. They've sat through every minute of this trial, and their opinions of the actions of Mr. Rosenbaum from testimony, videos, couldn't be more diametrically opposed. Detective Howard, on cross-examination, knew that the guy was hiding in the car and jumped out from behind the car and began chasing Kyle Rittenhouse. Oh boy, that's not good for the state's case. So there's the old chit-chat between Mr. Howard and Mr. Antaramian and the prosecutors after, and all of a sudden we've come up with the new theory. And you heard the new theory, that he raised the gun and that's what's on the video. Could I have the firearm, please? He told me he checked it.
He checked it?
He told me he checked it.
Okay. When?
Before lunch.
After lunch?
Before lunch.
Check it again.
Thank you. Think about when Kyle Rittenhouse is firing the gun, when he's seen holding the gun throughout the events of the 25th. He's shouldering the gun, and I'm not going to bring it all the way up to my shoulder, to the right shoulder, which would be a stance like this. The reason I objected in his closing argument is because that's not the way he was standing. If he's standing like this is right-handed, pointing the gun this way, up at the ready, his back would be to the drone footage. In the drone footage, you see the arm. It would be somebody having to hold the gun left-handed. This is a right-handed firearm. If this gun is brought up to his face and it is pulled back, the shell casing, hot, and the fire that ejects it is going to be going right into Kyle's face. The photograph I'll talk about later. You don't see the straps on his shirt. It didn't happen the way he said. It doesn't happen the way in the photograph. I'm going to need this again, but I'm going to set it down. Burden of proof, once again. The telephones, the searching of telephones with search warrants, the subpoenaing of records. I have no problem with that. It's good police work. But when you pick and choose and you make favorites, it's not. My client testified, and I'll say it this way, the detective testified that my client's phone was sent to the FBI. It was unsearchable because of the operating system. The FBI and the federal government had not cracked it yet. We found out about that. We had nothing to hide. here's the numbers, search the phone, as long as we're given a simultaneous copy. So we have what you have. We can have our experts look at it. They can have their experts look at it. So we know that there isn't anything added or deleted. We did that. We gave that to the state. If we had something to hide, they never would have gotten in that phone. They took the phone, they made a copy, they searched it. Lo and behold, nothing of an incriminating nature in it, nothing militia, white supremacist, any of that. Gage Groskowitz, different story. They had a valid search warrant for it. The only search warrant that these guys have never not executed when it's sitting right in front of them. Not just that, but Mr. Groskowitz could have consented to them going in the phone. If he has nothing to hide, why not? Why not let them look in the phone? And let's take common sense and judgment one step further. Police officers get search warrants, they execute the search warrant. Sometimes somebody feels as though their rights have been violated, and it gets litigated in a court of law. If it was illegal, the information in that search warrant never comes out in court. If it's legal, after a judge has said there were no rights violated, it comes in evidence. What was Mr. Groskowitz afraid of? Why wouldn't the state execute the search warrant, let Mr. Groskowitz and his attorney object, file a motion and say you can't go in my phone? Let the judge decide, not the person who's prosecuting and protecting Mr. Groskowitz. Come on, people. Mr. Groskowitz has 10 million reasons for not wanting somebody to go in his phone. The timing with the detectives and some of their actions, I think, are very important. They get down to Antioch at about 3:30 in the morning of the 26th, less than 4 hours after this happens. By 6 o'clock, 6:30, give them the benefit of the doubt, Kyle Rittenhouse is under arrest for first-degree murder. There's not been any autopsy done. There haven't been any witness statements taken. They've got 2 or 3 videos. The bullets, I should say it this way, all of the bullets have not even been picked up from Car Source at this point. But they're willing to make a decision. And were they under pressure? I'm sure they were. They're afraid that there's going to be another night of looting, destruction in Kenosha because of this happening and the way the word got out. He traveled across state lines. He was here. He brought his AR with him. The AR was here. He was a white supremacist looking for trouble. Nothing. That's why, ladies and gentlemen, when we picked you guys as jurors, we asked you if you could decide based upon the evidence that happens in the courtroom. Not what you'd heard before, not all of the lies and untruths that have been put out in the media. I heard one guy say, my client discharged the gun 60 times. Ladies and gentlemen, what's happening in court is what you decide the truth on. He was charged on the 27th. Still, they didn't have the information, the autopsy's final, anything like that. Ladies and gentlemen, this has been a rush to judgment. Richie McGinnis, I talked about earlier, citizen journalists. Mr. Binger talked about him seeing guns. But remember the cross of Mr. McGinnis. Guns are not legal in Portland, Washington, or D.C. or New York. They're not allowed on the streets. You can be arrested. There are state laws. And ladies and gentlemen, the gun in this case is no longer an issue. whether or not it was a dangerous weapon as it applies to the charges is, but my client is no longer charged with minor in possession of a firearm. But he needs his AR-15 and the assault weapon and the fear that goes with that to try and bring home an unjust guilty verdict. Ryan Balch had never met Kyle Rittenhouse before the evening hours of the 25th, has never spoken to him or known him after. And yet the state wants you to believe he made up something about a threat to kill. Why? What's in it for him? The threat. If I get either of you alone, I will kill you. That is a threat with a statement and a promise. And lo and behold, the chance presented itself to Mr. Rosenbaum, and he attempted to execute it. And I don't for a minute believe that he would have done it if it was Mr. Balch, who's much bigger than my client, muscular, well-built, and much more assertive and forceful. Rosenbaum, like any, as he referred to him, I don't even know what he called him, a ragdoll, whatever, but the little guy who gets beat up likes to go after the next littlest guy. He saw Kyle alone, and that's what he chose to. Or he could have been mistaken and thinking it was the other person at the ultimate that he went after and had to be held back. They were dressed very similarly, baseball caps, mask, and the only difference was the difference between shorts and a long pants. I can't answer that. Mr. Rosenbaum at this point, I guess, can't either. But you see Mr. Rosenbaum right around the time in question at that location, menacing with his chain. I'm going to finally get this right. I skipped. That's Mr. Balch. I talked about him going on. Ms. Amber Rasmussen, she was the DNA expert. What I say to you is DNA is an incredibly useful tool, but DNA is only as useful as what you put into it. And if DNA shows anything, it shows that it's not proof positive in this case. We know in hearing from Dr. Kelly that he most probably touched the gun. It was a contact wound is the way he described it. And we know through the videos, Huber touched the gun with his bare hand, and yet no DNA was found on that gun. So don't let your eyes deceive you. Don't let the physical evidence be discounted because of what she said. The end of that barrel was not swabbed. And we know...
Is a picture of someone appearing to touch a gun considered physical evidence? That's weird.
Would have had the soot on all of the fingers. Jason Lukowski, thought was an interesting witness. He was the Marine who put the phrase, shout, shove, show, shoot. And I asked him about that, and I don't for a minute disbelieve that that's the Marines' rule. Is there any retreat in there? And he said no. He looked at me like I was stupid. The reason he looked like that was because they don't retreat. Yet Kyle Rittenhouse did retreat. He tried getting away from Mr. Rosenbaum. He described Joseph...
Guys, just a quick interjection. I've felt that the prosecution has not done a good job, basically the whole case. So far, I've been watching this defense while on my call. This is not great in my mind. I'm not saying he's going to be guilty, but this is not very compelling.
He was there for a shorter period of time than anyone else at CarSource. He also cleared Gage Grosquist's gun after the shooting and made it safe, took the shell out of it. And I ask you to think back to the direct examination of Mr. Lukowski by the state. When they asked him, what did Kyle say to you? His first statement was, I just shot somebody, I need help. That's what he testified to. And then Mr. Binger shows him the statement and gets him to say, well, I told the FBI that. Ladies and gentlemen, I don't know what he told the FBI. The FBI doesn't let him see that statement, doesn't let him read the statement and say, you've read this to me, it's true in a correct copy. They write down what they think they heard. I ask you to think about what he said. If he didn't shoot somebody, why does he need help? That makes no sense. He said it, he testified to it. That's what happened. The state confronted him and pushes him back to his original statement so he doesn't get in trouble. He put the tourniquet on Gage Grosskreutz. He testified that he had his AR-15 with him, providing medical services, first aid, just like Kyle Rittenhouse. And I find it so ironic that he was there. Gage Grosskreutz had said to them, go home, we have our own medics, you stooges. And who ultimately helps him with his tourniquet? Sarah Hughes, her testimony, she reminded Mr. Huber and his girlfriend they needed to be home by curfew.
Nice sugary Gatorade for him. There you go.
Obviously,
try water.
Wish it had been.
Surrounded by
Carrie Ann Swart,
water, big water,
I talked about.
ocean water.
She talked about Joseph Rosenbaum
bombing,
being bipolar, being prescribed gabapentin. He had to leave her house that night after walking 4 miles, taking about an hour, and then walking another 4 miles back to downtown where the riots were going on, where he could involve himself fully. Her story contradicts Nathan DeBrune. I just got out when he said, I just got out of jail and I'm not afraid to go back. He'd been off his meds for the week prior. The videos of Joseph Rosenbaum show the state that he was in. No proof that he ever took his meds. Saul Kindiri, he was the first of the Kindiri brothers to testify. Car source. He's in the picture with all the people who protected his property. He's there, and he said he just liked the military garb. Why did he get a picture then with just one of them? How did he wrangle all these people up? Everybody in that picture said that they wanted him there. They gave him permission. Even Dominic Black concurred in that, the state's witness. But as I said earlier, they want these two guys to dirty Kyle up. He's just picking a spot to pick trouble and to be there and cause problems. He was asked to provide security. He did. They deny that they were going to pay any money, yet Nick Smith says they were. And going to pay money to Nick Smith. And ladies and gentlemen, do you get the feeling that they're a little afraid of being sued, as everybody else in this case is?
What?
I think so. And when they were up there, I don't remember them saying, oh, you can protect car source 2 or car doctor, but don't go to car 3. They had somebody arranged to protect car source 3, and the word came in that they had left. Dominic, Balch, Joanne Fielder, all of them say they had permission. Why would they lie about that? How does that protect them? They're not charged with anything. Who's the people who are lying here? Sal and Sam. Next, Police Officer Widener. He was the ET. He went and recovered some of the 2.23 rounds from car source. I believe he found 3 of them. The other 2 were found 3 days later. He photographed a mask. He didn't find the bag, and we do not concede that there was nothing in that bag. Not for a minute. They have the burden of proof. They have the burden to preserve a crime scene appropriately, get the evidence, and show it to you.
Binger's going to be able to take that apart very easily.
They didn't find the fire extinguisher. We know that the fire extinguisher was there. It's in the videos. But that doesn't fit in the state's narrative of Kyle actually going there to put out a fire, which had been started earlier in the Duramax. Officer Van Wee recovered the last 2 shell casings. Strike that.
Struggling with the technology.
I love technology. Officer Van Wee. Officer Moretti. He was the driver of the squad car that Kyle tried to surrender himself to. He said it was a war zone. It was a war zone those 3 nights. He described it as the city on fire. The police felt as though they were completely surrounded, described the constant gunfire that evening. Mr. Binger wants to slough it off as fireworks this. It really wasn't that bad that night. Ladies and gentlemen, it was hell in this area downtown. There were violent people causing trouble. And the state wants us to believe it was okay. The police pushed them back. Now they could leave. Car Source was safe. And I can't remember specifically what witness it was, but it stuck out in my mind. The witness said the police pushed him back, let him back, pushed him back, let him back. And a lot of the burning happened late at night, that witness said. Gage Grosskreutz.
Grosskreutz. It's actually Kreutz. Very weird.
10 million reasons to change his statement. His attorney is sitting in the courtroom, has been sitting in the courtroom when he testified. If he's just your average complaining witness, why get a lawyer? What do you got to hide? He didn't have a valid concealed carry permit. He wasn't charged. He lies to the police about being armed that night. He said he dropped his gun going down the street. Ladies and gentlemen, that's what's called obstructing. Most people, when you lie to the cops, especially in a murder investigation, you get in a little bit of trouble.
It's a little dubious to use one's having a lawyer as evidence that they can't be trusted. I mean, just legally speaking.
Bought, paid for, and protected. You don't want us to search your phone? Oh, we're going to invoke the never heard before Marcy's Law exception to the search warrant, even though they had a signed.
Also, did Rittenhouse have a permit for the gun he had at the Wisconsin thing?
He was also an armed medic. Wants you to believe that he didn't have one in the chamber and he would never shoot somebody. But before he said that, he said key, wallet, phone, gun. He never leaves the home without them. Ladies and gentlemen, I don't carry a concealed weapon. And I don't think I could shoot somebody. But when people carry guns, that's what they're for in the city. This isn't the wild, wild west. He had his gun. Kyle Rittenhouse had run by him. You'll see the picture. Was by him, gone. Did he go to give medical help? He didn't know that Mr. Rosenbaum was being tended to. No, he decided to run in and advance on the fray. He, the affiliated.
Yeah, he's sort of saying like the right, taking advantage of the right to get an attorney is suspicious.
And I might have that one word wrong, but he did it. And who ultimately put the tourniquet and fixed it on his arm? But Mr. Lukowski, a member of somebody he refers to as the militia and the Stooges. 2 different encounters between Gage Grosskreutz and my client. The first one, he does not show or give any indication of a weapon. My client does not point a weapon at him, does not shoot at him, does not swipe the weapon towards him. He states he's going to the police. That is uncontradicted. Why doesn't Mr. Grosskreutz let him be and go give aid and comfort to his fellow rioter? But instead, he joins the mob, chasing Kyle, arms himself, and runs in the 5th or 6th person into the melee in scene 2.
Scene 2.
And when
This is not a great closing statement, I think.
his friend said in his Facebook post, his only regret was not emptying the clip.
Richards actually seems almost disoriented.
We know what his intent was. We know what he wanted to do. Kyle shot first as he was coming in. And Mr. Binger talks about, he was going to grab the gun. Ladies and gentlemen.
Guys, this sounds like a Trump rally. You know when Trump's like, it's like, what's Trump talking about now?
Grab a gun with a hand filled with a phone. Right hand, gun. Goes back, loads up, and is advancing. That's when Kyle shoots him. He didn't shoot him when he put his hands up.
I don't even know
And
what
if
I'm
that
doing,
was it,
sir.
no intent to harm him, all he does, like everybody else, is back up, and nobody else gets shot. But Mr. Groskowitz decides he's going to shoot my client. Unfortunately, my client shot him first.
What?
If he had retreated, it's over. And when he's got his hand up like this, as I said earlier, the hands are up. It's not gripping the gun, it's loose. But when he goes in like this, the pistol grip is tight. Heather Williams.
This really is one of the strangest closing arguments I've ever seen.
No dispute regarding that. Detective Krieger, he was in the passenger seat.
This is a woman, absolutely no dispute.
Did not get his ID, didn't ask him about the gun, just told him to go home. Kristen Harris, Rundown Live, stated the video. We showed the video to start this, clearly depicting Mr. Rosenbaum standing there at Car Source 2 shortly after the dumpster, standing there with his chain, the shirt tied up over his head. But Mr. Binger says it's impossible for him to have threatened my client. That's garbage, just like his case. And Mr. Binger makes so much out of him one time saying, stay on your property. My client has as much right to go anywhere in downtown Kenosha as anyone else, just as the rioters did. And as he walks out to see if anybody wants medical help, he's not doing anything wrong. He's not doing anything to provoke anybody. Detective Antaramian, the juxtaposition of him and Howard, as I said, he is the one who talks about what he sees in the video, totally different. As you see, why did Mr. Rosenbaum go behind that car, 2 cars over from the Zeminskis? What was he doing over there? Why was he doing over there? And why does he come out as soon as Kyle...
Yeah, Binger went for a while, but there was a story. There's no story here, and he's just chugging blue Gatorade. This is bizarre. By the way, this may work. I mean, you know, the jurors, okay.
James Armstrong. The only thing I can say about James Armstrong is, okay, that's interesting. But what I'd like to say about his photographs, his knowledge of what he did, and some of the statements that the state has made regarding it is, what he did for those 20 hours is hocus pocus, and he makes an exhibit that is out of focus. And that's what the state is relying. The picture does not make sense. As I showed earlier, it has Kyle shouldering the gun in the left shoulder. If he has it in the left shoulder, his back would be to the drone. The drone is moving around, and that changes the focal point. He's right-handed. That's where it goes. You'd see the crosses across his chest. But no, they need him to have somehow pointed a gun at the Zeminskis. I don't for a minute concede he did, but we know that Mr. Zeminski has been armed all evening. How
This is crazy.
a gun at Mr. Zeminski provoke Joseph Rosenbaum, who, according to the state, earlier in the case, they didn't even know each other. But I think they had to run away from that because there's so many pictures of them together. Mr. Armstrong's photograph, testimony, it took 3 days and 20 hours worth of work to come up with that picture. Went from color to black and white, and he admitted he never compared it to the original photograph. Still shot. Didn't take into consideration the fact that the drone was moving. The word peer-reviewed, state has said. Peer-reviewed is an independent verification of the events, the exhibit. So there was no testimony to this because it didn't happen, that Mr. Armstrong's coworker did 20 hours on the same photograph and came up with the same result. It didn't happen. When you see, and I'll show it to you later, when you see in the video the mirror and the shininess of the mirror, that's what that is. And by going around, spending 20 hours and bringing things up, it doesn't account for Kyle's arm, it doesn't account for the heat signature of the gun, none of it. Dr. Kelly.
Wait, heat signature. Was there infrared video presented? Now, what is he talking about? In the drone video, the heat signature? Can anybody tell me what that's about?
My favorite witness. Because physical evidence doesn't lie. The soot, extremely close, if not touching. The location of the soot, I had him circle it on the exhibit. On redirect, after I had him do the demonstration,
The FBI video.
the state tried to get him to back up his opinion.
Okay.
Back it off.
Okay. The FBI video had okay. All right, that's fine.
Doesn't lie. It's, as they say in the business, an inconvenient truth. They can't change it. It is what it is. That's the demonstration that happened in front of you, the gun and the hand. And if the individual's coming straight at it, the barrel of the gun, it would go through the hand like this. But we know that it was coming from right here, going down, and came out with a very clean exit wound. No soot here at all. So we know that the gun can't be here. We know there's just a little bit of soot on what's commonly referred to as the ring finger right here, and the bulk of it goes this way because it was over the gun, touching the gun. And Mr. Bigger says he was swiping at the gun. Ladies and gentlemen, he didn't need to chase him, didn't need to keep chasing him, didn't need to lunge at him, didn't need to swipe at the gun, i.e. grab the gun.
Warm food around noon.
The shot to the back, as I said, 4 shots in 3/4.
This is really bad.
He's backing up, trying to stay away from him, shooting, and he shoots until the threat is immobilized. Ladies and gentlemen, other people in this community have shot somebody 7 times, and it's been found to be okay. And my client did it 4 times in 3/4 of a second to protect his life from Mr. Rosenbaum. I'm sorry, but that's what happened.
Sorry.
And this is the prosecutor who said he shot him in the back. He shot him in the back on a horizontal plane consistent with lunging. The shot goes in here and ended up in his lower hip across the back. If he's on the ground or down and shot, the bullet goes into the back and ends up in the stomach or on the other side.
Dear God.
Cleared back here, ended up in the lower hip. That's because he was on a horizontal plane when Kyle shot him. He had stippling to the stomach from the first. The pants stopped it from lower, but it was still on the upper. The furthest he was away when the first shot was fired was 4 feet and closing. 4 feet. I think it was Mr. Krause and I who had to fight about how far 4 feet is. It's not that far. It's not that far at all. Brought a tape measure so I could measure a gun barrel for you today. But that's no longer an issue. So I'll show you what 4 feet is. No doubts.
Sir, I object.
From the edge of the jury box to my foot right here, 4 feet. Lunge, grabbing the gun. Think how close that is. Think how fast that distance is closed. What was Joseph Rosenbaum doing? Was he running after my client to give him a key to the city of Kenosha? Was he running after my client to say, hey, thanks for providing security? Use your common sense and your judgment. Look at Mr. Rosenbaum's behavior throughout the night. As I showed you, these are the pictures. One last. Get you the pointer. Exhibit 105, Dr. Kelly. Soot, right here. Here's entry. The exit's right over here. Goes across, clean. Came out right there. This right here, nothing. Nothing on the back part of the hand, no soot. We know what was over the barrel. Remember Mr. Krause asking the doctor, well, what about that big puff of smoke? That wouldn't have an effect. Soot only goes so far. That was Dr. Kelly's testimony. He doesn't have a dog in the fight. He looks at the bodies, says what they are, makes a determination, and looks at the evidence. We had an expert, didn't call him because Dr. Kelly told the truth. Couldn't agree more. Ladies and gentlemen, facts and truth matter. In most trials, the case would have ended with Dr. Kelly. But we wanted to bring you our side of the story. We had nothing to hide. We were going to put on a defense.
What?
I heard Mr. Binger say red herring. The red herrings in this case are by the state, talking about super bullets, this metal jacket. I've been involved in homicide cases. One time it's a metal jacket. The next time the problem is the person had hollow points. Hollow points are designed to kill. Full metal jackets are to go through people. Ladies and gentlemen, bullets are bullets. Hate to tell you, at close range and close contact, they wreak havoc on a body.
Havoc.
No dispute. Wants to keep pointing at the militia, the militia, the militia. He knows Kyle's not a member of the militia. He has no evidence that he is. They went to the websites. They went to TikTok. They went all of that. All they can do is put up a little thing of a 17-year-old kid from his TikTok trying to be famous.
TikToks.
Kyle shot Joseph Rosenbaum to stop a threat to his person. And I'm glad he shot him, because if Joseph Rosenbaum had got that gun, I don't for a minute believe he wouldn't have used it against somebody else. He was irrational and crazy.
Crazy.
Talked about active shooter, the power of those words. My client didn't shoot at anyone until he was chased and cornered. Nick Smith. Got a phone call from Sam, asked on the second night of riding to go down there. They used the power washer and buckets to try and put out cars. He did that out of the goodness of his heart. Sam asked him to come and protect the next night and be paid, and he agreed to do it. He asked some of his friends to come with the help. Kyle, Dominic Black, talked about another father and a son, and then the people from West Bend showed up. He said that when they first saw Sam on the 25th, Sam gave him a hug and thanked him for protecting his property. He was on the roof when it was chemical bomb. He knew that Sam was grateful for their presence, but he also knew that people on the ground needed weapons. He heard Kyle when Kyle came back saying, "I had to shoot." Body armor. I don't know why the Grays Lake Cadet Program gives people body armor. Don't know. My client had it. And if he wanted to be an active shooter, as Mr. Binger wants to portray him, why would he give up his body armor? Nick Smith wanted body armor. He goes, "Here, Nick, use mine. I'm going to be doing medical." Helping other people. You see him do it throughout. He gave Nick his body armor. Why would somebody give up their body armor if they're going to go out looking for trouble, seeking confrontation? Doesn't make sense. Joanne Fielder, she described Joseph Rosenbaum wearing a red shirt with a green earring.
Oh, this one had a personality on her.
Well, I'll get to later. She stated Joseph Rosenbaum yelled he was going to kill us MFers and cut their hearts out. JR's arm goes up, and within seconds, they're tearing up from a gas bomb. She couldn't say for sure that she saw him throw it, but obviously that's the circumstantial evidence in her belief. She never saw Kyle act inappropriately with anybody, point a weapon at anybody. The size of the weapon might change, but it doesn't change what it can do. Presence speaks volume. It's a deterrent, and they've been pelted all night long with rocks.
What?
She was aware that they had consent to be where they are. Nathan DeBruyne.
Oh, this guy.
Witness.
Yeah, I'll say.
He was out there taking photographs on the nights in question, more importantly, the 25th. He filmed the destruction of this community, uptown, downtown. And the ATF and the FBI found out about his videos, his still photography, which I think was incredible. They wanted it. And what did he do? Didn't ask for money. He gave it to him. He sat down with the detective and gave a full interview, showed him the photographs, talked about Mr. Rosenbaum and all the problems he was causing that night, the things he was doing. And that's within less than a month after this. He'd never met Kyle Rittenhouse, didn't know Kyle Rittenhouse, but he had a feeling about what happened that night. And he said if there was trouble, Mr. Rosenbaum was there. I don't think any truer words have ever been repeated. Did he have a lawyer when he met with Detective Howard? No, he didn't. When did he get a lawyer? Remember? After he met with Mr. Kraus and Mr. Binger. Mr. Binger, the person who's made it his personal goal of putting my client's head on his wall. Ladies and gentlemen, that's what it did.
That's kind of crazy. It's like
he's been cutting corners.
He's the prosecutor.
Nathan DeBruyne said, after meeting with Mr. Binger, I was very uncomfortable. He tried to put words in my mouth. And he had to go and hire a lawyer to protect him. First, it was show him the videos and then ask him the questions, trying to put words in his mouth. He didn't want that to happen. He wanted to be able to tell his story of what he knew, what he did. He talked about Zeminski, the photographs of all the conduct that Zeminski had done that night, and I'll show you some of them. The photos have a timestamp on them, and he
So getting a lawyer is good now, I guess.
in September of 2020 about Joseph Rosenbaum yelling, I just got out of jail and I'm not afraid to go back. Those are his words, that he heard Mr. Rosenbaum. It was not objected to by the state, and there has been no proof that he wasn't in a jail. They want you to believe he was in a hospital. There's no medical records. He was in a hospital. There's no medical records. He was properly medicated. And I submit to you that in this case, the way he was behaving, I don't think he was properly medicated. There's pictures of him with the trailer fires, the chains, starting numerous dumpster fires. I submit that he was with the Zeminskis on many of the occasions, and he was emboldened by Mr. Zeminski because Mr. Zeminski was always brandishing his firearm. We saw Joseph Rosenbaum taking the chains. He chose to come down and riot. And
I'm struggling to remember. Is getting a lawyer good or bad? Is it a sign of innocence or guilt?
Why did he chronicle it? Because it's not very interesting if you take a picture of a protester who's just standing there. But Mr. Rosenbaum was involved in all these different things, and I'll show you those pictures. Lucas Zanin, Kenosha County resident. Every now and again he goes down to Texas in the winter. Testified, born and raised. He stated he had empathy for the small businesses of Kenosha, did not want them looted, did not want them burned. Is that somehow to be called into question? Does any of us want those fires started and to come and burn? I don't think so. He authenticated the video that was taken from his car as accurate, showing the south side of car source 3. And you watch that video and you see people destroying someone else's property. During the video, you look at the one wall, there's nothing there. You see somebody spray painting on it, and they've written the word loot on it. You see another individual going in the hood of the car, trying to do something. It's not his car. He's not some roadside mechanic. They're destroying property. Ladies and gentlemen, Mr. Binger and I will go round and round about it until the cows come home. They were rioters. They weren't demonstrators. Were the demonstrators down by the courthouse earlier in the night? Yes, there were people doing a legitimate demonstration. These people were rioting. And you see in his tape, they're hitting the cars with pipes. You hear the glass breaking. You see the people jumping on it. And the important part of it, and I'll show it to you, is you hear the first bang, which is Mr. Zeminski's shot. 2 seconds later, you hear the next shot, and then you see the exodus of all the people taking off from that. That's why Kyle couldn't run and continue to run from Mr. Rosenbaum, which he was under no legal duty to do whatsoever.
Did you see Binger's face?
Jacob
there?
Marshall referred to himself as
A little.
Gage Grosskitz's best friend. We brought Mr. Grosskitz's best friend in as a witness because he had posted something on Facebook immediately after this.
Is he chugging? Yeah.
He testified he couldn't find Gage Grosskitz because he was under an anonymous name at the hospital. Nobody knew who Gage Grosskitz was, who Jacob Marshall
Because
was.
it's not his name.
But he takes...
Who's Gage Grosskitz? Never heard of him. His name's Grosskreutz.
Talking about how... Could I have the next slide, please?
And hospitals, jail. I mean, it's crazy.
To his only regret was not killing the kid and hesitating to pull the gun before emptying the entire mag out. Coward. Here's the picture of them hugging each other at the hospital when this is posted. Ladies and gentlemen, why does somebody post something like that? Because that's what his friend told him. And he wanted to get Gage Grosskitz's word out. He didn't repost and say, I lied. He took it down. try and hide it, but unfortunately the internet has a memory. Next witness was Kyle Rittenhouse. I'm done with the Kandari brothers. We did recall them, but I've talked about that. Kyle Rittenhouse did not have to take the witness stand to tell his story. It was told through video. He wanted you as the jurors to hear his personal experience of the night of the 25th. He knew Mr. Binger would cross-examine him for hours, and he was willing to get up on that witness stand, take the oath, and tell his story the best way he could. And he did. Could Mr. Binger pick on him and find little things about it? A little bit. Did he damage his credibility? I don't think so. Getting to Mr. Yellow Pants, which he's been talked about. Mr. Binger talks about, he says with sarcasm. Ladies and gentlemen, you've seen the video. But remember that when Yellow Pants said to Kyle, he goes, "You held your gun like this." That's low ready. That's not like this. It's down. He never pointed his gun at him. Did he have a gun? Yes. Did he tell him to get off a car? Yeah. But when he said it to Kyle, Kyle said, "I did," and walked away, not wanting confrontation. And remember Richie McGinnis's testimony about that.
This is
There was
all over the place.
The individual with the slingshot. There was the individual with 2 rocks in his hand, and the other individual with the gun. And when Mr. McGinnis walked up to him, he immediately had to put his hand down because they were the one advanced on him, and he bought him off with a White Claw. My client, when this happened, was 17 years old. His actions are to be judged as a 17-year-old, not by Mr. Binger's standards, but by that of a 17-year-old.
Wait, hold on.
And Mr. McGinnis said he didn't appreciate the way people looked at him. And maybe he didn't. And I think the best evidence of that is when Mr. Rosenbaum begins chasing him, you hear on the tape, he yells, "Friendly, friendly, friendly," 3 times. He thinks that if he just says the magic words, they'll stop. They don't. Mr. Rosenbaum could have looked at it and said, "Hey, you're not trying to harm anybody. I'll leave you alone." Is that what happened? No. He said, "You ain't gonna do shit, mother effer," and began to continue to chase him. Mr. Rosenbaum
Began to continue.
made a fatal mistake. That day, chasing Kyle Rittenhouse into the corner, he ran as far as he could, and he shot 4 times in 3/4 of a second. Mr. Binger makes so much of Kyle's residence. Antioch, Illinois. I think most people here know where it is. It's not a foreign country. Antioch, Illinois, right across the border. He worked in Kenosha. His dad lived in Kenosha. His grandmother lived in Kenosha. He worked in Pleasant Prairie. His best friend, Dominic Black, lived in downtown Kenosha. They want you to believe that there's some sinister thing about that. Ladies and gentlemen, we live in a very mobile world. I'm from the foreign country of Racine, Wisconsin, 13 miles away, a little bit further. I'm on the north side. Ladies and gentlemen, when Kenosha burned, people who like Kenosha, they hurt. I remember 34 years ago walking into this courtroom, first time I ever appeared as a lawyer, back in that conference room. And when I saw what happened in Kenosha, it bothered me. Those 3 days. People can protest, but people can't indiscriminately burn property for no reason of innocent people. How does that further anyone's cause? Kyle feels for this community. He worked as a lifeguard. When he came down here, are we to believe that he's working to clean up graffiti, not getting paid because he's here to look for trouble? Is this all some master plan? That's ridiculous. He came down here trying to help, to see the damage, and that's what he did. Next. Dr. John Black, his testimony about the slides, making times, and I'll go over some of those. But specifically, as I argued earlier, the zero shot from, I should say it this way, friendly 3 times to the first shot, 10 point some seconds. There's a change in elevation in the video as he's lunging forward. The shot rings out after that. The zero shot, which is shot 1, then 2 2600ths, the next one 24, 23, for a total of .739.
2 2600ths.
He comes around the car because all the individuals had left. After hearing the shots, goes to check. And to believe that he could stay there is preposterous. All I said would have happened, scene 2 would have been moved to scene 1. You heard the one individual yell, "Get the F out of here." The Zeminskis are screaming, "He just shot him, he just shot him, get him, cranium." That's all happening. Mr. Zeminski's walking around with his gun over his head, pointing at Kyle, and I'll show you that in a little bit.
In a little bit. Isn't this guy about an hour and a half in already?
The exhibits that Dr. Black showed the jury, no color was added, no color was subtracted. The videos didn't go from color to black and white. There was no structural problems. He demonstrated his technique regarding changing brightness and contrast right in front of you. And the one video went from a dark mess of nothing, moved the 2 lines. I don't know how to do it, but he did right in front of you, hit it, and all of a sudden it's light and you can see it.
There's no way in hell this goes to the jury today, right? I mean, then there's still the rebuttal.
2 minutes and 55 seconds from the 3 times friendly to the time he surrendered or attempted to surrender at law enforcement. Officer Brittany Bray, let me go through the, back up to the first one. Total time, 2 minutes, 55 seconds, according to Dr. Black. Next, friendly, the 4 shots, 10.8 seconds. Those are the shot times. Remember the sound he put and synced up with the video? That was the audio graph, the green thing he showed.
We shouldn't underestimate that this might be a strategy tailored to what the defense perceives to be the intellect of the jury, to just kind of jump around all over the place and just kind of, I don't know, it kind of seems like self-defense. I don't know.
Have the time to think, process, and do all that. You have to remember how fast all this was happening in event number 1. He's running, the bag is thrown, he turns, addresses, keeps running, and makes a decision, a life and death decision, that he has to turn around and address the threat of Mr. Rosenbaum. At that point, Kyle is stopped. Mr. Rosenbaum, like those other people in event number 2, could have put up his hands and just backed up, made a bad decision, shouldn't have done it. No, he goes diving for him, yells the FU, and is going for his gun. Next. Event 2, I have it beginning when he's hitting the head with the rock and ending with the 4th shot, taking 14.9 seconds. Next, police officer Brittany Bray measured the gun, the pullback, the slide, 4 inches, brought the ruler out, because you never see in event number 2 Kyle pull back the 4 inches, slow motion or otherwise. There were no unfired bullets found at the scene for the AR. There was the unfired bullet by the clip and the Glock that had been cleared from Jason Lakowski. Drew Hernandez.
Judge is getting annoyed.
Mr. Binger, for some reason, didn't like Drew Hernandez. You could hear it in his questioning. Ladies and gentlemen, Drew Hernandez had a point of view. There's no doubt about it. But what was that point of view? He's a citizen journalist, and he's covering the riots.
Citizen.
And he didn't think that the mass media was covering the riots correctly. They were just calling everybody demonstrators and not covering the devastation and the destruction that was being done.
He had some bias. It's like Alex Jones testifying.
But does that mean that his video's lying? Does that mean when he says, I saw him lunge, that he's lying? He doesn't have a dog in this fight.
Actually, he does.
Tried to get all of his video to the state. The Dropbox wasn't big enough. He sees that the case is going to trial. He reaches out, gets a lawyer, and provides it simultaneously to both of us, and we end up playing it. He describes the Zeminskis, Joseph Rosenbaum starting fires in the dumpster, the yelling. He sees Kyle, the yelling of the word, the N-word. He sees Kyle walking around yelling medical, medical, right up until the last time when event number 1 starts. He was standing right at the corner, had a clear view to the first incident. He described him as charging from behind. He saw Joseph Rosenbaum throw the bag. He described hearing a shot from behind Kyle, which we all know is the Zeminski shot, the man who's never been brought before you people.
You people.
Joseph Rosenbaum lunge. Ladies and gentlemen, you've sat through almost 10 days of testimony. You've heard the openings, most of the closings, and I have yet to hear Mr. Binger explain why Joseph Rosenbaum had the right to chase my client. To me, if I didn't know better, I would think he's a whiny defense lawyer. Everybody's out to get me. Everybody's lying. I'm the one who's bringing forth the truth. Ladies and gentlemen, the videos...
A lot of attacks on the prosecutor.
The videos show the actions of Joseph Rosenbaum. Balch is lying. Fiedler's lying. Lukowski's lying. Richie is lying. Dale DeBrune, he's really lying because he's imputing my character. Nathan DeBrune, excuse me. Hernandez, he's lying because he's a right-wing journalist. All 6 of them are lying. And then, I forgot, Detective Howard, he's lying too because he could see through the videos. He could see that Rosenbaum came out from hiding behind the car after my client passed.
This is painful.
Rush to judgment, as I said earlier, you bet. Highly charged atmosphere here in Kenosha. Make no mistake, you live here, you know. They had to do something. They had to charge the white supremacist.
Supremacist.
A white supremacist.
Supremacist.
They've never reassessed their case. They've never looked at it. They've never said, oh, Dr. Kelly, let's talk about this wound on the hand. What? That means he was touching the barrel? Or his hand was over the barrel when it was fired? Well, that means he was pretty close. No, we're not going to reassess. We're going to march forward. We're going to throw it into the hands of 12 people from the city and let them do our work. Ladies and gentlemen, this is a political case. We can take politics out of it as in Democrat and Republican, but the district attorney's office is marching forward with this case because they need somebody to be responsible. They need somebody to put and say, we did it. He's the person who brought terror to Kenosha. Kyle Rittenhouse is not that individual. The rioters, the demonstrators who turned into rioters, those are the individuals who bring us forth. And I ask you to remember, and I'll show you the videos for the last time from me, the anger in the mob that was going on that night. They were not going to be dissuaded from doing things. They were pushing, firing dumpsters, destroying property.
Firing dumpsters?
That was... So you're saying Mr. Rittenhouse put out a fire? Yes, it was a small fire. Last time I checked, small fires turn into big fires. So kind of stupid. James Armstrong.
Oh, man.
Out of focus.
Please proceed, Governor.
I've talked about him. He spent 20 hours reworking a frame in a video and having my client somehow miraculously go from a right-handed shooter to a left-handed shooter. The mirror on the truck is the arm. Their whole case relies on that one photograph that he spent 20 hours. That's how they're going to prove provocation, a word you never heard in the opening statement. It was my client chased him down and shot him in the back.
This just may work. This just may work.
This is the day before car source burning, car source 1 burning the ground. What's in the foreground? The trailer should be the subject. Pictures later on. There's Kyle earlier in the day on the 25th, setting up his alibi, setting up his I'm a good person story, because he thinks he's going to go out and kill 3 people that night. Ladies and gentlemen, that is garbage. How would he know he's going to be photographed? And what does that do? It just shows he's interested in his community, trying to do good. Picture, Mr. Kandiri at Car Source 3. The state doesn't want Kyle to go to Car Source 3. According to the state, he has to stay at Car Source 2, 59th and Sheridan. Yet, Nick Smith called and asked him to go there because whoever was going to protect that property had left.
On objection, Your Honor, the record does not indicate that Nick Smith made that phone call.
It's argument, folks, you heard the evidence and use your collective recollections to determine what the truth of it is and discount anything that is not supported in the evidence.
Wow.
Testimony was he received a phone call saying they were destroying cars at Car Source 3, and he went down there. First, Kyle asked for a fire extinguisher, asked the other individual to go down there with him. He said, didn't give an answer, and Kyle took off going down there to try and help protect that property. This is that night, the tear gas, the fires. Here is Mr. Rosenbaum pushing one of many dumpster fires. Right there, that's one. Another one. Stop. Bats, guns. Mr. Rosenbaum pushing it in. Either the gas station or Drew Hernandez said there were police vehicles right down here. And they're trying to push it to him. I apologize. They're trying to push the dumpster down to the line of police or to the gas station. It's put out, and the reaction from Mr. Rosenbaum of dumpster number 2. You hear the voice? Why you do that? Get over this. There's Mr. Rosenbaum arguing. Mr. Zeminski, the smiling puppeteer, standing behind him. Yeah, they didn't know each other. Maybe they didn't, but they sure spent a lot of time together that night. Mr. Zeminski with the yellow circle, holding his firearm. Yellow pants, Kelly Zeminski with a flashlight in her hand. Last time I checked, there wasn't any lighting problems. The flashlight is a weapon to bash heads if you have to. Many people with AR-15s, not one person with an AR-15. That's the difference between this, the Ultimate gas station, fracas, and what happened down at Car Source 3.
It was a fracas.
Kyle Rittenhouse was alone. He had been taken away from the herd, and Mr. Rosenbaum and Mr. Zeminski were going to get movement. Mr. Rosenbaum and his bag. He's not dissuaded by the people. He's going right at him. He's not.
Remember that the defense said they were going to be very short. We're already at least an hour 38 minutes in, maybe more like an hour 45. And it's meandering. It's bizarre. It's very strange.
Shoot me, N-word. Shoot me, N-word. Mr. Zeminski holding his gun down to his side, remembering this is a Black Lives Matter rally, and he's there to support their cause. Yeah, right. Mr. Huber, right there, holding him back, actually physically holding him back, but right in the middle of it. Look at the anger in his face. This here, I'll start it, but I'm going to point it out first. You saw a video earlier, this individual starting the Duramax on fire. Right here, jump kick, man. You see him shoot in the lighter fluid or flammable liquid. You see Jump Kick Man being right involved. This is the calm Tuesday evening that Mr. Binger is alluding to. Mr. Rosenbaum, this time wearing a blue mask, tipping over the porta potty. It was just a little porta potty. The trailer. The trailer's important because it's the way he arms himself with the chain. Here's Rosenbaum pushing it. If he's just a regular demonstrator or misunderstood, a little bit upset, what does he need a chain for? What does he need a bag? Why didn't he leave it with Ms. Swart? Here, three things. The blue circle, his bag, backed up by the fire. Look at that bag. Does that look like there's nothing in it? Look at this. What is that? That's not a water bottle, ladies and gentlemen.
Illegal bag.
It is, but it's not a water bottle. Look at this. 2 feet of chain on each side. He's got it. Taken, I'm sure, from right here. The toe chain. Jump Kick Man. Right there, the mask, the white jeans, the black. Look at the boots. Those boots would soon be impacting my client's face.
It's crazy how the bag is a weapon. The boots are weapons. The flashlight is a weapon, despite no evidence that that flashlight was ever used as a weapon. But the AR-15 is not indicative of someone who is expecting trouble if the boots or the flashlight are, right? I mean, okay, maybe none of them are, but come on, guys.
Rundown Live.
Skateboard.
Showed this video. I started my opening statement with it. I was going to show you where Mr. Rosenbaum is. I've already done it. Don't need to waste your...
That was a tactical bag. SWAT uses the same bag.
How do I get to the end? Oh. Here's the picture that we showed at the beginning. Right there, the 125-26. Mr. Rosenbaum masked with his chain during the Rundown Live video. Mr. Rosenbaum with the chain. So I said earlier, look at how Kyle's dressed. Look at the pack on his left side, left hip. The crosses going across the front and the back of his chest. Nowhere in the magic picture is that depicted.
Elements of medical.
11:40, he's crossed over that line, asking people if they want medical, runs into Yellow Pants. He walks away from confrontation. And Yellow Pants said, "You pointed your gun at me," and he goes like this, low ready. The individuals who were there with him, slingshot, rocks in the hand, gun. Mr. McGinnis.
Wow.
Kyle, after having the brief thing with Yellow Pants, he goes away from them, goes over, looks for Mr. Balch.
Has it been mentioned why Rittenhouse was wearing purple gloves a lot of the night? I mean, I just out of curiosity.
Wants to get back to car source 2.
Those are medical gloves? Okay.
Goes back and waits. He gets the phone call. He testified about the phone call, either from Nick or Dominic. And what does he do? He gets a fire extinguisher. He hasn't had a fire extinguisher all night, but he gets a fire extinguisher. The circumstantial evidence shows the call came through. He testified the call came through. You know.
Please let me know in the chat. Do you think there will be any guilty verdicts here? Any at all? Yes or no? Let me know in the chat.
This is Drew Hernandez's video. It starts in color and goes, starts in black and white and goes to color. You have
More yeses than I would have thought.
the Zeminskis, and you'll hear Kelly Zeminski talking. And during the first part of the trial, we saw this trailer go by, and it cut off the view from this location. And I'll stop it a few times and did you hear that? Talking about a pepper ball exploding in her ass. That's Kelly Zeminski speaking.
Pepper ball.
It's blurry. Keep your eye here and here. Kyle will come to you. That's Kyle right there to the right of the garbage can by that splurge of light.
There's the trash can fire.
Mr. Rosenbaum, as soon as Kyle is coming, gets up and starts walking away along with Kelly Zeminski, this individual. John McMahon was there earlier. Up there. That's Kyle with the fire extinguisher walking. Doesn't say anything to any of them. They see him coming, they head down to do their ambush. He's not chasing them. He's not running after them. He's walking down to put out the fire. Let's start it over again.
What was the word he used? That there was a splurge of light?
You hear Kyle yell, "Friendly, friendly, friendly." That is the start of Mr. Rosenbaum chasing Kyle.
Very weird.
Now they come in. He's thrown. It goes to the small. He's thrown the bag.
Duramax just got. Oh, that Duramax got fucking beat.
Stop. destruction of the vehicles as he approaches. Gun, and he's off and running. We've seen the videos. Here is the Zanine video, parts of it. As I said, watch for the first shot. Look at all those people standing there, a wall of people destroying cars. The state wants Kyle to run into that wall of people. Listen for the first shot and watch the lackadaisical attitude, and then hear the 4 shots in quick succession and watch what happens.
Oh shit. They shooting. Oh shit. Oh my god.
Think about that, ladies and gentlemen. The first shot happens, they barely begin to move. Between the first shot and Kyle's first shot, which is the second shot you hear, Kyle has turned around. Why is he turned around? Because that wall of people is there and he has nowhere else to run. The cars, the van, all of the people destroying property, the soda machine, he turns around and Mr. Rosenbaum keeps coming. Mr. Rosenbaum keeps coming, he lunges, gunshots. As his wife yells, effing get him, he just shot somebody.
Okay. I was muted. I'll explain it later. Dear God. What an abortive stream.
Pointing the gun, once again.
I'm an idiot. Man, I'm an idiot. What I was mentioning was we had to temporarily ban Jimmy from Philly because he was cheering for the violence, and when Kyle Rittenhouse was shooting people, that's just over the line. It's just glorifying violence. And he was also attacking people in the chat. So we banned him for now, and he has left like 6 voicemails, and he's been emailing in, and it's crazy. We'll listen to it in a bit. This is Gage Pav.
Hey, what are you doing? You shot somebody?
I'm going to get the police. He's going towards the police. He's continuing on. He's past Gage Grosskreutz. He hasn't shot Gage Grosskreutz. He hasn't pointed the firearm at Gage Grosskreutz. The medic, if he thinks someone shot, why isn't he there? He doesn't know Richie McGinnis is tending to him. None of the people who chase him are at Car Source 3. There is no evidence. Zeminski doesn't chase him. Zeminski doesn't want anything to do with it. His wife doesn't want anything to do with it. But the mob has now formed and is chasing him down Sheridan Road in a northerly direction.
Who shot? Who shot?
He turns all the way around, looking towards Car Source 3. Could go there. At this point, he hasn't armed himself. Kyle is zero threat to anyone. This active shooter BS is something that Mr. Binger is trying to sell you people. Has he shot anybody since Car Source 3? No, he hasn't. He's running to try and get to the police. Mr. Binger must live in fairy tale land to think that Kyle could stop, put his gun down, and say, hey, everything's good, leave me alone, I'm going to the police. Unfortunately, that's not how the real world works. This was real world. People yelling to stop him. Next picture. You saw it in opening statements. Mr. Groskowitz.
How long is this even going to be allowed uninterrupted? I mean, we're almost at 2 hours straight right now.
Small of his back. He's arming himself right here. Look how far Kyle Rittenhouse is ahead of him. No threat. He's run 2 blocks. Almost 3 because it's at the far end of 63rd. He hasn't shot his gun since. If he's an active shooter looking to take as many people as possible, he's laying waste to everybody as he's running. Remember, he's got 30 bullets. He's shot 8 times. 4 in scene 1 and 4 coming up. He's not indiscriminately shooting, pointing, doing anything. Here's full speed. Pointing the gun at anyone? No. Running down the street, trying to get to those lights where the Bearcats are and law enforcement. He's not running off to the side to hide in the shadows. Blow to the head. First, knocking his hat off. What has Kyle Rittenhouse done? Nothing. Trying to get away from the mob. First strike from the mob. He's not an active shooter. He's gone 2 blocks, hasn't shot anybody. Coming in behind with a skateboard at the ready, Anthony Huber. That will be strike number 1. Remember in opening statements when Mr. Binger said, oh, something happened to his skateboard. He took a swing at him. Kyle blocked it with his arm in the enhanced photos. What does Mr. Huber do? He runs, grabs the skateboard, and comes in for more. He's on the ground. Most vulnerable position you can be in. And what do we have? We have Anthony Huber here, already picking up his skateboard. For this guy with the towel wrapped around his head, coming in at Kyle. Jump kick, man. This guy was hit him in the head. This individual. If we go forward just a little bit, see if it works this far. Nope. You saw this individual over here, who's now obstructed, come in at Kyle. Kyle points his firearm at him. He backs up. Kyle does not shoot. Jump kick man is leading with this foot. This foot is still on the ground. What direction is Kyle pointing right now? Watch what happens after jump kick man kicks him in the face. He's turned around. He's looking in that direction. Anthony Huber coming in with the skateboard. Watch what Anthony Huber does with the skateboard. Blow to the head. Coming in. Kyle's trying to get up. Anthony Huber's hand goes onto the gun. This is the fast one. The gun is pulled away from Kyle. Anthony Huber fires. When Anthony Huber fires, Gage Groskowitz
Quits.
flinches, covers up. Natural, uncontrollable reaction. Back. Get his ass. Now here's the slow motion. He's been hit in the head. The cap is off. Anthony Huber winds up with the full force of his body. And back here, he swings his skateboard at Kyle. Kyle senses it coming. He turns around and looks, blocks it with his arm. Doesn't turn around and shoot Anthony Huber as he's being attacked with what is a deadly weapon. A skateboard can cause death or great bodily harm, ladies and gentlemen. He doesn't do it. He continues to run a couple of steps before the blow to the head, and this is knocked into the ground. He immediately changes direction, goes running for the skateboard. Want to get through this one? Okay. Now this is slow motion. Just as he's on the ground, he's set up, trying to get up. The individual to Kyle's left is the one who runs in. Kyle points the firearm. He backs off. He is not shot at. Backs up. He's now addressing the second nearest threat. Does not shoot. That individual right there in that picture is stopping. Jump kick man launches, contact, fire, turned around. In comes Anthony Huber. Blow to the head and neck. Now, I'm going to start it. You'll see Anthony Huber pull on his gun. And you'll see the butt of the gun separate from Kyle's body going in that direction, away from him. See the gun being pulled away from him? Shot. Mr. Huber goes down. Gross quits. Flinches, freezes. Stops. Hands up. No pull. Mr. Grosskowitz is standing like this, and all of a sudden you see him kick his foot back and launch forward. He loads his back foot going forward at Kyle with a loaded Glock handgun. Kyle sees it coming, gets within a couple of feet, he fires. If he's got his hands up and wants nothing to do with Kyle, like everybody else, just back away and you don't get shot. Mr. Grosskowitz decides he's going to take him out, and his only regret, as stated in the Facebook post, he didn't fire first and empty his clip into the kid. He's hit in the arm, he's shot at once, he's backing up. That's the last shot. I went through the quickness of those shots, from the rock in the head to that fourth shot. He gets up. You still see this individual armed with a board or a 2x4 or a fence post. Doesn't shoot at him. This person he doesn't perceive as a danger. His hands are up. Doesn't shoot at him. Now as he wheels around, watch what this individual does. That was the end of it. Kyle turns around. He turns. That individual steps away from him. No more shots. Doesn't shoot randomly. Shots from behind him. Continues on his way, trying to turn himself into the police. end of it. People yelling to shoot him. He doesn't stop because it's not safe. Goes with his hands up to law enforcement.
Hey, he just shot them! Hey, dude right here just shot them! Dude right here just shot all of them down there! That dude just shot them on there! That dude right here! Yeah!
Continues on. Hands up. You hear the story about the pepper spray. Ladies and gentlemen, that's the case. There was no threatening behavior that started this. Mr. Rosenbaum was hell-bent on causing trouble that night. He did what he did, and he started this. There are tragic parts of it, but Kyle Rittenhouse's behavior was protected under the law of the state of Wisconsin, the law of self-defense. You've heard the instructions, and I'll end with this. You decide on count one. If you decide that his conduct was privileged under the use of self-defense, you don't go on to the lesser included. If it was privileged under self-defense, that affects count two. Both of the things that happened in scene one, as I read earlier, page 9 of the jury instructions. If his conduct was privileged as to Rosenbaum, it's privileged as to Mr. McGinnis. On to the next ones. At scene 2, ladies and gentlemen, there is no evidence whatsoever that he was an active shooter other than Mr. Binger calling him that. And there's no evidence that any of those other individuals who attacked him in the mob that night were attacking an active shooter. He wasn't shooting. And if they want to be the heroes and they want to beat somebody and do what they're going to do to them, they better be right. And they weren't. Kyle Rittenhouse shot Mr. Rosenbaum because he was attacking Kyle. Every person who was shot was attacking Kyle. One with a skateboard, one with his hands, one with his feet, one with a gun. Hands and feet can cause great bodily harm. I'm sure the state's going to get up and say, well, he didn't have great bodily harm, so it doesn't matter. That's not the standard. The standard is could cause great bodily harm. My client does not have to take a beating from the hands of this mob or the hands of Mr. Rosenbaum. And Mr. Rosenbaum might be little, but he was a pretty muscular guy. And some 30-some-year-old guy can take a 17-year-old kid 9 times till Tuesday. Ladies and gentlemen, it's a tough choice, but the evidence only leads to one conclusion. That is that Kyle Rittenhouse's conduct on August 25th was privileged based upon the actions of Mr. Rosenbaum and others. There are no winners in this case, but putting Kyle Rittenhouse down for something he was privileged to do will serve no legitimate purpose. I ask you to do this, do justice here under the law of the state of Wisconsin. Thank you very much.
Thank you, Mr. Richards. Let's take about 10 minutes, and please don't talk about the case. Read, watch, or listen to any account.
Wow.
By the way, how are the calzones?
Wow. I can't help but thank so many people who have grabbed memberships. Look at this, folks, signing up on my website during the closing arguments. Nora Schmucker, Adriana Daniel, Carl Beverly, Kristen Jaggi, Richard Rankin, Julianne Villerme, David Lindsay, Megan Bolanos, Stephen Rowe, Ben Ivory, Rodrigo Valenzuela, Ujwal Mizra, and Patty DeBon. 13 new members pushing us to 66. An incredible moment. An incredible moment. They're going to come back with the rebuttal. I have a second live stream I have to go on at the top of the hour. So this will continue. I will also be streaming on Instagram. It's going to be insane. It's going to be insane. I invite you to sign up at joinpacman.com. Use the coupon code UNCHARGEDPickles for a discount.
Uncharged pickles?
Now, we had something happen during today's stream. Jimmy from Philly had to be banned from our chat on YouTube because not only was he attacking people, attacking. When video was played of Kyle Rittenhouse killing individuals, he started typing, yes. That's over the line. So Jimmy from Philly has for now been banned. He started calling in while all this was going on. Let's listen.
David, Jimmy from Philly. What? Why am I banned? I'm streaming your stream on the trial on my stream. Why am I banned? I can't super chat. I can't see my chats. Why am I banned?
I just told you.
And don't tell me that you don't know what that is. What even is banning?
All right. Then he called back again.
David, Jimmy from Philly. What kind of poll is that? Like how fair? Which argument's fair? The prosecution's argument's over. The defense just started. Why wouldn't you do that poll at the end of the defense?
Then he called back again.
David, Jimmy from Philly. So the consensus of my chat, it says David Pakman gives very low-tier trash commentary. And every comment that David makes adds nothing.
All right. And then he called back again.
David, Jimmy from Philly. So apparently you know nothing about guns, David. I heard you ask if Kyle had a permit. He didn't need a permit. But that guy pointing the gun at him, he needed a permit. Your commentary is trash.
All right. Then he called back again.
David, fuck your cappuccino.
Then he called back again.
David, Jimmy from Philly. Why are you asking if Kyle had a permit?
Then he called back again.
David, Jimmy from Philly. What is this Elements of Medical you keep playing? You think that's funny? Me and my chat think it's the lamest thing they've ever heard.
And lastly, calling again.
David, Jimmy from Philly. You want to see a furious Trumpist? Take my call after the stream.
Yeah, I don't know if I don't know if we're getting to live calls today, but it's definitely something to look into. I'll probably unban Jimmy tomorrow, and we'll give him another attempt in the sandbox to see if he can play nicely, or not. Okay, everybody. So we are standing by for the rebuttal. I also am going to be live on Instagram, I think, at the top of the hour, assuming it all goes down. Let me just see here. Let me know when you're ready, and I will start. So I'm going to be streaming in two places at once. It's just the way the timing worked out. We've had 161,000 different people watch slices of today's stream. 161,000 people. And because a lot of the people watching now were not watching earlier, just a few comedic elements that I did want to go over with you guys. Here is an Obama element that was created. Okay, so that was one. Here is a new Obama song from the great Jethro Bradley. This is serious.
God bless the United States. God bless
Obama. You say Obama, I say Obama. You say your mama, I say your mamna. You say banana, I say banana. You say David Pakman, I say David Pakman.
That is being used by some, but it's Obama. I did miss it. I should have mentioned it. I agree.
You You say Obama, I say Obama. When Obama killed Osama, I think you mean Osama. When I smoke a blunt, it's always marijuana. The dude from Tibet, the Dalai Lama. Obama.
All right, so there is that. And then lastly, okay, we're still good. Here. What the heck? Oh my God, where is that coming from? Okay. And lastly, this is Lilu featuring Diamond and Silk with Deepak. It's called Bag of Mangoes. Mangoes?
My bag of mangoes.
Uh-oh. I love mangoes too.
99 cents. Okay. Now that we are up under a Biden's regime, my bag of mangoes now costs $11.99.
That seems like a pretty good deal. A bag of mangoes? Mango? That's like $3 each? That's it. I want what? $8 or $11? That sounds good.
The American people will lie. And highway robbery is what you're doing. Bring my mangoes back down. My bag of mangoes. My bag of mangoes.
Mangoes?
My bag of mangoes. Bring my mangoes back down. Raise the price of fruit. Don't raise the price of fruit. Don't raise the price of fruit. Bring my mangoes back down.
The Wisconsin crowd identified with the mangoes.
Disproportionately affected the American people. Those who want me to be healthy. Those who want me to be healthy. It's highway robbery is what you're doing. Don't raise the price of fruit. Don't raise the price of fruit. Don't raise the price of fruit. Don't raise the price of
Mangoes? There it is. So an incredible anthem presented to us there. It is really something else. So very much appreciate those new submissions from people in the audience. Extremely, extremely powerful from the standpoint of music. We are in what is supposed to be a very brief break. There's going to be a prosecution rebuttal here momentarily. And I think it's going to be wild. I think it's going to be extraordinary. Okay. Oh, big thank you to Robbie Largentin and Joseph Hurley, who just grabbed memberships on my website, numbers 66 and 67. No, 67 and 68. I apologize. I invite you to sign up. It has been amazing streaming all 11 days of the trial so far. We're going to be here for the verdict, et cetera, et cetera. We are banned on Twitch and lost 1,000 paid subscribers there. That's why it says Twitch sub 0 above my head. So instead, I'm inviting you to sign up here on my website at joinpacman.com. An absolutely perfect place to sign up. And today's coupon code and through the end of the trial is Uncharged Pickles.
Uncharged pickles?
Exactly. So come on over. You can also pledge on Patreon, and those count double. Patreon.com/David Pakman is what it is. Jimmy from Philly's continuing to call in. I'm kind of over it. I'll play one more, and then that's going to be it.
David, Jimmy from Philly. Wah! Wah! Twitch banned me! Wah! Wah!
Okay, we're done with Jimmy. Clearly having some kind of a mental health event over there. So that's it for Jimmy from Jimmy for today. Seymour Richard has just grabbed a membership on my website and is new member number 69. A very powerful membership there. Jimmy is 12 sheets to the wind, as they say. Landon Echeverrio says, F your cappuccino. The jury has Graham is our attorney commentator. Graham is a defense attorney and says, the jury has likely mostly made up its mind. Closings aren't nearly as important as us attorneys like to think. No way to know what they are thinking. Indeed. Indeed. This is a good question. Does the judge still have the mistrial option? Yeah, this was addressed this morning where the judge said he would formally give his opinion on it, which I can only imagine means he is not going to grant a mistrial. If he planned to, I can't imagine he would have that they would be doing all of this. That's my instinct. That's my instinct. But that's where we are at this point in time. Other super chats. Let's see, or other voicemails rather. Yeah, Whitney did call in again.
But continuing talking about gun culture and stuff like that, like why somebody would feel like the need to get a gun because they would see somebody else like, you know, in the media who has a gun who's just like them or really similar to them who feels the need to have a gun.
Yeah. Man, Whitney's on fire today. Whitney's on fire.
Hey, how you guys doing? Make sure to use the code Let's Go Brandon for 50% off David Pakman's soy lattes. Thank you, everyone.
Yeah. Oh, that's the guy I banned. Oh, okay. Yeah, that's really cringy. Why, like, when I see Let's Go Brandon in the comments when I, like, tweet or post to Instagram, I kind of cringe a little bit, like, ooh, someone thinks they're being clever and it's so stupid. Hearing the voice of someone doing Let's Go Brandon, it's even cringier than I imagined, and I imagined it was pretty damn cringy. It's actually pretty surprising. Let's see what else we've got here. Other voicemails.
Hi, David. This is Josh from Washington State. I just wanted to point out that I look at the Kyle Rittenhouse case from an objective perspective where think about if it was a car accident without car insurance. Just mull that one over for a bit and think that one over.
I don't understand the relevance, quite frankly. I apologize. I don't understand the relevance.
Hey, David, big fan of the show. Just curious what your thoughts were on the polar vortex and how it's making it cold this year. Wanted your thoughts on the winter solstice and what you'll be doing for the winter solstice this year. Also wanted your thoughts on cereal. I know you said you haven't eaten cereal for breakfast in about 10 years, but have you eaten cereal, and are you looking forward to the new year? I want to be the first one to wish you a happy birthday, dude. So happy birthday.
Oh my God. That's almost none of those things are relevant. So I have no thoughts about the polar vortex. I'm going to be in Los Angeles on the solstice. I have had cereal as a snack. I haven't had cereal for breakfast for a really long time, but I've had cereal as a snack with milk, typically whole milk. I am, I guess, not really looking forward to the new year, and my birthday is months and months away, so I just don't even really know how to deal with that. Okay. I want to say thank you to some really great people. Addison Gardner just signed up at joinpacman.com. Bernie Art just signed up at joinpacman.com. And Belinda Kepner just signed up at joinpacman.com. Very much appreciate that. Numbers 70, 71, and 72. Oh, and I don't want to forget, let's just make sure I get the name right here. One other person just signed up. Man, memberships are just dumping in massively here.
Big, massive dumps.
Okay, I'll get back to that because I'm not exactly sure how this person wants their name read. What am I having for dinner tonight? I'm actually having a lasagna tonight. I know that it's no calzone.
By the way, how are the calzones?
Yeah. Making a beautiful lasagna. What I have done is taken a cheese lasagna recipe, and I have unilaterally decided we're adding eggplant and we're adding spinach, and it's fantastic.
Within reason. All right, anything else before we start?
This is the prosecution's rebuttal, folks. Oh, thanks to Brandon Deck, who just signed up at joinpacman.com. Brandon is number 73. Whoa, excuse me. Also, momentarily, in 7 minutes, I have a separate scheduled stream on my Instagram. So I'm gonna black out here, and I'll be on my. It's just a crazy day, and we can't keep putting this off. So I'm gonna do this other stream with Casey Simpson on my Instagram. It's gonna be great. So you'll have two things: Judge taking a phone call here as we stand by for the start of the trial. Judge very, very strongly there, and making a number of different phone calls.
Warm food around noon, but we have Subway tomorrow. Pizza is here. Uncharged piccolos. Let's take a break. Lunch is here. The food is here. By the way, how are the calzones? All right, enjoy your lunch. All right, how was the KFC? Very good. Whatever you do, make sure you go to the bathroom somewhere other than the courtroom.
Yeah, man, it's really wild what's going on with this judge. The jury's coming back in. Judge now looking very perplexed by what he sees on his phone. Looking very confused, actually.
Thank you, Judge.
Here we go.
It simply cannot be reasonable for someone to be holding an AR-15 semi-automatic rifle.
I'll be right back.
With powerful ammunition and be chased by someone who is unarmed, who's smaller than him, who's shorter than him. And the first thing that you do to defend yourself is you plug 4 rounds into it. You shoot it from about 4 feet away, and not from 4 feet from Mr. Rittenhouse, 4 feet from the end of that gun. Your first shot immobilizes him. It shatters his hip. Then he's caused to go forward. And if you watch the videos, and we're going to watch a couple during this brief rebuttal, he crumples. He immediately crumples to the ground. No one is saying that Mr. Rosenbaum should have chased Mr. Rittenhouse. No one is saying that Mr. Rittenhouse did not have a right to defend himself. This case is about the right to use deadly force. And I want to talk about that standard because Attorney Richards, perhaps on accident, misstated it. He said that the standard is that it could cause death or great bodily harm to Mr. Rittenhouse, or that it is likely to cause death or great bodily harm to Mr. Rittenhouse. That is absolutely not what the standard is, and that is not what this trial is about. The standard is the defendant may intentionally use force which is intended or likely to cause death or great bodily harm, such as fire an AR-15, only if the defendant reasonably believed that the force used was necessary to prevent imminent death or great bodily harm to himself. Not, oh, if you repeatedly smash someone's face, it might lead to injury. Not, oh, this could have happened. Imminent death or great bodily harm. There's an old phrase that I could kill you with my bare hands. And there is literally no evidence that Mr. Rosenbaum was capable of that. Mr. Rittenhouse has size on him. We heard how he's a swimmer. We heard how he's a lifeguard. He's apparently in some kind of shape. Punch him in the face. Kick him in the testicles. Knee him in the face. Hit him with your gun. You don't just immediately get to shoot someone. And I don't care about provocation or any of that. Put that aside. It is not reasonable for any adult, for any person, for any 17-year-old male to not try and defend yourself first using other methods. Now you factor in provocation, the fact he had no right to retreat, or no ability to, or he had to retreat, and that he had to exhaust all methods. Clearly, if there is provocation, he's guilty. But even outside of provocation, why do you get to immediately just start shooting? As Mr. Binger said, he brought a gun to a fist fight. And he was too cowardly to use his own fist to fight his way out. He has to start shooting. And let's just say, theoretically, that we think, that the 12 of you think that it is reasonable to have used force, deadly force in that situation. Shoots once, takes out his hip. What does Mr. Rittenhouse have to do to avoid that? Well, maybe take one step back. And Mr. Rosenbaum is no threat. And Mr. Rittenhouse is responsible for every round of that gun. It did not have to happen as fast as Mr. Rittenhouse made it happen. He could have held back at one shot. He could have held back at two shots. The guy in the blue hoodie who came in to attempt to kick him didn't get 4 shots. Mr. Rosenbaum didn't get 4 shots. And Mr. Gross-Kreutz did not get 4 shots. The defendant has the ability to gauge what he is doing and to stop shooting. Mr. Richards talks about the threat being immobilized. What threat does someone 6 inches shorter than you that you've already shot in the hip and is already falling to the ground have? Why do you have to keep tracking them and shooting them and ending up with a kill shot in the back? Hit them, kick them, knee them, anything else. And Mr. Rosenbaum and Mr. Rittenhouse are alive. Because the defense talks about games that the prosecution has played. Let's talk about games. Let's talk about how Mr. Rittenhouse on that night did not tell Dominic Black, did not tell Joanne Fiedler, did not tell anyone about this grabbing of the gun. Didn't tell anyone about, oh, I was afraid they were use the gun against me. That is because once Mr. Rittenhouse and his team understood that an unarmed person chasing him and unarmed people chasing him later on would not be enough to meet this standard, to meet this privilege, they had to concoct a story. They had to concoct a story about how suddenly I was in great fear of this gun being used. And if that's the real reason, why didn't Jason Lukowski know that? Why didn't Dominic Black know that? Why didn't Joanne Fiedler know that? You darn well know if there was any evidence of the defendant saying that the night of, we would have heard about it. So yes, Mr. Rosenbaum is 4 feet or so from the barrel of the gun. He gets shot in the hip. He begins to crumple. Now remember, we did this demonstration when Dr. Kelly testified. This bullet entered here in the middle finger and came out here. This is how you grab something. I'm Mr. Rosenbaum trying to take this gun away. And this is how I'm going to do it, with my hand turned almost completely around, and with apparently my fingers spread, because these two don't get soot, which may mean they were on the gun or outside of the path, and the other ones do get soot. We're not talking about injuries to the palm here. We're not talking about injuries like this, or any kind of grabbing injuries. We're talking about either something accidental or completely defensive to knock that gun away as he is being shot just before he is killed on the 3rd or 4th shot. Well, we're supposed to believe that Mr. Rosenbaum is Jason Bourne or John Wick or some other movie star hero who's capable of killing with his bare hands and deserved the treatment that he got from the defendant. Mr. Richards' closing was quite personal. If not taking shots personally, Mr. Binger, it was gloating and boasting about his client's kills. And he talked a lot about the Zeminskis. He knows darn well that the Zeminskis are charged by my office and they have a Fifth Amendment right. This is a criminal defense attorney.
Stop. Stop. Let me ask you to step out for a moment, would you? What's your objection?
It's not in evidence, and Mrs. Zeminski doesn't have a Fifth Amendment right. Her case has been disposed of, and she did not appeal.
She did not plead or was charged with any arson, which the defense could get into, and she would have a Fifth Amendment right.
Wait a minute. As I recollect it, I think I handled the case. As I handled the Jason.
Joshua Zeminski.
What's that?
Joshua Zeminski.
That's pending.
Right.
Mr. Zeminski's case is pending, and it has been repeatedly adjourned to follow this case at the state's request. I handled the case of Mrs. Zeminski, and she came in on a reduced charge. It was a recommendation, I think, for a 7-day sentence.
She was being revoked and sent to prison. I know the pictures of that case, but if Attorney Richards
she wouldn't have a right of. I think I sentenced her to 7 months in prison consecutively to her sentence, and I don't think. Why would she have a testimonial privilege any longer?
if there are charges outside of what she was charged with. She wasn't charged with any arsons.
Are you going to charge her?
I don't know. Probably not.
All of the charges out of the event were wrapped up. All of the charges out of the event were wrapped up. They can't piecemeal the charges, and to argue that she has a Fifth Amendment right now is ridiculous.
I did say Mr. Zeminski had a Fifth Amendment right, and then the objection came. I did not say Mrs. Zeminski.
Disagree.
I can clarify that Mr. Zeminski has a
Well,
Fifth
let's find
Amendment
out
right.
from the report of what was said. I thought it was just Mr.
I think he said that Zeminskis are charged by my
The
office, and they have a Fifth Amendment right.
Did you say the Zeminskis? Both? All right, well then.
I'll clarify.
I'll sustain the objection.
I understand.
All right. All right. Ask the jurors to come back in, please. All right, I've sustained the objection because the statement which was made by Mr. Kraus was not accurate, at least as regards Mrs. Zeminski. Any question? Go ahead, Mr. Kraus.
Ms. Zeminski was charged and convicted by my office. Mr. Zeminski still has pending charges. Attorney Richards knows that he has a Fifth Amendment right to not testify.
He can. Let me ask you to step in the library again, please.
it's not in evidence. 2, 1, wait for the door. 1, it's not in evidence. 2, if he wants to say he has the Fifth Amendment right, they also can grant him immunity. They're the only people who can. And if they're going to say that, I should have a SIR rebuttal to explain it to those 12 people. They hold the keys to Mr. Zeminski testifying or not testifying.
We just heard 2 hours of how terrible Joshua Zeminski was, and the defense wants us to offer him immunity. That's completely
That's not what
our
he said,
decision.
Mr. Krause, please.
He still has a Fifth Amendment right. What I'm saying is accurate.
But you know, the questioning, the question you're asking, the Zeminski case has been here on a number of occasions, and it has been either it's been a mutual request to adjourn the case. Who's his lawyer?
Mr. Barth.
Okay, it's been repeatedly requested that it be adjourned, and I assumed, or was told, I'm not sure which, that it would be adjourned pending the outcome of this case. No, that's not true?
No. I don't know.
Well, it's not true. It is true that I assumed it. Whether I was told that or not, I don't know.
It's not the same as Dominic Black, Your Honor. It's a different situation. Mr. Zeminski's case will go to trial on January 31st.
Well,
that's the plan.
But why was it being adjourned?
I think there was some. We had a witness who was not available at the last trial date, so we needed more time to get them in.
Okay. And Mr. Richards also brings up a point that you have control over the availability of a witness in terms of grant of immunity, but I don't want to get into that because I think on the first point he made, which is that I don't think it's an evidence.
I asked Mr. DeBruin about it.
What did you ask Mr. DeBruin?
I asked Mr. DeBruin that when we were talking about our meeting, that he was going to be a witness against Mr. Zeminski, and that Mr. Binger talked to him mostly about Mr. Zeminski because there's a pending case against Mr. Zeminski.
Say again.
After Mr. DeBruin talked about our meeting, on cross-examination, I asked Mr. DeBruin, I believe this was a while ago, I indicated that he was going to be a witness in the Zeminski case, and that Mr. Binger asked him mostly about Zeminski, and why would Mr. Binger ask questions about Mr. Zeminski in an effort to change his statement in the Rittenhouse case? And he had no answer for that.
What's that got to do with the
Fifth Amendment right
that the district attorney is making, or the defense attorney is making?
It's that there's an open pending case against him.
There was specific testimony that there was a trial date on January 31st. That came in through Mr. DeBruin, and I actually mentioned it in my closing because it's in evidence that there's a pending case. I'm prosecuting Mr. Zeminski, and the trial's coming up in January. That is in evidence, Your Honor.
That has nothing to do with the Fifth Amendment, which is what I'm objecting to, and bringing that into this.
I don't know. You're making it sound as if, well, you're making it sound, and correctly so, that Mr. Zeminski is unavailable because of his testimonial privilege. But now Mr. Richards is asking whether he should be allowed a sur rebuttal to, so the jury would understand that that is somewhat under the control of the district attorney. But I'm not going to, at this point, I'm not going to get further into that. I'm just going to ask you to move on to something else.
Well, my next line of argument is that the defense named them in their witness list and could have called the Zeminskis.
No, he can't, because he's got a Fifth Amendment privilege for the very reason you indicate, and privileges must be claimed as much as possible outside the presence of the jury. That's the statute.
They could have called Kelly Zeminski. They written her here from prison.
Pardon me?
We had to have her available in case something came up. That doesn't mean we have to call her. We have no obligation to put anybody on the witness stand.
Nor does the state. And
Mr.
Richards commented many times about how we could have called them, which I think was dishonest given the Fifth Amendment issue. But then also I can mention that when he stood up and read his witness lists, the Zeminskis were on it, and they have the ability to call them as well.
The witness list is not in evidence.
These are opening statements, and he commented on those multiple times.
What was the last statement you made now that drew the objection?
That Mr. Zeminski has an open case and a Fifth Amendment right.
Yeah. Well, it is an accurate statement.
Then I should be able to fill in the holes because they're the only ones who can give them immunity. I can't call them.
Well, I know that, but
Why'd you subpoena him then?
you know. You can
He was sitting in the
no,
hallway
no,
for 2
no,
days.
No. You address your remarks to me, both of you. To me, not to each other, please.
It's called being prepared. I don't know what's going to happen at a trial.
Okay. Well, I think I'm just going to tell the jury that Mrs. Zeminski would have been available for to be called by either party. Okay?
Fine.
Oh, man, I got out of it alive. Okay. Ask them to come in, please. All right, folks, what the situation is that Mrs. Zeminski would have been available to either party to call as a witness, and neither of them has done so. Okay? Any question? Go ahead, Mr. Krause.
Thank you. Mr. Richards also mentioned that Attorney Binger talked about how all these people are liars and he was acting like a whiny defense attorney. I don't know why that language had to be used, but Mr. Binger never said any such thing. He never called anyone a liar, except for perhaps Mr. Rittenhouse. And Mr. Richards talks about how, well, in the state's opening, you heard nothing about provocation. Mr. Richards knows that is a specific thing, that instruction we get from the judge at the end of the trial. Had we mentioned at the beginning, he would have objected. He would have objected. Now let's talk about this threat, this supposed threat. Mr. Richards talked about that gas station and showed the video, and it showed Mr. Rosenbaum at the end. Attorney Binger had said he's not in this video as it started and you don't hear anything from him. And that is true. At the very end, he is seen standing quite a bit away from Mr. Balch and Mr. Rittenhouse. This is where that supposed threat happened. There's a distance between them. Next time the camera pans back, the protesters are pushed back. And you never hear this threat. You hear nothing. And apparently that is what the defense is accepting, is where the threat happened, although Mr. Rittenhouse actually does not accept that, because he said it happened at Blocker 2 North. So they can't agree on when the threat took place. They can't agree on where the threat took place. And it's the only few seconds of that part of the night that is not on tape anywhere. It's another concoction to give credence or to give weight that, oh, he had to defend himself against an unarmed man. There's been talk about how the defendant came around that Duramax and raised his gun. That didn't seem to be a contested issue in the case until the defendant lied about it on the stand. The defense themselves submitted an exhibit, number 41, in which it is denoted where the person that put that video together indicates Rittenhouse pointing gun at Zeminski's. I think it has a question mark. This was their exhibit. There was testimony from Detective Antaramian, and we showed this drone video. Now, but then the defendant won't admit to it on the stand, and then all of a sudden the defense has to fight it and talk about hocus pocus and make up little clever rhymes. The defendant could have told you the truth, but that hurts his case, and that gives us provocation. Now, I did have, on rebuttal, Mr. Armstrong put in 2 very blurry pictures. Mr. Binger didn't even mention these pictures in his closing because they're maybe the 5th, 6th, or 7th strongest pieces of evidence that Mr. Rittenhouse raised his gun. But the defense is seizing on them, and they inaccurately said that it took him 20 hours of work to do. He worked on that drone video for 20 hours. He made us multiple shorter videos of it. These images were the last part of that work. And that image does show Mr. Rittenhouse holding a gun. It is blurry. Does it show every detail? No. But we thought it important that there at least be some still shot besides these videos. The second one I showed, again, is very blurry, but it's of the shooting. And you see Mr. Rittenhouse blurry, you see the puff of smoke, and you see Mr. Rosenbaum blurry, still very much upright. And that is why those pictures are given. It was the tail end of all the work that Mr. Armstrong did on this video. The defense seems very scared of these pictures because it helps to prove their client lied on the stand, and it shows that he provoked the attack. Now, I would like to show you, I believe this is the full drone video, Exhibit 73. Okay, please play it. So in this one, it is difficult to see the raising of the gun because it's the full video. I would encourage you, if you find it necessary, to take a closer look at the bigger TV. Please stop it. Now, if you see in this video, Mr. Richards wants to make it seem like the only recourse the defendant has in retreating is walking into this mob of people who are breaking cars. But look at all that open space that he has. At this moment, he could have turned around and ran in that space and gone right back up Sheridan, and everyone would be alive and everyone would be fine. Instead, he decides to start slowing down and run into these cars in which he is supposedly trapped, which would be like being trapped in a Target parking lot. As you see, as we keep playing it, he goes around them no problem, and he goes right into this totally clear space that was available to him the whole time. He did not exhaust his duty to retreat. He did not exhaust all of his options. Now, I'm going to go to the video. I'm going to point something out. Mr. Binger is going to play it again, and I'll show you. This is in relation to Mr. Richards indicated that no one that attacked or that went after Mr. Rittenhouse in the second incident observed the shooting. That is not true. This video shows the person that is referred to as Jump Kick Man leaving the scene. And we have another view as well from another video, but I will point that out. See this man in a wheelchair who's struggling to get out of the way? This is Jump Kick Man is right here. He sees it. He's standing there the whole time, And he comes and he helps push the man in the wheelchair out of the seat. So he absolutely was there. He did see what happened. What's next? This is Exhibit 10. This is the Ford Fisher video. If you look after the shooting, it shows this individual pushing the wheelchair away from car source 3. There he is across the street, pushing the man in the wheelchair away out of the scene. Hello? This is a video you've seen before. It does look better on the large television, but this is where he comes into the screen. This is one of the videos that Mr. Armstrong cropped for us in his 20 hours of work. This is slowed down by 50%, and it zooms in as good as possible given the limitations of the video. I'll point it out up here, but I said it is better seen on the large TV. There he is pointing the gun. He's not close enough to the car to have that be a factor. He puts on the fire extinguisher, he raises up. It is. Now do the next zoomed in.
Mr. Gross.
Oh, we got it. Again, that really wasn't an issue at trial until the defendant lied about it. Now, Exhibit 84, this is another video that Mr. Armstrong did in his 20 hours of work. And this shows the part of the chase. That's where you see him point. Mr. Rosenbaum does his jump. See the defendant slowing down, seemingly preparing to shoot. And look where that first shot is. Go back one more, play it one more time. This is the zoomed in image that will eventually was shown. Look how far he's not reaching. He's being shot in the hip and falling. And he goes immediately to the ground, and the defendant sees fit to keep shooting at him, although he poses absolutely no threat. Again, 4 feet from the barrel of the gun, not from Mr. Rittenhouse himself. Here is another video Mr. Armstrong made in his 20 hours of work. I believe he made 6 of them all told. They're all on evidence. Here's a close-up of the final shooting. The puff of smoke is already out. He's already upright. He crumples immediately to the ground, but the defendant keeps shooting him. So did Mr. Rosenbaum turn and get shot in the back that way? No, he was even less of a threat. He was falling face first on the ground with his hips shattered. So yes, he was shot in the back, and he was killed by a shot in the back, and it was the 3rd or 4th shot. Attorney Richards indicated that Nick Smith called the defendant. Nick Smith did not testify to that. He was never asked. We don't know who called the defendant to go to that scene. And despite the fact that there's this madman out there who's such a threat and who's going to kill the defendant, he just saunters down there all by himself. No problem. He's not scared. This threat, if it even existed, was not taken seriously. He's a babbling idiot, as Mr. Lukowski said. Mr. Rittenhouse testified he didn't hear anything before he shot. He didn't hear this "fuck you." He didn't factor in the gunshot. There is no evidence that Mr. Huber did anything untowards that evening. They talked about pushing a dumpster, picking up pepper balls. That was not evidence that was ever submitted in this trial. And I don't know where it comes from. No evidence that he told Gage Grosskreutz, "I had to shoot in self-defense." And Attorney Richards talks about how, well, Mr. Detective Howard testified in a certain way and how he didn't talk about the drone footage or anything. He knows we got the drone footage, surprisingly, after Detective Howard testified. Guns do not have handed. There's not a left-handed or right-handed gun. So, yes, the demonstration that Mr. Binger did is how it happened. The defendant was facing that way. He picked it up, and the videos show it. Detective Antaramian reviewed it and saw it and testified to it, and it wasn't an issue until the defendant lied. Videos don't lie, but we know Kyle Rittenhouse does. He lied all that night. A lot has been made about how Gage Grosskreutz had an attorney. How hypocritical from a lawyer to hear someone criticize someone else hiring counsel. Mr. Rittenhouse isn't here alone. He has lawyers. And I apologize that the district attorney's office followed our interpretation of Marcy's Law, which is a fairly recent, especially at that time, constitutional amendment.
Mr. Richards, don't wait here yet.
Gage Grosskreutz is not on trial. He followed the advice of counsel not to turn over his phone, just as anyone who hires counsel can do. They can follow the advice of their counsel. We got his whole video from that night. The defense has seen it. We have it. What else do we need? Text messages from 3 weeks before? They just want to try to dig up dirt because they think it's there, because the defense wants you to believe that these people got what was coming to them, that they were bad people doing bad things, and we should be proud and boastful of Mr. Rittenhouse for killing them. Gage Grosskreutz testified what he heard, that he heard, "I didn't shoot anyone," and Gage Grosskreutz acted on that. He then followed, he left Mr. Rittenhouse thinking that he was not involved in the shooting and started going to the shooting of Mr. Rosenbaum before being told by others that saw it that he was the shooter, and then he returned. So Gage Grosskreutz relied on this statement of Mr. Rittenhouse. Let's talk about a rush to judgment. Mr. Rittenhouse turned himself in. Are you supposed to wait days, weeks, months to charge murderers who we know murdered people? It's a red herring, as Mr. Binger said. It's throwing up red herrings, false hypocritical arguments, and attacks on those that Mr. Rittenhouse killed to try and distract you from the fact that he was not in imminent fear of death or great bodily harm, and he was not privileged to act how he did. We heard from Ms. Carrie Ann Swart. Now that Nathan DeBruin talked about jail, now we can try to smear Mr. Rosenbaum more, although there really is no dispute, or was no dispute, that he came from a hospital. He's carrying a hospital bag. Ms. Swart testified that she talked to the hospital about how he would be released, that he went to this hospital. She knew he was coming home from the hospital. She knew it was in the bag, and he showed that picture of it backlit against the fire, trying to make it seem sinister. She talked about how there are medical papers in there. And we did that image again. Mr. Armstrong did this image for us, where you can get a little peek in the bag. And I would argue you can see medical papers. Though that big image they see, it looks like rolled up medical records that you get when you're discharged from a hospital. And Ms. Swart testified that he was given medications that day. Perhaps they didn't work. Perhaps there was a bad reaction. I don't know. I'm not a doctor. But he was given them that day. He could not get the ones for future days because things were closed. Balch did not testify that he thought there was anything sinister in the bag. He said he said something inaccurate at the time, but he said that he saw shampoo bottles and a water bottle. Mr. DeBruin, he did take some nice photographs, and he clearly wanted the world to know that he took some nice photographs. He's really more relevant to Mr. Zeminski, and he apparently, this is the photo of the bag, you can examine that further. Mr. DeBruin must have some problem with police and DA's offices. He goes to the detectives. He doesn't give a full story. He says, he testified to this. This is not me saying anything. He forgot things because he was so nervous because the door to the police station still had an unrepaired window. That caused him such nervousness that he could not give a full statement. He meets with us in a very polite, short meeting. He has very little relevance to this case that we knew about. And yes, we showed him some videos. Is this Josh Zeminski? Oh, no, it's not. Okay, would you see him in these other pictures? Yes. You don't know it's Josh Zeminski? Okay. Somehow that's us getting him to change his statement. What's that? We show him pictures, videos, say, is that Josh Zeminski? I don't know. We show him other pictures. Do you recognize that as the same person? Yes. That's not getting him to change his statement. We had him read his statement. Do you have anything to add to it? No. The next day, he goes over to Mr. Richards' office. All of a sudden, he knows all this extra information that wasn't in his statement. Oh, but he was so nervous meeting with us because we showed him a video or photograph that he took of Joshua Zeminski. And then what does he do? He goes and hires a lawyer very closely connected with a gossip blogger who attacks my office on a regular basis and who is very pro-Rittenhouse. Another just funny coincidence in this case, just like how Mr. Hernandez, who doesn't live in this state, could hire any of the thousands of attorneys in Wisconsin or tens of thousands of attorneys in the state. But no, he hires an attorney who Kyle Rittenhouse's defense team has already paid money to that firm. What a coincidence. So Mr. DeBruin doesn't tell us any information, then tries to attack us, and then tells the defense a lot more information. Mr. Rittenhouse denied pointing a gun at the yellow pants man, said he was being sarcastic. Well, Mr. Richards basically just admitted he did point the gun. So which is it? We know that Mr. Rittenhouse was going around that night trying to be a paramedic, a policeman, and a fireman without receiving any real training in any of them. Tough job to do all three at once. And he went around with his gun trying to scare people, to intimidate them, to not do minor property damage. He's a chaos tourist. He was there to see what was going on, act important, be a big deal. And then the moment a little bit of that chaos comes back at him, he cowardly shoots a man instead of fighting back. You put yourself in this situation, you know it's going to be out of hand, it gets a little out of hand, someone is chasing me, and you have to shoot him. That is not privileged. That is not reasonable. And that is not what any reasonable person in the defendant's shoes would have done. We kept hearing about this rock in his hand. There's no evidence of there being a rock in that hand. Now, there's talk about how the defendant maybe have re-racked his gun. We don't see that in the video. We don't know what he did. But we do know that as Gage Grosskreutz is sitting there with his hands up, the defendant turns over his gun and is looking at it and is doing something with it. The defendant admitted to this, that he looked at the gun. Fully reasonable that Mr. Grosskreutz could have assumed that he was re-racking and preparing to fire. And it does not mean that a unspent shell casing has to be on the ground. Officer Bray testified that she shot AR-15s. She knows AR-15s. If it jams and there's an unspent shell casing, the re-racking will take out the unspent shell casing. It does not have to be a live round. I don't know what he was doing with his gun, but it's certainly reasonable for Mr. Grosskreutz to interpret it that way. And then what does he do? He doesn't step back and take a firing position and shoot. He didn't shoot him 5 to 6 seconds earlier when Mr. Rittenhouse was being an active shooter after having killed his second person and shot at his third. He would have every right to have stopped Mr. Rittenhouse's activities at that point. But he didn't. He came up closer, he surrendered, and he said, he believed his surrender was not being accepted. Who shoots someone like this? Is he trying to shoot his own hand off? He never does anything about an actual position to shoot that gun. And as Mr. Richards admitted in his closing, when it's pointed at his head, his arm is already blown off. We're supposed to be so scared of Mr. Grosskreutz with his Glock when the defendant is holding a loaded AR-15. Then there's this preposterous argument that, Kelly Zeminski is holding a flashlight. It must be to bash heads. Certainly no one carries flashlights at night to walk home in the dark or walk to your car in the dark. I take it when I take my dog for a walk. I'm looking to bash in heads? No. We hear about how, this vicious kick that, if you watch it live, did not seem to make much contact, spun him 180 degrees. That is Kyle tracking him with the gun and shooting at him. He's moving as he's moving. That is not the force of the kick. And the video makes that clear. But again, we're grasping at straws and we're throwing out red herrings. And now, a skateboard is a deadly weapon. Someone should tell all the parents and grandparents and Santa Claus giving skateboards this Christmas about how they're giving their children a deadly weapon. I guess they should get them an AR-15 instead. It's just preposterous. And yes, Mr. Huber was acting heroic in holding down that and taking that skateboard and trying to hold him down and trying to take that gun. And what happened? The gun stayed attached to Mr. Rittenhouse. Because when the defense concocted this, they were trying to take my gun story, they left out that it is literally strapped to him. He shot an unarmed man 4 times because he was so scared that Mr. Rosenbaum was going to take the gun away from him when it was attached to him. It is an absolute red herring. It is an absolute ridiculous argument. Imminent threat. Not, in 5 minutes after we get beat up, then I might be a threat. Imminent threat. You've heard all the videos. I'm not going to go into it at any more great length, but when you listen to the crowd as Mr. Rittenhouse is running, they start yelling after as he's running when they're screaming, "Get him." Also, as people are approaching him at the end, they're asking, "Why did you shoot him? Why did you shoot him?" These are people that were provoked because they witnessed an attack or heard shots or heard he was attacking, and they took action. As Mr. Bringer said, I probably wouldn't do it either. But that they did it is brave, and they did not deserve to be killed. Kyle Rittenhouse has such strong ties to Kenosha, but he needs Google Maps to find a business he says he's driven by every day. He supposedly knows Kenosha so well and is such familiar with Kenosha that he doesn't realize you can walk one block either way to get back to the car source. He didn't want to go back to the car source. He wanted to go see what was going on. He wanted to stay in the action. He wanted to continue to do things that would make him feel big and make him feel important. These minor injuries we've heard the defendant have, again, Mr. Richards misstated the standard. It is not could have caused great bodily harm or death. It is not likely to have caused great bodily harm or death. It is imminent threat of death or great bodily harm. Where is that when you get a couple scrapes? Everybody takes a beating sometimes, right? Sometimes you get in a scuffle and maybe you do get hurt a little bit. That doesn't mean you get to start plugging people with your full metal jacket AR-15 rounds, and no, bullets are not bullets. And we heard testimony about that. Mr. Richards mentioned this in opening, but apparently he's noticed that the evidence doesn't bear it out. He talks about this, how Mr. Rosenbaum put this shirt over his head to hide his identity because he's going to go ambush Kyle Rittenhouse. Well, then obviously watch the videos. He's had that shirt on his head for some time. Whether it's COVID, this is all pre-vaccine as we know. Whether it's tear gas, whether it's fire, whatever it is, he's using it to protect his face, not as some evil plan to get Kyle Rittenhouse. They're setting this fire and they begin walking down Sheridan. There's no evidence that they knew he was coming. There's no evidence that they had any plan to get him. I'd submit to you that the Zeminskis and Mr. Rosenbaum were doing what they were doing all night. They were going to go bash that Duramax or start or stoke a fire. Kyle sees this and then he runs onto the scene. That's clear in the FBI video. He runs onto the scene. He puts down the fire extinguisher. He raises up his gun. Mr. Rosenbaum yells, "Gun, gun, gun." Why else would he yell that? It's very possible that while he was yelling friendly, 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 he's doing so while holding a loaded AR-15 at the Zeminskis. Mr. Rosenbaum was going to chase him out of there to end the danger. And Mr. Richards boasts that, something along the lines, "You won't do shit, motherfucker." Well, Mr. Rosenbaum was wrong. Oh, that's an attaboy right there. Way to kill someone unarmed because you won't engage them. He raises the gun, he provokes the attack. He has to retreat. He has to exhaust all remedies before he regains the right to even use self-defense, not even to use deadly force. That's a whole other separate question. He does regain the use right to self-defense if he exhausts all options. He does not. He could have ran a different way. He could have fought. He had all sorts of different ways to exhaust his options. He did not do it. As I said in the beginning of my closing, I don't think you even need provocation. An unarmed man chasing you and you shoot him 4 times as he's falling, and you kill him as he's falling in front of you because you don't want to physically defend yourself, that's first-degree reckless homicide right there. And Mr. Richards kind of plays games with the name reckless. Reckless means not intentional in this circumstance. And you can read the jury instructions, you can come to your own conclusions. And fire an AR-15 in any circumstance like this shows utter disregard for human life. There's no other explanation for it. If you're shooting an AR-15 at close range of people, you have no disregard for human life. That's not really in any dispute. I want to leave you with this. The meaning of reasonable doubt. I'm going to read portions of this instruction. Obviously, you'll have the whole instruction. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given. A reasonable doubt is not a doubt which is based on mere guesswork or speculation. That's what the defense is asking you to do, to guess what Mr. Rosenbaum was doing, to speculate what Mr. Rosenbaum was doing, to speculate and guess what Mr. Huber and this unidentified man were doing. We don't know because he killed two of them. All we can look at is the evidence and see him standing pretty much straight up or exactly straight up when he was shot in the hip and immobilized. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. The defense's whole case has been trying to stoke sympathy for Mr. Rittenhouse and showing how everyone else was just a terrible person. Every life counts. Every life matters. If people did bad things that night, they could have been prosecuted. It's not up for Mr. Rittenhouse to be the judge, the jury, and eventually the executioner. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision.
Folks, I'm back. The Casey Simpson live stream was great. What did I miss?
We all know that. We all knew that from the day we walked in on November 1st. But this verdict should be about what the facts are and what Mr. Rittenhouse did. That's what the 12 of you who go to deliberate will go and decide. You are the fact finders. You decide what is beyond a reasonable doubt. You decide what he is guilty or not guilty of from this menu of options that you now have. An imminent threat. The only imminent threat that night was Mr. Rittenhouse. He was not acting in legal, justified self-defense. He's guilty. Thank you.
Thank you, Mr. Krause. Members of the jury, the time has now come when the great burden of reaching a just, fair, and conscientious decision in this case will be placed wholly with you jurors selected for this most important duty. You will not be swayed by sympathy, passion, prejudice, or political beliefs. You will disregard any impression which you may have regarding what you believe to be my opinions on the guilt or innocence of the defendant. You will disregard the claims or opinions of any other person or news media or social networking site. You will pay no heed to the opinions of anyone, even the President of the United States or the President before him.
Wow.
The founders of our country gave you, and you alone, the power and the duty to decide this case based solely on the evidence presented in this court. You will fearlessly keep faith with those who have entrusted to you the fair rendition of justice and the protection of our freedom. You will be very careful and deliberate in weighing the evidence. I charge you to keep your duties steadfastly in mind and as upright citizens to return just and true verdicts. You will decide only whether the defendant is guilty or not guilty of the offenses which are charged. Any consequences of your verdict are matters for me alone to decide and must not affect your deliberations. It will be for you to determine whether the defendant is guilty or not guilty as to each of the offenses charged or submitted. You must make a finding as to each count of the information. Each count charges a separate crime, and you must consider each one separately. Your verdict for the crime charged in one count must not affect your verdict on any other. This is a criminal and not a civil case, and therefore, before you can reach a verdict which may lawfully be received, it must be reached unanimously. In a criminal case, all 12 jurors must agree in order to arrive at a verdict. When you retire to the jury room, select one of your members to preside over your deliberations. That presiding juror's vote is not entitled to any greater weight than that of any other juror. We're going to stop at this point, and I'm going to ask that you return tomorrow. I'm going to let you take a vote. When you want to start tomorrow? You could choose 8. You can choose 8:30. You can choose 9. How many would be in favor of starting at 8:30? How many want to start at 9? I missed 8, didn't I? How many still want to start at 8? How many would like to start at 9? All right, that's the clear consensus. Well, it's not a consensus, but clear plurality, probably majority, I think. And
By the way, how are the calzones?
As we have been. The case is ready for decision by a jury of 12. We don't have that. And it's just as important as ever. I'd say more so, except that it was always important, that you not discuss the case with anyone. And you won't have to resist that much longer now because you'll be able to decide the case. Please don't read, watch, or listen to any account of the trial or anything to do with the trial. And tomorrow morning we'll assemble, and as I indicated earlier, the tumbler over there will be used. All of your numbers will be placed in there.
That'll be really interesting.
And 6 of the, well, assuming there are still 18 of you, 6 of them will be drawn out. And those persons will be held in reserve and will not join the 12 in deliberation. We're going to retain you here in the building.
Oh boy.
Those of you who are
That'll be fun.
not, selected will stay here in the building, and
Brutal.
in the event that your services are needed as we continue the case. And then the 12 of you who are the jury selected will commence your deliberations at that point. So,
is there any chance these people weren't looking up news coverage of the trial every single day?
any questions, anybody? Enjoy the evening. We'll see you tomorrow.
So the jury will exit. This is the end of the Kyle Rittenhouse trial. Tomorrow, they will use a tumbler to extricate 6 of the 18 jurors to leave a 12-person panel to actually deliberate. The other 6 are alternates. If there's a problem with one of the 12, or it's conceivable that attorneys will say, we don't want this person. I believe there is another opportunity to strike and strike and strike tomorrow.
Strike and strike and strike and strike and strike.
Yeah. So I'll probably cover that. And then the deliberations will begin. And then we will be on verdict watch. We don't know how long it will be. Could be minutes, could be hours, could be, we don't know. Now, judging from how much coughing there's been throughout the trial in the courtroom, it wouldn't be a shock if someone had COVID, and whether that will wreak havoc on the verdict, we just don't know. I want to say thanks to... Uh-oh.
All right, see you tomorrow. Be here for the, obviously, you're going to want to be here, and you better be. 9 o'clock tomorrow morning. I sent them to you electronically. Yeah, about 2:45, I think. If you didn't get them, I had some trouble with your email yesterday, but I think I got it resolved. I hope I did. If not, let me know. Okay, great.
All right. Thanks to Michael Duckworth for subscribing on my website. You are number 74. And lastly today, Coco Sutter made a pledge on Patreon. Those count double. And that puts us at 76. Not a shabby day for sure. That's going to conclude our coverage for today. Obama. And we will be back here tomorrow with the final jury striking.